of up to 20% of their annual returns. Nonetheless, the court below deferred to the APA's question. There is no justification for giving the tie to the government or conjuring agency authority from silence. Both the APA and constitutional avoidance principles call for de novo review, asking only what's the best reading of the statute. Asking instead, is the statute ambiguous, is fundamentally misguided. The whole point of statutory construction is to bring clarity, not to identify ambiguity. The government defends this practice not as the best reading of the APA, but by invoking stare decisis. That is doubly problematic. First, at issue here is only Chevron's methodology, which is entitled to reduced stare decisis effect. We have no beef with Chevron's Clean Air Act holding, and we could not take issue with its APA holding because it failed to mention that statute. But second, all the traditional stare decisis factors point in favor of overruling Chevron's methodology. The doctrine is unworkable as its critical threshold question of ambiguity is hopelessly ambiguous. It is also a reliance-destroying doctrine because it facilitates agency flip-flopping. So the reality here is the Chevron two-step has to go and should be replaced with only one question. What is the best reading of the statute? I welcome the court's questions.
Mr. Clement, you heard the government's, the general's arguments with respect use of mandamus as a basis for deference. Could you comment on that? Because my understanding of mandamus is that the duty has to be clear before it actually lies. But I'd like your comment on that.
Absolutely, Justice Thomas. So I think mandamus is a critical recognition of the fact that, of course, Congress can limit the remedies available in particular circumstances, and that's the right way to understand the mandamus standard. But that's quite different from telling the courts that they're to engage in statutory construction, as Congress clearly did in Section 706 of the APA, but then say there's a point at which you can't actually give us your best answer because you're deferring. And I think it's important from a separation of powers purpose to understand that it's not just remedies are different, there's an accountability difference. Because I suppose Congress tomorrow could decide that we're going to go back to a world where the only review of executive branch action is mandamus, but then Congress would be fully responsible for that highly unpopular decision. But so that's the difference, I think, the fundamental difference from a separation of powers standpoint between a limitation on remedies, where Congress does it specifically, and essentially telling the courts in the APA specifically, you have the interpretive authority over statutes no less than constitutional issues, but then overlaying a doctrine that says what we're doing is interpretation. And that's the critical thing about the interchange between footnote 9 and footnote 11. Footnote 9 tells you as clearly as you can what you're doing in a Chevron case is statutory interpretation. But then in footnote 11, it says at a certain point, you stop doing statutory interpretation, even though you think there's a better answer, and you defer to a different branch of government. And it's not the branch of government the framers gave the interpretive authority to. It's the branch of government that the framers gave the implementing authority. So I think from that standpoint, Chevron is a fundamental, egregiously wrong decision that just gets it wrong on basic separation of powers.
There's such a tension in this. Interpretive authority, everybody seems to concede, means discretion. It means there's multiple meanings that you can take from something, and someone has to choose among those meanings. It seems like most people agree if the statute uses reasonable, that Congress is delegating the definition of reasonable to the agency. And the agency is deciding what is reasonable within some outer limit, either set within the statute or within the law. But the point is that it's great rhetoric, Mr. Clement, but we do delegate. We have recognized delegations to agencies from the beginning of the founding of interpretation. And so I'm at a loss to understand where the argument comes from.
Well, let me try to clarify. I think there is a difference between recognizing discretion and recognizing delegation. There are certain statutory terms, as you yourself point out, that properly construed by the courts definitively would give the agency a realm of discretion in which to operate. But there are other terms in which it is really a binary question. And the problem, the fundamental failing of Chevron, is it doesn't do a good job of distinguishing between the two, and the best example is Brand X. Broadband communications are either an information service or they are a telecommunication service. It might be hard to figure out which one, but they can't be one on a Tuesday and the next on a Thursday.
Oh, wait a minute.
It's a binary question.
It may be binary to you, but I do know that with the development of technology and with the development of how that is implemented in terms of transmission and the internet, that over time that's going to change.
But Justice Sotomayor...
And the same issue, even in the case that we're in right now, there were two areas that Congress looked at and knew that monitors were critical, okay? Foreign sea travel for obvious reasons, because there's very little that outside, once those ships leave, that the U.S. government can do to them. And the other was I think it was the North Pacific area. But the point is that that doesn't mean that similar problems didn't arise later, and that the broad words giving the Secretary the power to monitor and implement measures to ensure that its conservation goals were being followed wasn't given to the agency. Those are the facts that what we should be looking at, in my judgment, is this measure commensurate with what drove the similar measure, not identical, in the other two examples? And the agency should have first crack at that.
So I disagree.
If they're not similar, the court will look at it and say, your decision was arbitrary and capricious. If they are similar, we might say, okay, this is all right. I don't know the answer to that because we really haven't dug into that, but it's just the point I'm making, which is that things change on the ground. And a definition you give today may not hold up to new facts.
So facts do change on the ground. That is part of the problem with Chevron and Brand X. If there's a difficulty in classifying broadband today, the difficulty is that the statute was last passed in 1996. So figuring out whether 2023 broadband is a 1996 information service or a 1996 telecommunication service is a granddaddy of a problem. But it does have a binary answer. It's one or the other. Now, bringing it home to this statute, what I would say is if you do the Chevron ambiguity test, you find a word like appropriate in the statute, or maybe for some people carry, though I think that one's pretty clear, and you say that word is ambiguous, so I'm going to go to step two. That's what the court below did. But if you look at the statute as a whole, and if you looked at it the way you would in any other context, I think what you would see is this is a classic case for exclusius inclusius, get the exact Latin phrase. But the point is, you have a situation where in the most commercially well-heeled fishery in the country, Congress did two things. It said you may, not must, have monitors paid for by the industry, but you must, if you do that, cap the fees at 2 to 3% of the value of the catch. Now, a Congress that did that with the most well-heeled fishery in the nation, I do not think possibly conveyed the authority to the agency to say, with a much different fishery in the Atlantic, where it's small business people, we're going to let you do effectively the same thing, but we are going to let you do it to the tune of 20% of their annual returns. I think if you strip away Chevron, this is a fairly easy case where you just say, wow, Congress had this question in mind in one place, or actually three places to be specific, and with every domestic fishery, they only gave it in two instances, and in both instances they said it can be no more than 2 or 3% of the value of the catch.
You're just arguing that the statute's not ambiguous on that question.
I am arguing that the best reading of the statute is that my client wins. Now, if I have to,
well, but it seems to me that you're not contemplating the possibility of another reason, another result. And that may be right. What you're saying is that this is not a case where there can be a number of different interpretations. But I don't think that's coming to grips with the Chevron question.
Well, I hope it is, Your Honor, because what I would say is exactly what I heard Justice Kavanaugh saying, which is I don't think there is a different rule of statutory construction in cases where agency is a party, in cases when agency is not a party. In both cases, you just can't get to a certain point and say, gosh, this is hard. I think the law has run out. In both cases, you are supposed to take it all the way to coming up with your best answer. Now, if you
Well, you were just saying, I mean, that the principle of exclusio unius answers the question. And if it answers the question, I guess I don't understand how you even get to the Chevron issue. Because Chevron step 1, you would give the same answer.
Maybe you would, Your Honor, but nobody knows where step 2 ends and step 2 begins. And, you know, I suppose now taking the hints from Kaiser, which is about our, not Chevron, you would say, well, of course you apply all the canons of statutory construction before you get to step 2. But the point is, in every other case, you apply all those canons, and if you're not sure about the answer, you dust off the back of Scalia and Garner, and you see if there aren't some other canons.
Because you have no other option. I mean, what Chevron is it's a recognition that in certain cases, you apply all those tools, and the conclusion you come up with is Congress hasn't spoken to this issue. And if you had no other option, you're a court, there's a case before you, you try as hard as you can, even though you know you're basically on your own. But when Chevron comes in, when there is an agency, what Chevron says is now there are two possible decision makers. There's the agency and there's the court. And what we think is that Congress would have preferred the agency to resolve this question when congressional direction cannot be found because of the agency's expertise, because of the agency's experience, because the agency understands how this question fits within the statutory scheme. So it's not a question of the court couldn't do it. It's a question of once congressional direction can't be found, who does Congress want to do it?
So, Justice Kagan, I don't agree with you that the law runs out in those circumstances, even though there's an agency there. But I will give you this. If I did believe it, I would say, at that point, let's give the tie to the citizen. Let's not give the tie to the agency. And I think it's important.
See, I don't think it's like what we would do. You would give the tie to the citizen, and I would give the tie to the agency. Chevron is about what Congress wants. And you can call it fictional all you want, but we have lots of presumptions that operate with respect to statutory interpretation. And this is just one of them. It's just saying Congress understands as well as anybody different institutionals, comparative attributes, and comparative virtues. And it does not want courts making, it's law, but it's policy-laden judgments once Congress's direction can't be found.
So, Justice Kagan, if we're going to talk about what Congress wants, we probably should at least avert to the fact that we do have an amicus brief in this case from the House in its institutional capacity. And it doesn't want Chevron. It's on our side of the case.
If it doesn't want Chevron, it has total control over Chevron. It can reverse Chevron tomorrow with respect to any particular statute and with respect to statutes generally. And it hasn't. For 40 years, it has acceded to Chevron, except in super rare cases. It has basically said, this is the background rule. It gives us a stable default rule from which to write statutes, and we've accepted that.
So let me say three things about that. First of all, I'm not sure everybody in Congress wants to overrule Chevron because
everybody in Congress doesn't want to do everything.
But no, my point is it's really convenient for some members of Congress not to have to tackle the hard questions and to rely on their friends in the executive branch to get them everything they want. I also think Justice Kavanaugh is right that even if Congress did it, the president would veto it. And I think the third problem is, and fundamentally even more problematic, is if you get back to that fundamental premise of Chevron, that when there's silence or ambiguity, we know the agency wanted to delegate to the agency. That is just fictional, and it's fictional in a particular way, which is it assumes that ambiguity is ours of delegation. But ambiguity is not ours of delegation, and more often what ambiguity is, I don't have enough votes in Congress to make it clear, so I'm going to leave it ambiguous. That's how we're going to get over the bicameralism and presentment hurdle, and then we'll give it to my friends in the agency, and they'll take it from here. And that ends up with the phenomenon where we We have major problems in society that aren't being solved because instead of actually doing the hard work of legislation, where you have to compromise with the other side at the risk of maybe drawing a primary challenger, you rely on an executive branch friend to do what you want. And it's not hypothetical. When I hear you talk about...
Instead, you end up in gridlock, which we have now.
No, what I'm saying is Chevron is a big factor in contributing to gridlock. And let me give you a concrete example. I would think that the uniquely 21st century phenomenon of cryptocurrency would have been addressed by Congress. And I certainly would have thought that would have been true in the wake of the FTX debacle. But it hasn't happened. Why hasn't happened? Because there's an agency head out there that thinks that he already has the authority to address this uniquely 21st century problem with a couple of statutes passed in the 1930s. And he's going to wave his wand and he's going to say the words investment contract are ambiguous, and that's going to suck all of this into my regulatory ambit, even though that same person, when he was a professor, said this is probably a job for the CFTC.
I was just going to ask you to address stare decisis. Let's assume for the sake of argument that I agree with you that in 706 Congress has spoken to the problem, that we're not applying a fictional presumption, but that Congress has told us, we want courts to decide questions of law. The Solicitor General in the last argument talked about how litigants will be lining up for cases that were decided under Step 2 to seek to reopen challenges to the agency's interpretation. What do you have to say about the disruptive consequences of overruling?
So I think the Solicitor General, with all due respect, will be saying the exact opposite if this court overrules the decision, and will be saying, no, you got to look at it at the right level of generality. What I would say is this court has moved away dramatically from certain methods of interpretation, more dramatically than just we look at legislative history less now than we used to. Implied causes of action, as far as I can tell, are dead. But that didn't mean that every decision that was decided in the bad old days was overruled ipso facto.
But that's a little bit different because those implied causes of action, the court was saying this is what the statute means. Title IX implies the cause of action or whatever. This would be different because the court would just be saying, may not be the best, but the agency's interpretation is reasonable. So it doesn't settle it in the same way that maybe some of those old implied cause of action cases did.
If you don't want there to be disruption, all you have to do is make the precise level of generality move that you alluded to, which is, I would think, in every one of these Chevron cases, the question is the agency's interpretation of the statute lawful? And if the court has already held, yes, it is lawful, I would think that would settle the matter. And as I say in our brief, the only reason I have any doubt about that is because of Brand X. And Brand X is a huge embarrassment for the government and the government's friend. I looked through the bottom side amicus. I counted 13 amicus briefs on the bottom side. Only 2 of them cited Brand X. Because, gosh, it would be nice for that decision to just go away, wouldn't it?
Sorry, Justice Thomas.
But that absolutely makes clear that, this is a reliance-destroying doctrine. And frankly, if you said that Chevron is over and all of those Step 2 cases that were decided are going to have stare decisis effect because of the level of generality point I made, you would be giving new stability to the law. It would be improving stability. And that's an important distinction from Kaiser. In Kaiser, the Kaiser doctrine, the Auer doctrine rather, never had its Brand X moment where this court made clear that the agency could flip 180 degrees. And indeed, in Kaiser itself, it suggested the opposite. But here with Chevron, we know this is a reliance-destroying doctrine. Here's another thing to think about in terms of Kaiser. As I read the court's decision, in addition to the fact that we know it doesn't directly speak to Chevron, thanks to the Chief Justice, I also read it as all it says is you need a special justification. Well, I think we've offered you special justifications in droves, and special justification beyond the decision being wrong. And I don't know of a case where you would defer on stare decisis grounds when the relevant decision didn't cite the relevant statute at all. I mean, look, this would be a different world if Chevron went in and wrestled with Section 706 and said, despite all contrary textual indications, that it forecloses de novo review of statutes. I suppose I'd have to be here making every single stare decisis argument. But that is not what Chevron did. It didn't even mention the relevant statute. Now, of course, I don't want to be seen as running away from the stare decisis factors, because I'm happy to walk through all of them, because I think all of them cut in our favor. The decision is tremendously unworkable. Nobody knows what what ambiguity is. Even my learned friend on the other side says there's no formula for it, and that's an elaboration on what the government said the last time up here, which is that nobody knows what ambiguity means. But that's just workability. Let's talk about reliance. I talked about the Brand X problems, which are very serious problems, and I love the Brand X case because broadband regulation provides a perfect example of the flip-flop that can happen, but it's not my only example. There are amicus briefs that talk about the National Labor Relations Board flip-flopping on everything. Ask the Little Sisters about stability and reliance interests as their fate changes from administration to administration. It is a disaster. And then you get to the real-world effects on citizens that Justice Gorsuch alluded to, but I'd like to emphasize its effect on Congress, because honestly, I think when the court was originally doing Chevron, it was looking only at a comparison between Article 2 and Article 3 and who's better at resolving these hard questions. I think it got even that question wrong, but it failed to think about the incentives it was giving the Article 1 branch. And that's what 40 years of experience has shown us. And 40 years of experience has shown us that it's virtually impossible to legislate on meaningful issues, major questions, if you will, because right now, roughly half of the people in Congress at any given point are going to have their friends in the executive branch. So their choice on a controversial issue is compromise and forge a long-term solution at the cost of maybe getting a primary challenger, or instead just call up your buddy who used to be your co-staffer in the executive branch now and have him give everything on your wish list based on a broad statutory term. And my friends asked for empirical evidence. I think you just have to look at this court's docket. It's been one major rule after another. It hasn't been one major statute after another. I would have thought Congress might have addressed student loan forgiveness if that were really such an important issue to one party in Congress. I would have thought maybe they would have fixed the eviction moratorium. I could go on these issues. They don't get addressed because Chevron makes it so easy for them not to tackle the hard issues and forge a permanent solution. My friends on the other side also talk about, this is great because it leads to uniformity in the law. Well, I don't think that's an end in itself. Again, if it were up to me, if we think uniformity is so great, let's have uniformity and let's have the thumb on the scale inside of the citizen. But the reality is, the kind of uniformity we get under Chevron is something only the government could love, because every court in the country has to agree on the current administration's view of a debatable statute. You don't get the kind of uniformity that you actually want, which is a stable decision that says this is what the statute means.
Mr. Kamek, can I ask you the same question I asked Mr. Martinez about why Chevron was initially popular? People who were very sophisticated and had a deep understanding of how judges decide what a statute means and a deep understanding of how administrative agencies work thought that Chevron would be an improvement because it would take judges out of the business of making what were essentially policy decisions. Now, were they wrong then? And if they weren't wrong, then what, if anything, has changed since then?
So, Justice Alito, I think they were partially right then. So let me say what's changed and what hasn't changed, i.e. what the court missed back in Chevron. What has changed is we've come a long way in statutory interpretation. And, if Chevron was a response to some of the excesses of the D.C. Circuit in the freewheeling days of the late 70s and the use of legislative history, and oh, by the way, the text of this statute appears in the margin of my opinion, and I'm not going to talk about it again because I'm off to the races. We now, I think, are all textualists. The focus is much greater on the text of the statute. And once you recognize that, you recognize the problem with deferring at a certain point to the agencies. And let's look at the track record of the agencies before this court. If they are so expert, they should be able to persuade you in case after case that they're getting these statutes right. By my count and by Cato Institute in their amicus brief, since the court last cited Chevron, the administration is batting about 300 in these cases. So expertise is not all what it's cracked up to be. And that's true even in the most complicated cases. Look at the American Hospital Association's case. I don't think you're going to find a statute that's more complicated than that one. But yet this court had no trouble unanimously saying that you can't have hospital chain-specific pricing without first doing a survey.
Well, I don't know whether you can say we had no trouble.
I was going to say that, but...
No one was troubled to write a dissent. Let me put it that way. But and I can use other examples. Encino, a case where this court said that Chevron wasn't applicable because of a procedural defect. Now, it split the court 5-4, but how did it decide the case? It decided the case with the distributive canon. Do you think the Labor Department Wage and Hour Division is the experts on the distributive canon, or do you think
I was going to say that
with pronunciations case? I don't think you're going to find a statute that's more complicated than that one. But yet this court had no trouble unanimously saying that you can't have hospital chain specific pricing without first doing a survey.
Well, I don't know whether you can say we had no trouble.
I was going to say that, but so was I.
No one was troubled to write a dissent. Let me put it that way. But and I can use other examples. Encino, a case where this court said that Chevron wasn't applicable because of a procedural defect. Now, it split the court 5-4, but how did it decide the case? It decided the case with the distributive canon. Do you think the Labor Department Wage and Hour Division is the experts on the distributive canon, or do you think the courts are?
Thank you, Mr. Clement. The answer from Mr. Martinez on several questions about what happens when you get rid of Chevron in this case was Skidmore. And if Skidmore is going to occupy a more prominent role going forward, I'd like to know exactly what your understanding of that principle is.
So my understanding of Skidmore, consistent with Justice Kavanaugh's, is it's not actually a deference doctrine. Call it a doctrine of weight or persuasiveness. And then the beauty of Skidmore, as I understand it, I suppose the defect as well. Justice Scalia called it the totality of the circumstances. But I think the Skidmore test allows you to consider the weight of the agency's views, but then consider, is it something they came up with like right after the statute was passed, so it actually sheds light on the original public meaning of the statute? Or is it something that they didn't adopt for 20 years later? Or did they adopt one policy right after the statute was passed and actually flip it over 20 years later? All of that is something that Skidmore can account for, that Chevron has never been caused to account for. Now, you could modify it, a la Kaiser, and try to add all of that to it, but I do think that the Chevron experiment has failed.
Well, it's usually described as a deference doctrine. People talk about Skidmore deference.
Yes, they do, Mr. Chief Justice, and that puzzled me a little bit, and I went to the dictionary and I looked up deference, and the most common definition is yielding to the will of another. And I think if that's the definition of deference, then you shouldn't apply Skidmore, in a way where you actually say, all right, this is super close, and I think I have the right answer, but I'm going to yield to the position of the executive branch.
That's never what Skidmore has been understood to mean or said. It said the persuasiveness of the government's interpretation depends upon the circumstances, and some of those you enumerated.
Absolutely.
Call it what you will, that's what it is, right?
Look, I don't mean to be pedantic, but I do think that calling it deference sort of gets you to footnote 11 land in a junior varsity way, and I think that would be unfortunate. And the other great thing about Skidmore is
Skidmore, I mean, what does Skidmore mean? Skidmore means if we think you're right, we'll tell you you're right. So the idea that Skidmore is going to be a backup once you get rid of Chevron, that Skidmore means anything other than nothing. Skidmore has always meant nothing.
Justice Jackson, the earlier one, would beg to differ with you on that score. He thought it was quite important, and I think, if you look at the Skidmore case itself, I mean, it took into account the Wage and Hour Division's view of waiting time, and ironically enough, in that case said, we can't have a bright line test one way or another, because the agency has looked at this and thought a lot of time, and it's really going to be more fact-dependent than that, and we can take that into account. I think in some of these situations, you are going to be able to look at the agency's expertise and make a judgment that this is in their bailiwick. They've really made some pretty good points. But in other contexts, you're going to see that what the agency wants you to defer to is its own view that, as in this case, we ran out of money. And it sure would be nice if we could just impose this fine and continue to monitor these people at a 50% rate by making them pay for it instead of us having to pay for it. I mean, there's no expertise there.
Thomas? Justice Alito? Mr. Here? Justice Kagan?
I guess what I'm struck by, Mr. Clement, and this follows from this Skidmore thing, because Skidmore is not a doctrine of humility, but Chevron is. Chevron is a doctrine that says we recognize that there are some places where congressional direction has run out, and we think Congress would have wanted the agency to do something rather than the courts. We accept that because that's the best reading of Congress, and also because we know in our heart of hearts that agencies know things that courts do not. And that's the basis of Chevron. And then you take that doctrine of humility and you put on top of it stare decisis, another doctrine of humility, which is to suggest we don't willy-nilly reverse things unless there's a special justification. Here, Kaiser said it's even more than that. There's even more reason not to reverse something, because there have been 70 Supreme Court decisions relying on Chevron, because there have been 17,000 lower court decisions relying on Chevron. And you're saying blow up one doctrine of humility, blow up another doctrine of humility, and then expect anybody to think that the courts are acting like courts.
With respect, Your Honor, this court has on multiple occasions corrected its own errors when it comes to statutory interpretation, how to deal with qualified immunity, implied causes of action. In the Encino motor case, there was a canon of construction that said exemptions to FLSA provisions should be construed narrowly. This court overruled that and said that should have no role to play in interpreting the FLSA. It didn't run through the stare decisis factors. So I think there is, I don't know whether you call it humility or just clarity, but when the question is judicial methodology, I think it's very weird to ask Congress to fix your problems for you. I don't think you actually want to invite, in all candor, that particular fox into your henhouse and tell you how to go about interpreting statutes or how to go about dealing with qualified immunity.
Kaiser, 5 justices, a majority of this court, made clear that our deference was subject to normal principles of stare decisis, and to the extent that there was a ratchet up or a ratchet down, it ratcheted them up because it understood that that deference decision was the basis for tens, hundreds, thousands of other decisions.
So I'm going to be at a disadvantage in debating what exactly Kaiser held. But the way I read Kaiser is it said that you need a special justification beyond the decision being wrong. I think we've given you that in spades. Kaiser did not, with all due respect, wrestle with Saucier against Katz. It didn't wrestle with Baudin in the opinion. So I think I can reconcile all your law by saying, all right, when it's a procedural rule or a court-made rule of interpretation, maybe we look to some of the same factors, but they don't apply with the same weight as they would if it were a substantive result. And that does make sense because, at least under our view of the world, when you move on from a bad methodology, you don't overturn all those decisions, those substantive decisions. They still stay there. So Section 1982 still has an implied cause of action. Section 1981 still has a cause of action. I could go on and on. Those cases don't get overturned.
Thank you, Mr. Clement.
Justice Gorsuch.
One lesson of humility is admit when you're wrong. Justice Scalia, who took Chevron, which nobody understood to include this 2-step move as originally written, and turned it into what we now know. And late in life, he came to regret that decision. What do we make of that lesson about humility?
No, look, I do think that, reconsidering particularly a methodological error is part of judicial humility. And I do think if you look at Justice Scalia's Perez opinion, the mortgage banker cases, one of the things he said there most clearly, but he said all along, was our decision in Chevron was completely heedless of Section 706 of the APA. And if you're looking for a special justification to overturn an opinion, I think whiffing on the underlying statute entirely has got to be at the top of the list.
Thank you.
Justice Kavanaugh?
A couple questions. First, on Skidmore, I just want to say how I've thought about it, and you can tell me whether this is wrong, that it respects contemporaneous and consistent interpretations as evidence of the proper original meaning of the statute, because that's kind of common sense in statutory interpretation more generally, that if an interpretation was contemporaneous and consistent, it's more likely to be correct. So that's respect, but the word deference I wouldn't have used there.
I think you have that exactly right, and one of the virtues of looking at Skidmore that way is it is consistent with a principle that this court articulated in the Christopher against Smith-Klein-Beckman case, which is sometimes the industry is the one with a consistent long-term understanding of the statute that goes all the way back and sheds light on the original public meaning. And it seems to me Skidmore allows you to say if the industry is taking a position that's consistent from the beginning and the agency flips 25 years into the enterprise, Skidmore gives you the tools for saying, all right, agency, you're going to lose that case. Chevron doesn't.
Right. A big difference between Skidmore and Chevron, there are others, is when the agency changes position every 4 years, that's going to still get Chevron deference, but Skidmore would, the respect to that interpretation would drop out because it's not been a consistent and contemporaneous, consistent from the contemporaneous understanding of the statute.
Absolutely. Flip-flopping is a huge Skidmore minus, and it's a matter of indifference, or actually, if you look at some of the things that Justice Scalia said in the beginning, when he was enthusiastic about the doctrine, he viewed the fact that agencies could flip-flop under Chevron as being an affirmative virtue.
And Justice Kagan raises an important point about judicial restraint or humility in terms of Chevron, and that's an important concern for any judge. I think the flip side, why this is hard, the other concern for any judge is abdication to the executive branch running roughshod over limits established in the Constitution, or in this case, by Congress. So I think we got to find that's why it's hard to find the right balance between restraint and letting the executive get away with too much. On that front, there was questions earlier, do judges really rely on Chevron? You want to speak to that?
No, I'd love to speak to that because I think that's an important consideration. I mean, one of the premises of one of Justice Kagan's questions in the first argument was that, you rarely get to Chevron step 2, but there are statistics on this. There is the most exhaustive survey of over 1,000 cases by Barnett and Walker. We cited on page 33 of the blue brief. It found that courts were reaching step 2 in 70% of the cases. 70% of the cases. The Cato Institute brief, you might think, well, things have gotten better because that was a longitudinal study over a number of years. You might think, well, things are getting a lot better because we've signaled that Chevron is on sort of life support. But the Cato ran the numbers for like 2020 and 2021, and it's down to 60%. But it's still well over half the time your average judge in the Court of Appeals is getting to step 2, and Judge Kethledge, he hasn't updated that speech, but as far as I know, Judge Kethledge still hasn't gotten to step 2 once. And, that's an unsettlement in the law. That's a disconnect in the law that is very hard to get your fingers around. Like, at least if, one circuit says the statute means X and another circuit says Y, everybody can see that, cert can be granted, this court can resolve the case. But if courts are deciding some cases step 1, some cases step 2, in ways that are radically different, I don't even know how you really unearth that. So I think that's another huge problem with this.
One last question. If Chevron were overruled, I think your brief says we should go ahead and decide the issue, the statutory issue in this case. Can you speak very briefly to why?
Very briefly, because I think it would give a great illustration of how to do plain old-fashioned statutory construction. It would also be a useful object lesson in how far very good judges get astray by applying Chevron. Because another problem with Chevron, I'll still try to be brief, it tends to focus on 1 or 2 terms and ask whether they're ambiguous, and you lose the context of the statute. I think if you have the context of this statute and the fact that the only other places they put these kind of fees on domestic fisheries, they put a serious cap, and then they did it only for the most well-heeled fisheries or in special circumstances, this is an easy case doing good old-fashioned statutory construction.
Thank you.
Justice Barrett?
So we have a host of canons, clear statement rules, some of which are constitutionally inspired. And when I asked the Solicitor General in the last argument about whether Chevron should be thought of as part of that package, she said that Chevron kind of stood distinct, that Chevron was unique. Can you address that?
I think she's right about that. I think it sits out there like an island, and that's part of the reason to overrule it. And I think all the other canons, that I can think of are fully consistent with de novo statutory interpretation. I might be missing one, but the ones I think of is when you're doing de novo statutory construction, you take into account all of those canons. Chevron's the only one I know that says that at a certain point, you just stop the de novo stuff and you sort of surrender even under circumstances where if the agency weren't a litigant, you would keep going. Only Chevron does that.
One last question. You said, you pointed out that on our docket we've had multiple cases in which the major questions doctrine has come up. Do you think that overruling Chevron is going to solve that problem? Because in a lot of those cases, the agency has hung its hat on words like appropriate, on the kind of language which I think, and you can tell me if you disagree about this, I think you agree that when a statute uses a word that leaves room for discretion, like appropriate, feasible, reasonable, that is a delegation of authority to the agency. So don't you think agencies will still continue to rely on words like that in ways that might not, limit our emergency docket?
I'm not so naive to say that overruling Chevron is going to solve all the problems with the emergency docket, but it is going to make it a lot better. Because sure, there's some places where they use appropriate or they try to use modify, which was bold in light of AT&T, but whatever. They pick some of these words that are more capacious. But that broadband case is coming here. That's a case that shouldn't be Chevronized. Someday somebody's going to litigate whether crypto is an investment contract. Justice Kagan's confident that, AI is going to get here because of a statute. I think it's more likely that Congress is going to say, well, there's some scientific officer in Commerce, we'll let them fix the problem. But so my own view of this is it's not a cure-all, but it's going to move things very much in the right direction.
Thank you.
That is too much.
Thank you. General Prelogar, welcome back.
Thank you, Mr. Chief Justice, and may it please the court. Throughout this litigation and at times this morning, petitioners have sought to characterize this case as presenting a fundamental question of the separation of powers and a test of Article 3. Will courts continue to say what the law is? But I think stepping back, I want to make sure that what doesn't get lost in the shuffle is that petitioners have made an important concession that I think illustrates that the issue here is actually far narrower and that their attacks on Chevron lack merit and are unnecessary. The concession is this: petitioners acknowledge that Congress can expressly delegate to agencies the authority to define statutory terms and fill gaps. Imagine, for example, if the statute said in Chevron, stationary source as defined by the administrator. I take both petitioners to give that up and recognize that is a delegation and courts should respect that. The role of the court in that circumstance is to make sure that the agency has followed the proper procedures and stayed within whatever outer bounds Congress itself has set. And all of that complies with the Constitution, of course, because Congress has Article 1 authority to delegate gap-filling authority to agencies, and the executive has core Article 2 authority to fill in those gaps. That's a core exercise of the executive power. And then the Article 3 courts are just fulfilling their judicial role when they give effect to what Congress has done in its choice to rely on the agency in that regard. But I think what all of this shows is that the constitutional attacks on Chevron and the suggestion that it's egregiously wrong in that regard lack merit, because there is no constitutional distinction between that kind of express delegation and the delegations recognized in Chevron. If Congress can expressly vest an agency with authority to interpret the law through an express delegation, then it can do the same thing implicitly, especially in a world where Congress has to provide the agency with the express authority to carry the statute into operation with the force and effect of law. Now, we can debate, of course, whether Chevron drew the right line in identifying exactly when these delegations have occurred. I think the court got that right for all of the reasons I've tried to explain this morning. But I think it's important to recognize that that debate doesn't have a constitutional dimension to it. That falls out of the equation. Instead, it's just a question of whether the court drew the right line in identifying when a delegation has occurred. And if you recognize that, then I think what's left over are the practical concerns that have been raised about Chevron. And I don't want to diminish the force of the concerns that some members of the court have articulated, but I also think that those concerns are manageable. The court could do in this case what it did in Kaiser. It could clarify and articulate the limits of Chevron deference without taking the drastic step of upending decades of settled precedent. And I think that's the right thing to do here. You know, my friends in their briefs both said judges should aspire to be like umpires calling balls and strikes. But stare decisis is part of the rules of the game here too. And in this case, I think all of the stare decisis factors counsel in favor of retaining Chevron. I welcome the court's questions.
How do we discern delegation from statutory silence?
So, Justice Thomas, I think that it would be wrong to suggest that you can neatly categorize cases as those involving silence and those involving ambiguity. And the reason for that, I recognize that Chevron itself used both of those terms, but I think that the court was just trying to be comprehensive about those kinds of circumstances where Congress hasn't itself directly resolved an issue. There's never going to be total silence in a statute. At the very least, the agency is going to have to be able to point to the express delegation of rulemaking authority, the directive from Congress to put the statute into effect with the force of law. So that will always be at least a baseline in this context. And then in the mine run case, you'll be able to point to any number of additional features of a statute that help to signal the agency's authority. And actually, this case is the perfect example because my friend said that the Magnuson-Stevenson's Act here is silent on the issue of whether the industry can be required to pay for monitors. But we have 4 different provisions of the Act that we've pointed to that undergird the agency's authority. There's the provision that expressly says that the agency can require the vessels to carry the monitors. Then there's the definition of what a monitor is under the statute. It can include a private third party. Then there's the penalty provision that says in a circumstance where the vessel owner has contracted with a private third party and not paid, the agency can penalize. And finally, there's the residual authority to enact necessary and appropriate terms in these fishery management plans. So we don't think that this is a case about silence at all.
General, yeah, that's really good. Again, we're back to the same question the Chief had of Mr. Clement. That's a really good statutory interpretation argument. Sounds like exactly the bread and butter of what we do every single day. And we can resolve that, right?
We think that you could find that this statute is clear, but I think that...
The fact that you think it's clear and Mr. Clement thinks it's clear, but a court below thought it was ambiguous should tell us something, shouldn't it?
No, I disagree with that. And I should say that I think actually if you look at both what the D.C. Circuit and the First Circuit were doing in these cases, they recognized the force of the arguments. The D.C. Circuit, it's true, and Loper-Bright acknowledged that ultimately it couldn't conclude with confidence that the statute definitely authorized the agency explicitly.
But you think it does.
We think that there is a lot in the statute to, support the agency's interpretation.
You think you win under step 1, and so does Mr. Clement. And yet here we are.
I don't think it's at all unusual to find a case where the government thinks it has both the clear interpretation of the statute on its side and that the agency has acted reasonably.
Yeah, because we have this ambiguous ambiguity trigger that nobody knows what it means.
Well,
now, let me just ask you about the delegation, your example in the opening, which is interesting.
Yeah.
I totally understand a statute that does delegate. You know, you make up what rate you think. And that might pose a delegation problem, might not, fine. But we know Congress delegated it. That's one thing. What you're asking us to do is infer from a linguistic ambiguity that may not be the product of any intent at all, pulsiver, and might mean or in some circumstances. And infer from that not that we should go to look at statutory context and other clues within the statute itself to determine who has the better reading. But the government should always win that case.
No, not at all. Of course you should look at context.
That seems to me
That's
very
part
different.
Of the tools
Just to finish up. I understand the delegation in one context, but I struggle to see that we should infer the fiction of delegation in the second, always and necessarily.
So I disagree that there is a fiction of delegation in the circumstances that trigger Chevron. At the outset, I want to make perfectly clear that, of course, the statutory context and structure is one of the important tools of interpretation that a court should use at step 1. So if we are in a world where the court can walk through those factors and ascertain that Congress spoke to the issue, let me just be very clear. We recognize the court then should give effect to what Congress is saying. And if what you're suggesting then is that in a world where Congress hasn't actually spoken to the issue, the court should give no respect at all to the agency's interpretation, I disagree that that is faithfully implementing Congress's intent, because what Chevron recognized is in a circumstance where Congress hasn't spoken to the issue, given the express grant of adjudicatory or rulemaking authority to the agency, and necessarily recognize that the agency is going to have to fill the gap along the way, it is perfectly sensible to presume that Congress would want the agency to do it.
Let me just ask you about Michigan versus EPA, too, because that had a very broad, it was somewhere between the example you gave of agency go forth and come up with rules and a linguistic ambiguity about the meaning of the word and it said essentially appropriate, necessary. The court found there were outer boundaries even there that can be exceeded, right?
Yes, absolutely. And we're not suggesting that in a
So
world
courts
where you're at
can do that, right?
But what I'm disputing is the idea that there is always a binary answer either way, rather than a vesting of discretion.
There was a binary answer in Michigan versus EPA, right?
There was a particular agency regulation that was under review, but if I understood my friend correctly today, he seems to suggest that in all statutory contexts, you can look and say, Congress dictated it. There is a binary answer with respect to broadband, or there's a binary answer with respect to how to define stationary source. And what Chevron recognized, and what I think is just absolutely true, is a matter of the on-the-ground realities and how Congress legislates, is that Congress doesn't actually decide all of these issues. What Chevron recognizes is that when Congress hasn't decided it, and some follow-on person is going to have to fill in the gap, and it's a question of whether it should be the courts or the agency, there is a presumption here that Congress intended it to be the agency, but always subject to those guardrails about making sure the agency's construction is reasonable.
Mr. Clement suggested that we should ignore Chevron because it didn't deal with 706. Do you have a theory as to why it didn't address 706? And how do you respond to that part of his argument?
Yes, so my theory for why Chevron didn't address 706 is because 706 has never been understood at any time, at the time it was enacted or in any of the 8 decades since, to have dictated a de novo standard of review for all statutory interpretation questions. So there was no inherent tension between Section 706 and Chevron. I think it's actually just further confirmation of what the APA's own history shows. As I was trying to explain in the first argument, this is a situation where the court has recognized that the APA wasn't meant to create dramatic changes. And it would have been a dramatic change, going from all of the deference principles that had been deployed, particularly in cases of ambiguity in the case law, including immediately leading up to the APA, to a de novo standard on a prospective basis going forward, would have been a big change in the relationship of how judicial review occurs for agency action. But no one mentioned that. No one suggested at the time that that was the right way to interpret the APA. It's never how this court has interpreted it. And I think this is an important point, Justice Barrett, in response to your questions about the APA. It's not as though this has just been a one-off decision. The court has had any number of decisions, over 70, applying Chevron. And I think in each and every one of those, it's important to recognize that there hasn't been this kind of inherent tension between the APA and Chevron itself, which just, I think, further shows the court's own understanding of Section 706 is entitled to some weight here.
So I have a question about the relationship between Brand X and your suggestion that we Kaiserize Chevron, essentially. So I understand Brand X to say that a court must let go of its best interpretation of a statute if an agency advances an inferior but plausible one. But you told us that one way to handle this would be to emphasize footnote 9 and say what we said in the Kaiser context that no, use all the tools in the toolkit and come up with your best interpretation. So why wouldn't adopting your approach require us to essentially repudiate Brand X?
So if you understand Brand X to hold that the court can think it has a best interpretation, it has figured out what Congress was saying about this issue and Congress spoke, and nevertheless has to adopt some inferior agency interpretation, then that is inconsistent with our approach. We don't read Brand X that way. I understand Brand X to be distinguishing between Step 1 and Step 2 holdings. So if there is a Step 1 holding where, in fact, the court has got it at the end of the day and recognizes that Congress spoke to the issue, there's no room under Brand X to let an agency come along after the fact and say the statute should be understood some different way. It's only in the circumstance where there was Chevron deference granted under Step 2, and part and parcel of that is recognizing that that's because the statute was interpreted at the first time to not actually supply an answer dictated by Congress and instead to give the agency discretion.
Court have a best answer if it's a Step 2 question? I mean, it seems to me that having a best answer suggests that you engaged in a question of statutory interpretation, came up with your best answer, and it might just be really hard. So sometimes if a court outside of the agency context confronts a difficult question of statutory interpretation, they might say, look, I'm 90% confident or I'm 95% confident, but I mean, I think your reading of Brand X might depend on what the trigger for ambiguity is, right?
Well, I do think that it's kind of clearly demarcating the lines between step 1 and step 2 holdings. And so at least the rules of the road are clear with respect to when an agency might have been granted discretion to revisit its prior conclusions. You know, if you're suggesting that there's a way to read Brand X to say that even in a circumstance factoring into the equation the possibility that Congress meant to delegate to the agency, that there is a better interpretation, a best interpretation, that Congress actually resolved it, I just don't think you would ever get into the Brand X scenario, because that sounds to me like a step 1 ruling. And I take the point that there is some inherent lack of precision in a term like ambiguity. That's not something that's uniquely created by Chevron, of course. There are ambiguity triggers in the laws in all kinds of contexts. But it's also that kind of indeterminacy that might be worrying you is not anything that's cured by overruling Chevron. Because as I was saying to Justice Kagan in the first argument, I think it will just open up a world where there is a lot of indeterminacy and inconsistency in how judges are applying the principles in a case of ambiguity.
On that point, some of the amicus briefs and the briefs point out the experience of some of the states with Chevron. Some states don't have Chevron, and other states haven't had something like Chevron but have eliminated it in recent years and decades. And their experience, they say, has shown that it's plenty workable in such a regime. So I just want to make sure you can respond to that.
Yes. So my understanding is about half the states still have something akin to a principle of deference. There might be some variance with respect to how much it looks like Chevron, but I acknowledge that some states have abolished any form of deference to administrative agencies. I do think that there is a lot less concern at the state level about the lack of uniformity or consistency. So one of the values that Chevron implements and recognizes for why Congress would prefer for an agency to be able to set these rules and for the courts to respect that is the value in ensuring that there are uniform rules throughout the country. And I don't think that that same experience exists at the state level. And I would just add as well, in a lot of states, I think the political accountability rationales could differ as well because many state court judges are elected.
Did I understand you in response to a question from Justice Thomas to say that Chevron doesn't apply to constitutional questions?
Yes, it's only a doctrine that applies in the context of statutory interpretation.
Well, I know, but how you interpret statutes certainly can have an effect in raising particular First Amendment questions or otherwise. And does it apply in that situation? The Department of Education has some rule. This applies to, all schools, and it can apply to religious schools because this is how we interpret, whatever the impact of the rule is. And when we interpret it that way, we don't think it raises any free exercise problems. So is there Chevron deference there?
So I think that if a particular interpretation would create serious constitutional problems, then the doctrine of constitutional avoidance is one of the traditional tools that the court can consult in order to understand whether Congress spoke to the issue.
And the agency says we don't think this causes particular constitutional problems. That's our expertise about how we apply this provision, and given that, we think there's no free exercise problem.
No, a court would not defer to that because this is all happening at step 1. I think that this is part of the process of the court determining whether Congress spoke to the issue, and the court has been very clear that deference doesn't come in at all until you get to step 2. So, for example, the agency's view that it deserves Chevron deference or, its kind of take on one of those step 1 issues, it's not itself meritorious of getting any deference at that stage of the case. I do want to take another shot at trying to explain why I believe petitioners are wrong to have characterized Chevron as resting on a fiction. And I think what they have tried to say is that this doesn't really reflect what Congress is intending. But I see 3 principal problems with that. The first is that I think that actually looking at it from a matter of first principles, there is a lot of merit and weight to the recognition that in a situation of genuine ambiguity, there are good reasons for Congress to want to vest the expert agency with this kind of authority. It's the recognition that agencies of necessity are going to have to fill in the gaps, and many of these programs are complex, they're technical, they're going to require the agency to draw on its longstanding experience with the program and the expertise it's accumulated in working within that regulated industry in order to make a sensible regulation that also will encompass, I think, inherently some policy considerations. Congress would know that the agency can run a centralized decision-making process in doing this. Chevron only applies in circumstances where there is a sufficient level of formality in the agency's decision-making. That's usually notice and comment rulemaking, and that's a process where all comers can come in and tell the agency, here are our views, here's what you should think about in terms of regulating.
That notice point is a very important, it seems to me, to your argument, because the rationality of a supposition that Congress would want to favor the government rather than a supposition equally rational that it would want to favor individual liberty is made a little more weighty if you assume that the government's provided everybody a notice, an opportunity to be heard. But often the government seeks deference for adjudications between individual parties and then apply that to everybody without notice to them. Or deference for...
This is part of the interpretation. You know, I do want to take another shot at trying to explain why I believe petitioners are wrong to have characterized Chevron as resting on a fiction. And I think what they have tried to say is that this doesn't really reflect what Congress is intending. But I see three principal problems with that. The first is that I think that actually looking at it from a matter of first principles, there is a lot of merit and weight to the recognition that in a situation of genuine ambiguity, there are good reasons for Congress to want to vest the expert agency with this kind of authority. It's the recognition that agencies of necessity are going to have to fill in the gaps, and many of these programs are complex, they're technical, they're going to require the agency to draw on its longstanding experience with the program and the expertise it's accumulated in working within that regulated industry in order to make a sensible regulation that also will encompass, I think, inherently some policy considerations. Congress would know that the agency can run a centralized decision-making process in doing this. Chevron only applies in circumstances where there is a sufficient level of formality in the agency's decision-making. That's usually notice and comment rulemaking, and that's a process where all comers can come in and tell the agency, here are our views, here's what you should think about in terms of regulating.
That notice point is a very important, it seems to me, to your argument, because the rationality of a supposition that Congress would want to favor the government rather than a supposition equally rational that it would want to favor individual liberty is made a little more weighty if you assume that the government's provided everybody a notice, an opportunity to be heard. But often the government seeks deference for adjudications between individual parties and then apply that to everybody without notice to them. Or deference for interpretive rules for which no notice and comment, let alone formal rulemaking or adjudicatory proceedings is required. And so there are many circumstances in which the government does seek deference for a view of the law that affected parties have no chance to be heard about. What do we do with that?
So I think with respect to the category of interpretive rules, it's true that the court hasn't ruled out that those can receive deference in appropriate circumstances. But
so you'd have us Kaiserize that?
Well, I would just have the court reiterate what it said in Meade, which is it's not as though any agency pronouncement is necessarily going to warrant deference.
Well, nobody knows what Meade means. I mean, it's got 7 factors to it, and the lower courts complain about that too. So I don't know what that. I mean, is that another factor we're going to add to Meade?
I think that Meade is an important check on ensuring not only that there's been a delegation here, but that the agency has used the appropriate process and procedure.
Okay, so interpretive rules would be out under your.
So I think they raise a much harder question.
A harder question, but do they rule in or out on your theory?
I think the court has not ruled them out under Meade. If you thought
what would you have us do?
I would have you retain Meade, which recognizes.
What would you have us do with interpretive rules? Is my question, not Meade. I mean, I don't know what to do with Meade.
Well, I don't think that you can treat them as a class. I think it's going to depend on the nature of the particular interpretive rule, and
sometimes notice is required, and sometimes it isn't. How about adjudications? You keep those in, I'm sure.
Yes,
yeah.
We certainly think the Chevron has core application to adjudications, and I agree that in that circumstance, there's not the same ability to take the input from all comers. But the court has emphasized that in the mine run case where it has been applying Chevron deference, there is this possibility, at least, of a centralized decision-making process in order to ensure that the agency at least is gathering the facts and has the tools at its disposal. And the alternative to each of these, Justice Gorsuch, is to have the courts do it through piecemeal litigation. At the very least, I think that it's easy to see why Congress might think that that is not as good of an alternative in a circumstance where the court's pronouncements could come out of nowhere with respect to a particular party. We have an amicus brief from the small business.
Except for everybody gets to litigate their case. Everybody.
But I think that it's important to recognize that particular decisions can have impacts on parties who are outside.
As a matter of precedent, possibly within that jurisdiction. But even that person who's bound by the precedent can appeal it all the way to the Supreme Court. Everybody gets their day in court.
Absolutely.
Versus under your view, many people without notice, any notice, or any chance to be heard are bound.
No, so my concern and what I was focusing on with respect to the prospect of disrupting expectations with respect to litigation is that it's not as though every party who might stand to be affected by a case is necessarily going to know about it. Look at the amicus brief that was filed by the Small Business Association.
No, of course they're not going to have notice about somebody else's case, but when the government comes for them, they get to take their case to court. They get a neutral
Obviously,
judge.
when they are a party, they have an opportunity
They get to
to
appeal.
participate.
Okay.
But Congress has often expressed a preference for not having these kinds of issues resolved piece by piece in different courts around the country with the prospect of the disuniformity that
Yes,
that
it is
creates.
provided for notice. It provided for formal and informal formal rulemaking and adjudications, and it anticipated most of rules would be resolved that way. In fact, they aren't. For a long time, those processes haven't been used, and agencies rely on informal adjudications and informal rulemakings. And really now today, perhaps as a product of Chevron and 2, agencies have advocated that and are moving more and more toward interpretive rules where they don't have to provide notice and comment.
But I think that does circle us back to the fact that the court has not suggested that interpretive rules are necessarily going to trigger deference. And so I think at least in the mine run case that this court has looked at, it's the product of a formal process from the agency, and I think it's an important process.
On the adjudications front, I think one of the amicus briefs talked specifically about the NLRB in particular and kind of how that agency moves from pillar to post fairly often, and concern raised there, because that is a situation you can't adjust your behavior ahead of time necessarily based on a new rule, new change in interpretation, but it's done in the particular case and affects the people who didn't have notice. Any response to that brief or that scenario, or want to tell me why that's wrong?
Well, I guess my overarching response to that set of concerns is that the agency has to justify its decision-making with respect to whatever tool it's using to implement the statute in the way that Congress directed. So if Congress is telling the agency you should adjudicate or you should conduct notice and comment rulemaking or giving it its authority to choose between those tools, the agency in either context is going to have to justify what it's doing. And in particular, my friends have focused a lot on the idea of agencies changing their minds. There are burdens in this context. The agency has to take account of reliance interests. A lot of this gets put into State Farm, of course, but I think also at Chevron Step 2, with respect to reasonableness, a court can permissibly take those kinds of considerations into account.
Thank you.
Do you want to finish your answer about what you would say to your friend's view of fictionalized intent?
Yes, so I was trying to defend Chevron as a matter of first principles, and that was kind of the first order answer on this. There are often really good reasons why Congress would want an expert agency to take the first crack at filling in the law. And there's no way around it. If the agency is administering the statute, the agency has got to do it. And this court has said that a core feature of executing the law is interpreting statutes along the way, understanding for the agency what the law means. The second point I wanted to make is that even in the situation where you think there's more room for doubt about exactly what was happening in 1984 and what Congress would have expected, this is a really foundational precedent from the court. It's not like Chevron has flown under the radar and Congress is unaware of it and doesn't realize it's out there and kind of setting the ground rules for how this court and lower courts are going to understand what Congress is doing. This is one of the most frequently cited decisions from the court, and in that context in particular, I would think that the inference of legislative intent becomes all the more sound because Congress has not chosen to displace it, and as well, it triggers, I think, that critical, strong form of stare decisis that the court applied in Kaiser when it recognized that in a situation where Congress is actually the best institutional actor to do something about it, it matters. It matters that Congress hasn't sought to change Chevron in any kind of fundamental way.
Thank you, counsel.
That's okay.
I do have one more. I'm
Hold
sorry.
on, I did.
I'm sorry.
I was waiting for us to go around. I know this is not in the heady intellectual question, but how do you respond to Mr. Clement's point about the interpretation of this particular statute and his reliance on the theory that this Congress definitely, when it capped big industry paying 2 or 3%, whatever the number is, would not have wanted small fishermen to pay 20%?
So I have a range of reactions to that. My first is, as I was suggesting to Justice Gorsuch, we think, and to Justice Thomas, we think that there is a lot in this statute to support the agency's exercise of regulatory authority here. And I want to point in particular to the penalty provision, which specifically contemplates that the regulated vessels might have a contractual relationship with third-party monitors and therefore might be in a situation where they haven't paid, and it says the Secretary can sanction in that circumstance. So it's premised on the idea that there will be certain circumstances when there is that direct relationship.
Just as a footnote in the schedule, in the way that Congress did the other two monitors, they were always government monitors, not independent monitors, correct?
Yes, so so there are 3 fee-based programs that my friends have relied on to try to support this idea that there's a negative inference you should draw from the statute. 2 of those apply in the domestic context, and those operate as pure fee-based programs, so it's very different. Ultimately, they pay fees to the government. The government provides a range of services, including providing the monitors, entering into the contractual relationship, and having those monitors be government contractors. And those programs also pay for particular administrative expenses that would not be a part of this program. The foreign vessel program likewise operates in this fee-based way. There is a residual part of that program which contemplates that in a circumstance where there aren't sufficient funds, it might be possible that the regulated vessel will then, through a supplementary authority, be required to contract with the monitors directly. And I think my friends would say, well, that's the whole explanation for the penalty provision. But it doesn't work because Congress put that penalty provision in an overarching section of the Act that applies to domestic vessels too. If this was really just meant to be a tendril to tack on to the foreign vessel program, that would be completely inexplicable. So I think that they don't have a persuasive response to the penalty provisions here. And they say, to wrap this up, that it's unheard of to charge 20%. I do want to be really clear. They are latching on to a part of the rule that acknowledged that earlier versions or studies had suggested that costs could go potentially up to 20%. But then the agency acted in response to that. It created waivers, it created exemptions, and with respect to some of the types of fishing at issue in these cases, the estimated costs were more in the range of 2 to 3%. So this is all something that courts can look at and review. They in fact pressed arguments that this rule was arbitrary and capricious for neglecting to give full attention to the costs. The lower courts rejected those arguments, and I think rightly so.
Justice Kagan?
Justice Barrett asked before about Kaiserizing Chevron, and I just wanted to ask, what would that mean? I mean, would it mean doing exactly what Kaiser did to our deference, to Chevron deference? Would there be adjustments that would be necessary? Would one want to go further in any respect? What does it mean to Kaiserize Chevron?
So I think that the court in this case, if it has some concerns about the implementation issues, could do 4 critical things, which draw heavily on Kaiser, but I think look a little different in their particulars. The first thing the court could do would be to re-emphasize the rigor of the Step 1 analysis. Now, this is drawn directly from Kaiser. As I mentioned before, we've seen results in the lower courts where they are now following this court's direction with respect to that. So in this regard, what the court would be saying is, don't wave the ambiguity flag too readily. Don't give up just because the statute is dense or hard to parse. Instead, there are a lot of hard questions out there that can be solved and reveal Congress's intent if the court applies all of the tools and really exhausts them. So that would take care of a whole category of cases. Then at Step 2, I think the court could again do what it did in Kaiser, which was to reinforce that reasonableness is not just anything goes. Justice Gorsuch, I think at times has said it just means the government wins, but that is not actually the standard. Even at that Step 2 stage, it's obviously deferential, but the court should be enforcing any outer bounds in the statute and making sure that the agency hasn't transgressed those. I think the third thing the court could do is emphasize that this whole enterprise only gets off the ground in a Meade-type situation where you have the agency being directly empowered by Congress to speak with the force of law and then exercising appropriately a formal level of authority in implementing the statute. And so I think that that is an important principle as well, that there are certain contexts in which the agency is not actually speaking with the force of law or in a way that would be fitting with the delegation Congress has provided. And then finally, the fourth thing that the court could do, and I think this is a little bit different from Kaiser, would be to emphasize that it's always important to look at any other statutory indication that Chevron deference was not meant to apply. And what I'm thinking here of are things like situations where the nature of the statutory question, as the court has said in other cases, isn't one where you would expect Congress to give that to the agency. There's a flavor of this in the major questions doctrine case, and I don't want to rule out other scenarios that could come up, because part of our central argument here is Congress can adjust, Congress can react, Congress can take statute-specific steps, and so courts should pay attention to that. And there is nothing in Chevron that dictates that this presumption is irrevocable. Instead, it's fully rebuttable.
And is there anything you would say about the matter of changed interpretations?
So I think that changed interpretations already are an area where the agency is under additional burdens to justify its decision making. I think they get a harder look. And the court has made clear that in a circumstance where an agency is changing its regulatory approach, one of the things it has to do is take full account of the reliance interests and explain why those shouldn't alter what it's doing in the kind of revised approach. The agency also frequently, if it's come from a notice and comment rulemaking, has to run that process all over again. That's a time-intensive process. It takes a substantial investment of agency resources. So I think in that context, too, the court could police the bounds of that and make sure that the agency is following the procedural requirements to ensure that it's informed decision-making. But at the end of the day, if the agency can run the gauntlet and survive those hurdles, then the fact that it has some discretion under the statute to change its approach, I think is not something to say is kind of a bug in the statute. Instead, it's a feature, because there are all kinds of circumstances where Congress would want to give the agency the ability to adapt to changing circumstances, to new factual information, or to the experience it's accumulated under the prior program.
Thank you.
Justice Gorsuch, Justice Kavanaugh, Justice Barrett. Thank you, counsel. Rebuttal, Mr. Clement.
Just a few points in rebuttal, Your Honor. First, my friend started with express delegations. I think express delegations show all the problems with this fictional implied delegation. Because the great thing about an express delegation is you have some text. What an express delegation generally does textually is delegate implementing or executing authority. It doesn't do what Chevron purports to do, which is to delegate interpretive authority. But better yet, once you have text, you can put limits on the text. And Michigan against EPA is a perfect example of that. And of course, all of these delegations do raise Article 1 non-delegation concerns. And if you have text, you can check for that as well. But I can't think of anything that's more antithetical to an intelligible principle than ambiguity and silence. And I will say, in terms of this premise, I think it's entirely fictional. I think in most cases, a statute is ambiguous because the proponent did not have enough votes to make it any clearer. My friend at one point said that I view the whole world as every statute has a binary answer. To be clear, my position was the opposite. There are statutes like that, reasonableness, appropriateness. There are also things like information services, telecommunication services, a service advisor. Is it a salesperson who is involved in the servicing of cars? I say yes, but you could say no, but it's binary. The terrible thing about Chevron is you can't tell the two apart, because at a certain point they both look ambiguous. But what can tell the two apart? Good old-fashioned statutory construction. Find out, as the courts, what the words mean. Reasonable is a term of capaciousness and elasticity. Telecommunication service is not. Good old-fashioned statutory interpretation can do the job. Now let me say one thing about the mystery of why Section 706 did not appear in the Chevron decision. There's a really easy answer. It was a Clean Air Act case. The court sort of stumbled into these pronouncements about how, as a meta matter, you should go about statutory consideration. It was a mistake. It didn't wrestle with the relevant statute at all. That is a special justification to revisit the decision and to get the decision right. Let me say one word about expertise. Expertise and deference do not have to go hand in hand in a way that precludes de novo review. We have things called tax courts. We have things called bankruptcy courts. We have the Court of International Trade. They all deal with technical specialized issues. Every one of them, the legal questions are reviewed de novo. That's the basic understanding with a statute like Section 706. Lastly, let me say this. You cannot Kaiserize the Chevron doctrine without overruling Brand X. The fact that you could take into account if the agency had flip-flopped was part of the rationale of Kaiser, many factors before you applied an hour. That is a feature, my friend correctly admits, that is a feature of the Chevron doctrine, and you really can't Kaiserize it without overruling Brand X. And if you're overruling Brand X, well, then stare decisis just went out the window, and we might as well get this right. Chevron imposed a two-step rubric that was fundamentally flawed. The right answer here is a one-step rubric that simply asks, how is the statute best read? Thank you.
Thank you, Counsel General. The case is submitted.
Thank you, Your Honors.
Thank you, Counsel. The case is submitted.
And in a second case involving the interpretation of laws by
Justice Kavanaugh?
That I know. I mean, wrongdoing is defined by law usually, right? But you're saying no, it doesn't. He doesn't have to know that it's unlawful.
We will hear argument first this morning in Case 23-108, Snyder versus United States. Ms. Blatt.
Mr. Chief Justice, and may it please the Court. Section 666 applies to 19 million state, local, and tribal officials and anyone else whose employer receives federal benefits, including 14 million Medicare-funded healthcare workers. Congress did not plausibly subject all of these people to 10 years in prison just for accepting gifts, especially when federal officials face only 2 years for accepting gifts under 201C. 666 punishes corruptly receiving anything of value intending to be influenced or rewarded. Corruptly intending to be influenced covers classic bribes where officials get upfront payments in exchange for official conduct, while corruptly intending to be rewarded covers bribes paid after the fact and to officials who aren't actually influenced. The government argues corruptly under 666 means wrongful, immoral, depraved, or evil. But the government tried this case and countless others on the theory that corruptly just meant knowingly. Regardless, the government's new definition is implausible and stunningly vague. No gratuity statute, that's none whatsoever, uses the word corruptly, and for good reason. The government can't tell you what gifts are corrupt. What gift is too much for the doctor who saves your life? Is pornography an immoral gift? The federalism and due process implications of the government's view are gobsmacking. All states prohibit bribery, but localities and states take infinite approaches to gifts and outside compensation. Affirmance would let federal prosecutors second-guess all of these judgments. Meanwhile, state and local officials will have no way of knowing what gift would subject them to 10 years in prison. Remember, extensive guidance tells federal employees that accepting anything over $20 is a crime. It would be downright Kafkaesque to subject state and local officials to a standardless and severe regime where federal interests are at their weakest. I welcome questions.
Ms. Blatt, if I find a lost pet and return it to the owner, and the owner is grateful and gives me $10, that's a reward, right? Even though nothing else happened in advance between the owner and me.
So, yes, divorced from, a crime that makes it corruptly giving something of value, intending to be rewarded. The word reward, just divorced from text of a statute, context, common sense, at least in this case, sure. Reward can mean both a bribery and a quid pro quo bribery and a gratuity, and we think it's very significant in all the statutes that use reward to mean gratuities. They're vastly different in 4 respects here. They all say when reward is used to mean gratuities, these are cited at page 31 of our brief, they make clear that no quid pro quo payment is required. They say you can't receive any authorized fee or compensation. Also, there are 13 gratuity statutes identified in the brief. Virtually all of them have no express mens rea whatsoever. They have vastly lower penalties, and they almost exclusively apply to federal officials. And I think that just highlights that gratuity statutes are generally prophylactic rules where the government has a direct interest. And at least here, to use corruptly in a gratuity statute would make this statute a unicorn. It literally has no accepted meaning. It doesn't exist in any other statute. I don't think anyone knows what a corrupt gratuity is.
But I would think that a demanding mens rea would cut against you. In other words, if you add a demanding mens rea to the statute, one will have less fear that the statute is going to be applied in an overbroad way. So you're using that on your side, but I would think that it's really the government's argument.
No, mens rea can't help you if it's standardless and has no meaning and just leaves it up to a jury and I guess federal prosecutors.
So your view is dependent on the vagueness of the standard. If we just knew that it was a demanding mens rea standard, then it would cut for the government?
No, it's not just that it's vague, it's also unheard of and ahistorical. And I just don't think the government story holds up. The government story is, hey, in 1986, we had this gratuity language and we add the word corruptly. But that, of course, is not true. You had a statute that was identical to Section 201C that was a gratuity statute. And the Congress did not just sneak in the word corrupt. They deleted that statute in toto, hook, line, and sinker, and added corruptly intending to be influenced, rewarded in a way that looks much more like the 201B bribery statute.
I'm sorry. I thought the original 666 covered gratuities. And what Congress then did is instead of copying the bribery statute 201A, it decided to copy the gratuity statute 201C. So if they intended bribery, why didn't they just copy the statute that meant bribery?
So in 1984, the statute read, you can't give or accept anything for because official conduct, and that is the gratuity statute. That language got deleted in toto.
Well, but that's the point. Why not borrow then the language from 201A, from 201B, I'm sorry, 201B. B instead of C, instead of A.
And our point is it looks a lot like more 201B, which has the corruptly intending to be influenced. And I just don't think the story is that.
But they had that language, but they chose something broader and different. And so I don't understand.
I don't think it's broader at all. And let me see if I can be clear on this. 201B is very different. The court in McDonald said you can actually be convicted if you don't have any intent to be influenced under bribery. But under this statute, 666, the government...
They didn't have McDonald in front of them, so I don't know what that has to do with anything. They had clear bribery language in 201B, and instead they chose something closer to the gratuity language of 201C.
So, it doesn't look anything like 201C or any other gratuity statute in the U.S. Code.
Can I go to the disparity that you were talking about? Mm-hmm. 666, when it was clearly a gratuity, had 10-year statute penalty. So it was always disparate from other statutes involving federal officers. So what do I take from that? Meaning you say that Congress couldn't have intended to treat state from federal officials differently, but it always did. It did before it amended 666.
I wouldn't consider 2 years always. It was a short-lived statute that was immediately deleted. So, and I don't even know if the government had any prosecutions. But if I could just finish my answer on what I don't think the government has a response to. If a jury finds that a official was not influenced because he would have taken the same vote anyway, the jury has to acquit if the statute had just said intending to be influenced. And so intending to be rewarded is absolutely critical in this statute, and that is not the case of the federal bribery statute. This statute actually requires either an intent to be influenced or an intent to be rewarded. The other thing I can say about the disparate penalties is that no other statute in the U.S. Code puts gratuity on par with bribery. And under the government's view, you'd never, ever have to either charge, must let, prove an intent to influence, because under their view, any payment that is an intent to reward under their reading renders any need to prove intent to influence completely superfluous, irrelevant, and unnecessary. And that is an outlier in history and in the U.S. Code.
Can I ask you?
Sorry, go ahead.
Why do you keep saying that this doesn't look like anything else? I'm looking at 215, and it uses almost exactly the same language. It has corruptly, it has giving, offering, promising anything of value to a person with the intent to influence or reward. When I look at the legislative history of 215, it says, or 666 says that it's modeled off of 215. And 215's legislative history says it includes gratuities. So I'm just trying to understand what you mean about this not looking like anything else.
Of course. Let me take on Section 215. So You're right. The wording is quite identical, and the only court to address the issue has held 215 as a bribery statute. But on the legislative history, to be sure, a footnote in the legislative history of Section 215 mentions that that statute applies to gratuity. But if we're going to rely on legislative history, I'll take the footnote in the legislative history of Section 666 itself. When it references the Section 215 statute, it only refers to bribery. But now we're really going to be worrying over footnotes in legislative history. I'll take ours. But the other thing I would say about 215, which is extraordinary, is that there is a provision, I think it's 215D, that says orders federal agencies to give guidance. So every federal agency has issued extensive guidance to bank officials. There is massive guidance, of course, to federal officials. There is no such guidance. And had the government issued guidance, it would just make the federalism implications all the more bizarre. So bank officials are told, here's what you can and cannot do. And there's no...
And are they told you can accept gratuities in the 215 context?
The guidelines which were promulgated after Section 666 was passed. But again,
No, I'm sorry. What's the answer? Can they accept...
The guidelines do assume that 215 applies to gratuities, and that is the government's...
And the language is identical to 666, correct?
Correct, but the only court, no court has held that Section 215 applies to gratuities. It's got a 30-year sentence, and even if you did think it did, I would say the title at least mentions gifts, the legislative history says it means gifts, and there is a provision for guidance. None of those three things are true under Section 666. The title says bribery, the legislative history only mentions bribery, and there's no guidance. And it is truly unthinkable that officials would not know what type of gift is corrupt. Even a gift basket. Yes. I don't know where on the Harry and David menu the gift becomes corrupt.
Well, that's...
It ends at $3.19. It starts at $19.99.
Ms. Blatt, can I ask you, so you're referencing some of the horribles, and your brief points out, the Harry and David gift baskets, the tip, the gift card to your garbage collector, that sort of thing. Can you point to any actual prosecutions or convictions even that have pursued those kinds of...
Just two in our reply brief, and I don't know if they reached a conviction, but somebody was charged for soliciting donations to a sports league, and then another defendant was charged for having plaques and luncheon for female judges, and that was considered it. But this court, there's just legions of cases that say you're not going to interpret a statute with crazy breath on the trust me assumption of federal process.
And what about... just one other question. So, federalism breadth aside, you also point out that for private entities that take federal funds, then this would also channel into them. Apart from the pandemic money, are there other reasons to think that federal funds would pull private entities into this?
Yes. You held in Fisher that it covers Medicare, which is one of the largest industries in this country. It covers every nurse, doctor, orderly, anyone at a hospital. It covers any grantee, and I think we gave in the brief, literally Google government grantees, and there's just tons and tons. Lockheed,
I'm sorry, doesn't the nexus requirement get rid of most of this? The tax collector, the person who just says thank you generally. The nexus requirement says that the gratuity must be, quote, in connection with any business transaction or series of transactions of a covered entity involving anything of value of $5,000 or more. The trash collectors not having anything to do with $5,000 or the contract itself.
The doctor who removes your wart, fine, but the doctor who takes your gallbladder out or does your face, like my plastic surgeon, no, that's worth over $5,000. No, seriously, I'm not even joking. Snow removal's worth over
$5,000 or more. The trash collectors not having anything to do with $5,000 or the contract itself.
The doctor who removes your wart, fine, but the doctor who takes your gallbladder out or does your face, like my plastic surgeon, no, that's worth over $5,000. No, seriously, I'm not even joking. Snow removal's worth over $5,000. Writing a letter for your kid to get into college, that's priceless. I could go on and on and on.
But it still has to have a nexus to that contract.
Yes, and people give gifts all the time to nurses after an operation. That is a crime. Do you think...
Go
ahead.
Sure. Okay. I had thought that the government had actually pursued prosecutions below on the theory that the $5,000 in connection with the business requirement could be satisfied by pointing, for example, to the police officer's salary was more than $5,000.
The government took an outrageous view expansively, which is why they used 666 over 201, because they didn't think it had to be linked to an official action. But they did fancy footwork in their brief and says, no, we won't do that anymore, so we'll keep it closer to 201. But no, that's why they love 666.
I thought there was, in fact, an affirmed conviction in the Seventh Circuit in the United States versus Robinson along just
You can ask them, because I think they're a little cagey on how much they will give on what a business or transaction is. But even assuming it's tight, it doesn't take that much to do snow removal that's worth over $5,000, or the police officer who helps find your kid who's kidnapped. This is like government officials and healthcare workers do stuff worth over $5,000 every day, every second, every minute.
Can I ask? No, your turn now. No, please.
Do you think that the horribles also apply to the bribery side of the statute? I mean, what strikes me about the statute is the number of people that it covers. But you can imagine all of your horribles being done on the bribery side. I give the orthodontist for my kids hockey tickets so that, and we kind of it is a quid pro quo so that, my kid gets the best appointment or something like that. I mean, you can imagine a whole lot of cases where even though there's an explicit bribe, it also seems like, really, we're criminalizing that? So I'm just wondering whether the horribles only apply to gratuities as opposed to there are horribles in this statute because of the kinds of people it applies to.
No, I disagree, Justice Kagan, for this reason. Under Section 201, there's a 15-year sentence for bribery. Government hates to have to prove a quid pro quo, and there's a 2-year sentence for gratuity where it's really easy to get a water bottle plus a mug and it's over $20. There's vast difference. The government, if it's that no big deal, let the government just prove quid pro quo. Just let them. It's much more damaging. The government has a direct interest. If you have to prove there was an influence on your official conduct, at least the government says it impacts the federal program. Here they have 6 different ways where they're defining corrupt. If it's not benign, if it was against the employer's rules, it's against common sense rules, if you're conscious of wrongdoing, which I have no idea what it means, if it could skew your official decision making, it is very different to say, and I do think the fact that all states prohibit bribery cold, and not all states, some employers in some localities allow gifts. They just do, because they're not corrupt, unless it's prophylactic.
How would you define corruptly if you had to in this particular provision?
Well, we would win if it was defined under half of it violated your employer rules, common sense ethical rules, or consciousness of wrongdoing. I don't know what benign means. I don't know what immoral means. I mean, the government says we waived, but they don't tell us what we should have asked for. They never spelled out what that instruction was.
Sorry, please.
Just on that, I thought you did ask for jury instructions that would make clear that an after the action agreement
100%
would require.
JA 18 objects to the definition of corruptly on JA 28 by saying, very clearly laying out the sine qua non of bribery is that quid pro quo payment, and the jury would have to convict if it only found a gratuity. What the government is trying to say is that we should have said something other than the way the government's prosecuted every other 666 case on just a knowing theory, and they've said 6 different ways what that would look like. And if you charge, again, I'm sure you will ask them what the jury should be charged, what common sense ethical rules are. I mean, the restaurant example alone, I don't know where I'm pretty sure Chipotle would be okay, and at Little Washington wouldn't, but ask them about the Cheesecake Factory.
Well, I'm not going to ask them about the Cheesecake Factory. Somebody else may.
Okay.
But I'm going to ask you a little bit more about corruptly.
Okay.
And the mens rea that you think it should import here, putting aside the jury instructions and the debate over forfeiture. You mentioned consciousness of wrongdoing, which the court mentioned also in Arthur Anderson, if I recall. And that suggests, I think, that you have to know that it's unlawful. It's one of those rare statutes where perhaps ignorance of the law is a defense, if you will. What do you think of that?
So, no, that's some other case. Corruptly has a very, very specific definition with bribery. It cannot possibly mean one thing for bribery and something else in this statute. It clearly means quid pro quo. Bribery has always had both common law, historic, 201. Corruptly means quid pro quo in this context. I think when you have Arthur Anderson, official proceedings, document destruction, what have you, corruptly can mean all kinds of things.
It makes no sense what you're saying to me. here's a case in which someone is, that's the allegation, demanding money, gets it basically for no services, spends his time giving 2 or 3 different reasons and services that he performed, which he didn't. And there's a series of meetings or phone calls, texts, etc., before the second contract is awarded between these people. At some point, can't the jury see that as a demand for payment for services? Well, and you're giving no definition that would cover that kind of behavior.
So, first of all,
I think that's different than the situation the chief posited. I find someone's wallet and I tell them, I'm not giving it up to you unless I get a tip.
Yeah, so
I want half the money in the wallet.
It's none of the federal government's business if a local official is doing nothing wrong with state and local laws and complied with all local laws. Most of their brief has nothing to do with their theory. Their brief is somehow there was improper steering by his buddy, who's now the head of sanitation and trash, which is a little bit ironic. But their theory is...
You are suggesting that the federal government can't say there is something wrong with demanding payment after the fact for an official act.
The government has not, Congress has not criminalized gratuity against state, local, and tribal officials.
You are answering my question,
yes, that's not a crime.
It's not a crime.
Not a federal
for
crime.
State officials who run around the country with respect to federal contracts and say, I voted for X, now pay me.
It's not a federal contract, but if there's bribery...
a state contract.
If the government thinks there was a quid pro quo, which they did here, they did allege and try to argue to the jury there was bribery, but you're making it a case where...
No, I'm asking a simple question. It's all right, according to you, or it's wrong for federal law to attempt to take the situation, which is alleged here, that demanding payment for official acts is wrong.
So you keep saying demanding. If he had asked for to please give me my GoFund money for my kid's cancer surgery, I think in your view that's a crime. And I'm saying Congress could not have possibly intended to put that official in 10 years. But that's the problem with your example.
Is the question whether it would be wrong for Congress to criminalize that or whether, in fact, Congress has criminalized it?
Yes, it's the latter.
It's the latter, so, okay.
And why doesn't the language cover? I mean, I understand we're all thinking about this in terms of gratuities, and that opens the door to all of the, relatively benign examples that you bring up, when someone's just sort of showing thanks for doing services. But the statute does not use the word gratuities. In fact, the statute uses terminology that's very similar to what Justice Sotomayor just said, right? Someone who corruptly solicits or demands, and I'm skipping here, anything of value intending to be rewarded. And those are the facts that the government is at least alleging in this case.
And corruptly is completely a foreign concept to gratuity, and it's a very familiar...
No, but I'm not... set aside gratuity. I'm just looking at the statute. Why aren't the facts that the government alleges here fitting entirely with the statement, the text of this statute?
Because the plain language of reward can mean bribes. And it has been used that.
And it can't mean after the fact seeking a payment for something that you've done officially.
Rewarding can plainly mean bribes to officials who aren't actually influenced. You give me money, and either you're never going to take the vote or you couldn't take it anyway. It also applies to after-the-fact payments. And if I can just say one other thing, because you say on reward about corrupt, $1,000 bottle of wine.
No,
$2,000 bottle of wine.
But I guess if the person is demanding it as a result of something that they've done, it would be the same scenario.
It's the same statute that applies to the giver. So you and anyone else in this room who gives an expensive bottle of wine to a nurse in connection with a $5,000 surgery.
Is she demanding it for having done something to me or in my family?
You have to divorce 601, the giver to the taker. I mean, the giver to the taker. That's the exact same wording. It applies to anyone who gives with an intent to reward. That's the plain language. And I think in your view, you'd have to draw a line between the $2 chuck at Trader Joe's and the wine that goes up to $500,000. And I don't know where the government's line is. There is no drop-down menu on Amazon for mens rea. There's just not there are 13 gratuity statutes. None of them are like this. They have no mens rea because they're just prophylactic, bright line rules. You can't get that compensation, which is why that is the federal rule. You get even $1, it is a crime, regardless of mens rea. And there are 11,000 pages of guidance to make sure that when you're a federal employee, you don't go to jail for 2 years. I don't know what every single person.
So what is rewarded doing in this statute? Because basically you've defined it as bribery, and we have intending to be influenced. So what is the work of rewarded?
Two critical things, and the government has a response. It's not a good one on one of them. They have no response to my first point. It takes the issue of timing and causation off the table, and where they don't have a response is on causation. The statute, if it just said intending to be influenced, a jury would have to acquit if the jury found the person wasn't influenced, like a gun, I don't know, take a pro-gun or an anti-gun person who said—
I don't understand that. It says intending to be influenced. It doesn't say you have to actually have been influenced. So,
well,
I mean, isn't a bribery you're intending to be influenced? Okay.
No, if he says I wasn't influenced, I would have taken the vote anyway, the jury would have to acquit. I wasn't influenced. I didn't even intend to be influenced because I told my God, my wife, and my son that I was going to vote that way anyway. I had no intent to be influenced. And on our second one is after the fact. Now, I agree you could stretch the English language, but I
payment for something that you've done officially.
Rewarding can plainly mean bribes to officials who aren't actually influenced. You give me money, and either you're never going to take the vote or you couldn't take it anyway. It also applies to after-the-fact payments. And if I can just say one other thing, because you say on reward about corrupt, $1,000 bottle of wine.
No,
$2,000 bottle of wine.
But I guess if the person is demanding it as a result of something that they've done, it would be the same scenario.
It's the same statute that applies to the giver. So you and anyone else in this room who gives an expensive bottle of wine to a nurse in connection with a $5,000 surgery, they did.
Point. Can't the jury see that as a...
The horribles only apply to gratuity.
Instruction.
No, sorry, please.
Just on that, I thought you did ask for jury instructions that would make clear that an after-the-action agreement
100%
would require acquittal.
JA-18 objects to the definition of corruptly on JA-28 by saying, very clearly laying out the sine qua non of bribery is that quid pro quo payment, and the jury would have to convict if it only found a gratuity. What the government is trying to say is that we should have said something other than the way the government's prosecuted every other 666 case on just a knowing theory, and they've said 6 different ways what that would look like. And if you charge, again, I'm sure you will ask them what the jury should be charged, what common sense ethical rules are. I mean, the restaurant example alone, I don't know where I'm pretty sure Chipotle would be okay, and at Little Washington wouldn't, but ask them about the Cheesecake Factory.
Well, I'm not going to ask them about the Cheesecake Factory. Somebody else may.
Okay.
But I'm going to ask you a little bit more about corruptly.
Okay.
And the mens
Yes.
rea that you think it should import here, putting aside the jury instructions and the debate over forfeiture. You mentioned consciousness of wrongdoing, which the court mentioned also in Arthur Anderson, if I recall. And that suggests, I think, that you have to know that it's unlawful. It's one of those rare statutes where perhaps ignorance of the law is a defense, if you will. What do you think of that?
So, no, that's some other case. Corruptly has a very, very specific definition with bribery. It cannot possibly mean one thing for bribery and something else in this statute. It clearly means quid pro quo. Bribery has always had both common law, historic, 201. Corruptly means quid pro quo in this context. I think when you have Arthur Anderson, official proceedings, document destruction, what have you, corruptly can mean all kinds of things.
It makes no sense what you're saying to me. Here's a case in which someone is, that's the allegation, demanding money, gets it,
These items might be your
basically
best
for no
bet.
services, spends his time giving 2 or 3 different reasons and services that he performed, which he didn't. And
Excellent
there's
choice.
a series of meetings or phone calls, texts, etc., before the second contract is awarded between these people. At some point, can't the jury see that as a demand for payment for services?
Well,
and you're giving no definition that would cover that kind of behavior.
So, first of all,
I think that's different than the situation the chief posited. I find someone's wallet and I tell them, I'm not giving it up to you unless I get a tip.
yeah, so
I want half the money in the wallet.
it's none of the federal government's business if a local official is doing nothing wrong with state and local laws and complied with all local laws. Most of their brief has nothing to do with their theory. Their brief is somehow there was improper steering by his buddy, who's now the head of sanitation and trash, which is a little bit ironic. But their theory is...
You are suggesting that the federal government can't say there is something wrong with demanding payment after the fact for an official act.
The government has not, Congress has not criminalized gratuity against state and local and tribal officials.
You are answering my question, yes or no?
That's not a crime.
It's not a crime.
Not a federal
for
crime.
State officials to run around the country with respect to federal contracts and say, I voted for X, now pay me.
It's not a federal contract, but if there's bribery...
a state contract.
If the government thinks there was a quid pro quo, which they did here, they did allege and try to argue to the jury there was bribery, but you're making it a case where...
No, I'm asking a simple question. It's all right, according to you, or it's wrong for federal law to attempt to take the situation, which is alleged here, that demanding payment for official acts is wrong.
So you keep saying demanding. If he had asked for to please give me my GoFund money for my kid's cancer surgery, I think in your view that's a crime. And I'm saying Congress could not have possibly intended that official in 10 years. But that's the problem with your example.
Is the question whether it would be wrong for Congress to criminalize that or whether, in fact, Congress has criminalized it?
Yes, it's the latter.
It's the latter, so, okay.
And why doesn't the language cover? I mean, I understand we're all thinking about this in terms of gratuities, and that opens the door to all of the, relatively benign examples that you bring up, when someone's just sort of showing thanks for doing services. But the statute does not use the word gratuities. In fact, the statute uses terminology that's very similar to what Justice Sotomayor just said. Right? Someone who corruptly solicits or demands, and I'm skipping here, anything of value intending to be rewarded. And those are the facts that the government is at least alleging in this case.
And corruptly is completely a foreign concept to gratuity, and it's a very familiar...
No, but I'm not... set aside gratuity. I'm just looking at the statute. Why aren't the facts that the government alleges here fitting entirely with the statement, the text of this statute?
Because the plain language of reward can mean bribes. And it has been used.
And it can't mean after the fact seeking a payment for something that you've done officially.
Rewarding can plainly mean bribes to officials who aren't actually influenced. You give me money, and either you're never going to take the vote or you couldn't take it anyway. It also applies to after-the-fact payments. And if I can just say one other thing, because you say on reward about corrupt, $1,000 bottle of wine.
No,
$2,000 bottle of wine.
But I guess if the person is demanding it as a result of something that they've done, it would be the same scenario.
It's the same statute that applies to the giver. So you and anyone else in this room who gives an expensive bottle of wine to a nurse in connection with a $5,000 surgery.
Is she demanding it for having done something to me or in my family?
You have to divorce 601, the giver to the taker. The giver to the taker. That's the exact same wording. It applies to anyone who gives with an intent to reward. That's the plain language. And I think in your view, you'd have to draw a line between the $2 chuck at Trader Joe's and the wine that goes up to $500,000. And I don't know where the government's line is. There is no drop-down menu on Amazon for mens rea. There's just not there are 13 gratuity statutes. None of them are like this. They have no mens rea because they're just prophylactic, bright line rules. You can't get that compensation, which is why that is the federal rule. You get even $1, it is a crime, regardless of mens rea. And there are 11,000 pages of guidance to make sure. I don't know what every single person...
So what is rewarded doing in this statute? Because basically you've defined it as bribery, and we have intending to be influenced. So what is the work of rewarded?
Two critical things, and the government has a response. It's not a good one on one of them. They have no response to my first point. It takes the issue of timing and causation off the table, and where they don't have a response is on causation. The statute, if it just said intending to be influenced, a jury would have to acquit if the jury found the person wasn't influenced, like a gun, I don't know, take a pro-gun or an anti-gun person who said...
I don't understand that. It says intending to be influenced. It doesn't say you have to actually have been influenced, so...
Well...
I mean, isn't a bribery you're intending to be influenced? Okay.
No, if you says I wasn't influenced, I would have taken the vote anyway. The jury would have to acquit. I wasn't influenced. I didn't even intend to be influenced because I told my God, my wife, and my son that I was going to vote that way anyway. I had no intent to be influenced. And on our second one is after the fact. Now, I agree you could stretch the English language, but I just think it refers to more naturally an upfront payment before the vote is an intent to be influenced, and I'll do it, and then after the vote is taken, just more naturally refers to a reward, which is what the Fifth and First Circuit found, was that it totally takes timing off the table. And so corrupt is doing all the work of quid pro quo, and intending to influence and rewarded is doing the work on either the timing of the payment or the way you intend it.
Thank you, counsel. Justice Alito, anything further? Justice Kagan? Justice Gorsuch?
I know we discussed this in Sabri, but I'm just curious your thoughts on, I guess, what Justice Alito framed as the first question. What are the limits to what Congress can do to federalize state substantive criminal law here?
Yeah, so Sabri is definitely in the context of bribery, and so the question would be if the the 1984 version just criminalized gratuities and said because of official act 10-year penalty, and you would have to there you would meet, I think, the spending clause clear statement. And the clear statement under Bass to upset the federal-state balance, and you have a pure Sabri question. I mean, it's tough. I think what the government would say, the only thing they intimated in their brief is that sometimes the gift could be so bad, I don't know, a Ferrari, that it might skew your official decision-making. And the problem with that is they don't have an answer, what about the toy Ferrari? I mean, so they still have the vagueness problem, but I think their argument would be, although it's way less, it's certainly much weaker than bribery. I think their skewing is the way they would get around the sort of, I guess, whatever you call it, spending clause authority or Article I authority. But it was bribery. It was definitely, bribery was at issue with both campaign finance and with the connection with the federal program was clearly a bribery quid pro quo.
And here we have a very different scenario with gratuities. And did Congress really, did it clearly need to displace all state law?
It's clear it's not clear to me. Not when it just looks nothing like any other gratuity statute in history or on the books today.
Thank you.
Justice Kavanaugh?
You've suggested a few times that state and local governments regulate gratuities of state and local officials. Can you give us some more color on that? Is there a disparity? You know, some jurisdictions will say up to $50, others up to $100.
It's infinite. Some of them will say even if you do it, give the gift back. They don't put you in jail for 10 years. I mean, the government, there's an infinite. Here it was not even alleged that Portage and Indiana have extensive ethical rules. There's no allegation that the petitioner did anything in violation of those rules. And although the federal government has its own, every employer has different rules. Even in the banking context, DOJ is supposed to work with the bank and make sure that, it's copacetic. And even then, DOJ says, well, we may second guess the banking rules if we find them unreasonable. But they're supposed to at least work out ahead of time. But there's a lot of cities and there's a lot of states, and I don't think most states even have gratuity laws.
Thank you.
So they're just making something a crime that's not.
Justice Jackson?
Yeah, so if you're right, and there's a distinction between bribes and gratuities in the way that you're positing it, I guess we'd have a statute in which Congress is intending to prohibit an official from going to a company ahead of time and saying, pay me $15,000 and I will steer the garbage truck contracts to your company. But Congress would not have intended to prohibit that same official from steering the garbage truck contracts to the company and after the fact going to them and saying, okay, give me $15,000. And I guess I don't understand how you have a statute that is rationally drawing a distinction between those two scenarios.
Oh, Sun Diamond. Justice Scalia goes on and on and on, like one of his favorite cases ever. He just goes on and on about the big difference between a bribery, that's where you pay the money in exchange, and a gratuity, that the action is taken, it's after the fact. 201 made that distinction. And so the other thing I would say, and you can ask the government's position does not depend on steering. This could have been the best garbage truck contract in the history of the planet, but didn't like the $10,000 or didn't like the type of gift. They say it's okay to give coffee and donuts to the police who work around the clock. Well, what about the police who coerced a confession? Is that corrupt? Same gift, same donut. The government's theory to the jury has nothing to do with the steering. It's just they want to do that to make the client look bad. It is simply you got something of value after the fact because it related to official conduct, which it doesn't depend on any misconduct at all by the official. And again, Sun Diamond is literally all about the difference. And even in Sun Diamond, this court went crazy to make sure federal officials were protected because 2 years was too long for federal officials to go to jail for gratuity.
Thank you, counsel. Ms. Sinsdak?
Mr. Chief Justice, and may it please the court. The federal government needs to ensure the money it appropriates to local governments for public benefits is allocated in a way that maximizes the benefits to its citizens, not the rewards for local officials. Congress therefore enacted Section 666 to bar officials from corruptly accepting payments with the intent to be influenced or rewarded in connection with their official duties. Petitioner asks this court to weaken Section 666's protection for the public fisc by holding that a person does not violate Section 666 when he corruptly solicits a payment with the intent to be rewarded, unless he has also agreed to accept the reward beforehand. But that requirement of a beforehand agreement finds no basis in the statutory text. The plain meaning of reward readily covers a payment given in return for an official action or decision that is already complete. So a police chief who sends his officers to foil a burglary at a store and then demands the store owner pay him $10,000 for his officer's work, he acts with the intent to be rewarded. A safety inspector who issues a building permit for a dangerous project and then solicits a $30,000 payment acts with the intent to be rewarded. And a mayor who steers a contract for a particular business and then asks that business to pay him $13,000 for the contract acts with the intent to be rewarded, whether or not the contractor agreed to give him the reward before the contract closed. Petitioner's argument to the contrary ignores both the plain meaning of the term rewarded and the statutory history. In 1984, Congress enacted a flat bar on the acceptance of bribes and gratuities. It was modeled directly on the one in Section 201C that applies to federal employees. In 1986, Congress narrowed that bar to carve out a subset of only the most culpable gratuities by adding a corruptly mens rea and an express exception for bona fide salary and benefits paid in the ordinary course of business. Now, Congress's textual fix worked. Petitioners haven't pointed to any real-world examples of Section 666 prosecutions for the sort of innocuous gift-giving activity that occurs in the ordinary course of business. And I'm happy to explain why the two examples in their reply brief really just aren't what they're describing. But the court should therefore reject petitioner's invitation to artificially narrow the reach of Section 666. I welcome the court's questions.
Counsel, under your theory, there are two offenses in 666, the gratuity and the bribery. And gratuity is really just a bribery without a quid pro quo, right?
So first of all, there's a single offense, corruptly accepting a payment, and then there are two means of committing that offense, either intending to be influenced or intending to be rewarded. So it's one offense, the corrupt acceptance, and then two different means. And you're right, they overlap a lot of times when you're accepting a payment.
Well, I don't know if they overlap. It seems one is a lesser included offense than the other, right? Gratuity. Why isn't the bribery thing just surplusage? You just show a gratuity, and as I said, it's just kind of bribery without the quid pro quo. That's all you need to show.
No, there are going to be situations where somebody is going to accept a payment intending to be influenced without intending to be rewarded. So that's going to happen when somebody accepts a bribe and says, yes, this $10,000, it's going to influence me in making this decision, but I haven't made up my mind yet. And maybe they turn to someone else and say, hey, somebody else gave me $10,000 to influence me. Sure, $20,000 might push me in another direction. At that point, the person gets $20,000 and does what the second person wanted. Now, in the second situation, I think that is somebody who's both intending to be influenced and intending to be rewarded, because they're going to do something for that $20,000. But in the first situation, there is nothing to be rewarded. So they are intending to be influenced, but they haven't made a decision. They haven't taken an act, so they aren't intending to be rewarded.
But no, that's a strange hypothetical, right? It doesn't really happen in the real world.
I'm not sure that's...
I guess what I'm suggesting is that you have to work pretty darn hard to get out of the problem that the Chief Justice suggested.
No, I don't think so for two reasons. First of all, I don't think it's so far-fetched to imagine a mayor who says I'm taking bids on the contract, and hey, it sure would help if you put a payment, you offered me something too, and then I think you are going to have a few different payments happening with the intent to be influenced but not rewarded. But the second point is that I think this lesser included offense comes from the relationship between 201B, which covers bribery for federal officials, and 201C, which covers gratuities. And the 201C offense is a broader offense. It's the for because of language. There's no corruptly mens rea. There's no express exception for bona fide salary and compensation. So there, I think it actually can be described as a lesser included offense. But here, it's not that all gratuities are covered within the rewarded, because, of course, the other restrictions within Section 666 still apply. So it has to be accepted corruptly, and we have the exception for...
Keep going, sorry.
Oh, no, I was just going to say the exception for bona fide salary.
Well, I think the problem you have is what does corruptly mean?
So I think Arthur Anderson described corruptly. It said it has to be corrupt, so that means wrongful or evil or immoral. And
so does a $100 Starbucks gift certificate as a thank you to the city council person for working on a new zoning reg, is that corrupt or not?
So, no, and let me tell you exactly why. I think that
How about a $500 one?
So I think it would be helpful to set out what the guidelines are going to be here, because when there's a corruptly mens rea, what you usually see in the jury instructions, sometimes it says consciousness of wrongdoing, so you have to know that what you're doing is wrong. But sometimes what the jury instructions do is isolate what is actually wrongful, what is obviously wrongful about this conduct. So I think when we're talking about corruptly in connection with rewards, you have to isolate what's wrongful. And what's wrongful is when it appears that the government is for sale. What's wrongful, so here are three...
Well, you're changing the hypothetical. The hypothetical is the actions taken, and a citizen gives a thank you. And it could be a gift card to Starbucks, or it could be tickets to a concert or game, and just drops it off to the person. Thank you for all your hard work on this issue. Appreciate you.
So I do not want to get away from corruptly. I also want to point out that, of course, there's other limitations within the statute. So if the business or transaction that's being rewarded isn't worth at least $5,000,
I understand that.
Assume that. Okay, I just want to make sure, because I do think, for example, in Sundiamond, Justice Scalia said that requiring this connection with a particular act is going to eliminate innocuous gift giving for federal officials.
But you can't. I'm going to press on this. What is innocuous and what is not, and just as important, how is the official supposed to know ahead of time, oh, the $100 gift certificate's okay, but the larger one's not, or the set of books, or the framed photo?
So again, I think there are three circumstances where the official is going to know that what he's doing is obviously wrongful. The first one is where he took the public act with the intent to be rewarded.
Assume that's collapsing two different things. The council, you're collapsing two different things.
That's not my hypothetical. Yeah. My hypothetical is the official knew nothing about the potential for the gratuity after the fact.
So that's going to make it harder for the government to prove corruptly. But there are two other circumstances.
Why?
Because corrupt corruptly has to get at what's obviously wrongful in the statute, which is where you are performing public acts for private gain.
Counsel, I'm
So if
sorry
that's-
to interrupt, but I am going to interrupt there because I think the questions and the ones I'm interested in have to do with mens rea on corruptly, and I think that's what Justice Kavanaugh's getting at. So put aside the actus reus for a moment. You say corruptly carries with it some mens rea.
Absolutely.
What is it?
Consciousness of wrongdoing.
So you think the defendant has to know that what he's doing is unlawful?
Or wrongful. He doesn't have to know about the specific. Well, he does not.
Wrongful.
Or wrongful, inherently.
Where does that come from?
That comes from Arthur Anderson.
But a consciousness of wrongdoing usually means that I know. I mean, wrongdoing is defined by law usually, right? But you're saying no. It doesn't. He doesn't have to know that it's unlawful. He has to know that it is unlawful or fill in the blank.
Wrongful. And I think sometimes actually, so unlawful is usually, you're right, going to get you there. And here I think we have someone who did everything he could to hide that he was getting this money and said that it was a consulting fee. So you have a lot of evidence.
How do you know it's wrongful if it's perfectly legal?
Well, so it isn't. It was not.
I mean, is it a sin? Are we now talking about something that something that would be a venal sin, or does it have to be a mortal one?
I want to ground us in the facts of this case, so I think it's important here to establish that the Indiana Code actually bars giving a gratuity to a public official. The Indiana.
I'm not asking about Indiana. Okay. I'm asking about what the government's position is on corruptly and mens rea, and you say it has to be unlawful or wrongful. And wrongful in what sense?
So, again, I think what we're talking about here is wrongful in the sense that Arthur Anderson said evil, corrupt, immoral. And sometimes that's...
Immoral.
That is what this court said in Arthur.
So a gift of pornography, as your counsel friend on the other side pointed out in her opening, would that count in the government's view?
It needs to be wrongful in the way that the statute is targeting. So here again, what the statute is targeting, the obviously wrongful conduct that the statute is targeting is taking public acts for private gain. So where, again, and I'm just going to give you the three circumstances.
That defeats your whole theory. I'm sorry, because if the public act was done, completed, we're done with the new zoning reg, we're done with the new school board decision, and then the gratuity, the gift, the thank you arrives, you're still going to prosecute those cases as corrupt under your theory of what corruptly means, correct?
Where one of three circumstances
so that
is met.
means where you haven't taken the public action for private gain.
No, I think that's where the problem is coming in. So here, for example, imagine that the official just knows that the Buha brothers, they pay big rewards to people who give them contracts. So what he decides to do is award the contract to the Buha brothers. Afterwards, he's going to ask for the payment. That is corrupt.
The facts of this case are great in that sense for you to respond to the question, but there are 19 million employees who are going to wonder about the thank yous.
For all of those employees, the government is going to have to prove corruption. So if they can't prove that the person actually did, and let me get out the other two because there are two others.
I will.
So if they can't prove that the person actually took the act intending to be rewarded, which gives you corruptly, they can also sometimes prove that by taking this payment, let's say it's $100,000 for having won a case, in the future, the person is going to be trying to win cases to get the money rather than for in the interests of the public. And then there's also going to be, with certain payments, it's just going to be clear that if the public official takes this, it's going to look like the government is for sale. And
well,
that's
every
because
time. Does this provision apply to campaign contributions?
Section 666 applies to campaign contributions. Under McCormick, there needs to be a quid pro quo in the campaign context. So, in the campaign contribution context. So the government does not prosecute where.
So where do you get? How does that fit into the statutory language?
So what we've taken it is there would be an as-applied constitutional objection if we were trying to prosecute a campaign contributions on a bona fide campaign contributions on a pure gratuities theory. And sorry, if I could just get back again.
Well, how about this? I mean, this statute applies to more than government officials. It applies to pretty much every hospital. It applies to pretty much every university. So let's say a billionaire patient comes to a hospital and gets extra special treatments. He gets appointments when nobody else would get it. He gets surgery scheduled when nobody else would. And it's all done because everybody knows he's a billionaire patient, and they're hoping that he'll give an 8-figure gift to the hospital. How about that? Does that fit?
So it needs to be, you walk through the statutory requirements. There needs to be the acceptance or the solicitation of money in connection with particular business
Well,
transactions.
they're definitely going to accept the 8-figure gift when it comes.
Oh, sorry. Are you talking about they're on the promise of this 8-figure gift?
No, I'm just saying they treat him really super nicely because they're very hopeful and that he's going to recompense them for all the special consideration that they've given. Does that fit or does it not fit?
So the government is going to have to prove that accepting that reward would be corrupt and that the hospital understands
a lot of people do not think it's good to give super rich people better health care than not so super rich people. So I could see a jury saying that's pretty immoral, but probably every hospital in America does it.
Well, the hospital has to have consciousness of wrongdoing, so it's what the hospital thinks that matters there, right? The hospital has to understand that in accepting that money, they are committing wrongdoing. And so...
Well, but there's a jury that's going to decide whether they're committing wrongdoing or not. And a jury might say that sounds pretty corrupt. And all I'm suggesting is that given that this statute applies not just to government officials, but to pretty much like every important institution in America, I mean, that seems quite extraordinary that when you do stuff, hoping, thinking it might earn you a big gift, even if it's just for the institution, not to put in your own pocket, that would land you 10 years in prison?
Let me respond to that in two ways. First of all, under Section 201C, the federal government officials are undisputedly bound by these sorts of requirements with no corruptly mens rea. And in Sun Diamond, this court said that requiring a tight connection between the reward and specific official acts, or here you would say specific business or transactions worth more than $5,000, that was going to eliminate many of these cases. And I don't think that we haven't, again, petitioner isn't here pointing to a mountain of cases where this has gone horribly astray. So Section 201C does it for government officials without the corruptly. I'd also note, and I think you were pointing this out earlier with in the colloquy with petitioner, that it's not going to get us out of this problem to just graft on a atextual beforehand agreement, because all that has to happen is that rich patient says to the doctors and nurses, hey, if you treat me well, there's going to be a nice big gift for the hospital at the end, and then the beforehand agreement requirement just isn't going to do anything.
Counsel,
so
you said the friend on the other side hasn't pointed to a lot of examples in the real world, but we've had several cases where we've made the very clear point that we don't rely on the good faith of the prosecutors in deciding cases like this.
That's right. And in 1986, neither did Congress with respect to local and public officials. That's why it added the corruptly mens rea, which has to be proved to a jury. And that's why Congress added an express exception for bona fide salary, for compensation in the ordinary course of business. So Congress really did confront all of the concerns that I think the court is reflecting today, and it said we recognize we do not want to just cover innocuous gift activity.
What is your answer to Justice Kagan's hypothetical? That's a question that would be submitted to the jury, and the jury would have to decide whether the donor acted wrongfully and the hospital acted wrongfully, right?
They would have to prove that the hospital understood that it was wrongful to accept that payment. Now, again, that's going to be the case if the donor, under petitioner's theory, that's the case if the donor is telling the hospital when he goes in for the surgery.
No, don't turn it into a bribe. It's a gratuity. It's after the fact. There's no agreement.
Well, no.
But so it would be whether the hospital knew that it was wrongful.
So,
yes, suppose there were internal emails, and one official says, we really shouldn't be giving such special treatment to billionaires, and another email says, get real, we need money, and et cetera, et cetera.
At the end of the day, Congress is entitled to draw the statutes and to make the bars the way it wants to. The reason, though, that I was pushing back and giving you the bribery hypothetical is that I really do think that what I'm hearing today is there are some payments that just aren't, or some gifts that just aren't corrupt. And that's going to be true whether you're pursuing a bribery prosecution.
Counsel, how does anyone in the real world know the line? Put aside billionaires and hospitals. Deal with small gifts with the teachers, doctors, police officers all the time. And one could make an argument, if consciousness of wrongdoing doesn't mean consciousness of illegality, awareness of illegality, if it means something more abstract than that, how does this statute give fair notice to anyone in the world as to, and I hate to do it, but I'm going to, the difference between the cheese factory and in a little wash. Thank you. How does anyone know?
Again, Justice Gorsuch, I do not mean to suggest that if you are aware that you are violating the law, that's not going to establish consciousness of wrongdoing.
No. Counsel, put that aside. You've rejected that as the definition of consciousness of wrongdoing. You say it includes consciousness of either illegality, which I would have thought might mean wrongdoing, but I'm wrong. It can mean something more than that. It can mean a venial sin. It can mean a mortal sin. How does somebody who accepts the Cheesecake Factory know a trip to the Cheesecake Factory for nice treatment at the hospital, for treating my child well in school, for an arrest made? How does that person know whether that falls on what you call the wrongfulness side of the equation or not?
Well, certainly they can look at ethical guidance and guidelines. As
how about looking at state law, Counsel? How about looking at state law?
They could do that as well.
And let's say it's all legal under state law.
If it's all legal under state law, the government is not going to be able to prove consciousness of wrongdoing. I think
why not? Why not? We're going to have, Counsel, please.
Sure.
We're going to have internal emails, just like Justice Alito posited. Some people say, I wouldn't go to the Cheesecake Factory. That would look bad. Or maybe you should go to the Cheesecake Factory, but not Little Washington. Well, a lot of nice places to me. But you're going to have evidence, and you can prove it. And a jury might well convict.
Sure, and that's why the act also has to be wrongful. This is actually a protection, Justice Gorsuch, so I think that maybe we're talking a little bit at cross purposes, because what I'm trying to say here is that the government has to show that it's wrongful and the person's aware that it's wrongful. So if it's lawful under state law, then the defendant is going to be able to come in and say, no, look, this is lawful under state law. So it wasn't wrongful. The state obviously didn't think it was wrongful. And by the way,
is that an automatic rule? Is that an automatic rule? Is that a safe harbor? If it's lawful under state law or local law, then you cannot be federally prosecuted for the gratuity under the statute.
If it's lawful under the governing rules that apply to the person.
In other words, it's not made unlawful. If it's not made unlawful by the relevant state law or local law, is that an automatic safe harbor such that the federal government cannot prosecute under this statute?
Yes, but I have to, just for the sake of the public integrity unit, say that if a city mayor decided to change all the ethics rules to allow him to take billions of dollars in connection with contracting, then I don't think he could get it in. But otherwise, yes, we're not. So again, this is what I'm trying to say. The consciousness of wrongdoing isn't a trap for the unwary. It's to help the unwary.
A little town has no rules about gratuity, so you can't prosecute anybody in that town under 666.
No. So first of all, there would be state rules. Absolutely. There's going to be state rules. I took...
All right, there's no applicables. The state has left the regulation of gratuities to municipalities. And a particular town has got 3,000 people, 2,000 people, 1,000 people. It has no rules about the gratuities that police officers can accept.
Look, if the police officer can come forward and say, I just had no idea this was wrongful because there were no applicable rules, there was no applicable state law, then the government isn't going to be able to prove consciousness of wrongdoing.
The question was whether that's an automatic rule. And first you said it was, and now an automatic safe harbor. Now I think you're saying it's not.
No, I disagree. Let me distinguish between two things. One is a case where there are ethics rules that say this is permissible, okay? If there are ethics rules that say this is permissible, if there are state laws that say this kind of gratuity is permissible, that is a safe harbor. Other than...
I changed the language of the question then to say also, what if it's just, to Justice Alito's point, not made unlawful?
I see. Okay, so I think there...
What's the answer there? Is that a safe harbor?
It's not necessarily a safe harbor if it's obviously wrongful conduct, but I will say it's...
What is obviously wrongful?
So,
yes.
isn't counsel...
What's the jury instruction? Maybe this is what I said. What is the exact wording of the jury instruction on corruptly in your view?
So I think there's two different options. One is to isolate what is obviously wrongful in the particular case. That's what happened here, right? So in this case, and I think this is a helpful way of seeing how it played out, petitioner was not saying, I didn't know it was wrongful to take a $13,000 payment. What petitioner was saying is, I wasn't taking a $13,000 reward. I was actually taking consulting fees. So the jury instructions here said what the jury has to find is that the petitioner understood that this was a reward. So that's what separated the wrongful from the innocent conduct. So that's one way of doing jury instructions, to look at a particular case and just say, okay, what would make accepting $8 million for a hospital patient?
Well, I don't think that gets you very far from the things what people have been talking about. Understood that this was a reward. I mean, they understand that the plate of cookies or whatever is a reward, but that doesn't mean that they should be facing the criminal exposure we're talking about.
Yes, pardon me. And we're not saying that if the government was somehow prosecuting a plate of cookies, this instruction would be sufficient. What I'm saying is that in most cases, there's actually no dispute about whether it would be wrongful to accept thousands of dollars in return for having done some official act. The dispute is about, was it a reward for doing that specific official act, or was it something else entirely?
You say that it doesn't. That the government's not going to go after you for the plate of cookies. But I mean, Al Capone went to jail for tax fraud, right? Not for killing however many people. And you were careful to make sure you weren't stepping on the toes of the Public Integrity Unit. But I expect they have a different perspective on a lot of these things than others might.
No, in terms of whether the reward needs...
Whether they can go after something that other people might regard as really sort of normal type of say gratuity, whether it's a Christmas gift for the trash collectors or something like that.
No, I disagree, and they certainly couldn't in the Seventh Circuit. If you look at 41A, the Seventh Circuit said that accepting something corruptly is knowing that it's forbidden. So this is counsel in the Seventh Circuit.
Isn't that really the answer to Justice Kagan's hypothetical that sort of got us down this road? In other words, to the extent that we have an ordinary practice of, unfortunate as it may be, high-profile, special, people, billionaires who come to hospitals, and it's sort of understood generally that the development office is going to be notified, and afterwards that person might, in fact, be asked to give a donation to the hospital that treated him so well, etc. That's sort of standard practice. So in a situation like that, I would think the government's position is that is not wrongful from the standpoint of corruption. We could not prove consciousness of wrongdoing related to anybody who's doing that sort of thing precisely because it's standard practice. But when you have a situation like this one, where it's not standard practice for a garbage contract to be given to a particular company and then the company that received that contract to pay out money, $13,000 for the officials who were involved. That doesn't happen very often. And so when we're in that world, then perhaps we do have a dispute about whether or not there was wrongful behavior, consciousness of wrongdoing, etc. But that's what separates all these other standard practice, the cookies, the gift cards, the whatever. That's normal practice.
Unless it's a corrupt, what if it's a corrupt, like, sorry to pick, in Illinois or Chicago, but what if you're talking about some sort of local unit or a corrupt hospital where that actually is kind of corrupt practice that everyone would agree would be wrongdoing, not the donation to the hospital. Talk about something that's more unsavory. Maybe these rewards are just kind of accepted in this small town, and you can't use that guideline then that Justice Jackson is talking about what's standard, because graft could be standard or gratuities could be standard even in unsavory cases.
So the government has the burden of proof. They need to prove that somebody acted corruptly with consciousness of wrongdoing. I certainly agree with Justice Jackson that if a person knows that this kind of behavior is happening all the time, that's the evidence they're going to put in to make it very difficult for the government to meet their burden of proof. I take your point that the government might say, well, this is an obviously corrupt hospital. Here's all the other evidence of that.
Counsel, my head is spinning.
Yes.
I see the questions before us as twofold.
Yes.
Does the language of this 201C include a gratuity? It's very hard for me to think otherwise because the language is pretty clear. So if it's clear that it includes gratuity, a lot of these questions have to do with what kind of gratuity. And that's where I think my colleagues are focused on what does the word corruptly mean. And you are fighting their suggestion that if you limit it to accepting rewards that are unlawful, I think Justice Gorsuch said unlawful defined how. He would say under state law. I think. I don't want to be putting words into his mouth, but I think he would say unlawful by state law. But you want to broaden it. You want to say by ethical rules. But assume we put that aside. Can you live with, yes, it includes gratuities, but only if you define corruptly as being unlawful? The way that Anderson suggested it went a little more broadly.
With the understanding of unlawfulness, yes, absolutely. And let me answer that directly. Let me also say that I take your point. Rewarded, I think the reason we're talking about corruptly is because rewarded just very clearly does cover after-the-fact payments. There is no beforehand agreement requirement. And I think that to the extent there's a dispute about exactly how you would define corruptly, that isn't before the court because they did not object to the definition
I understand it's not before the court, but it really is. Because if it's not defined that way, I think there's a sense of then gratuity has no meaning. That anyone that could, it would be so vague that it would be impossible.
It would just be the provision that applies to federal officials in Section 201C, which doesn't have the corruptly mentioned.
Yes,
that's right.
Obviously.
Thank you, counsel. Justice Alito?
Well, I'm not sure I understood your most recent colloquy with Justice Sotomayor. You said that it would be that corruptly should or could reasonably be interpreted to mean unlawful under state law. Is that what you said?
I think she asked whether we could live with a definition, and I said that understanding that it was unlawful is a definition I think that certainly would be preferable to carving out gratuities from the statute altogether.
So if something is not unlawful under state or corrupt,
that sense of if it's not really is. I understand it's not before the court, but it really is because if it's not defined that way, I think there's a sense of then gratuity has no meaning. That anyone that could, it would be so vague that it would be impossible.
It would just be the provision that applies to federal officials in Section 201C, which doesn't have the corruptly mentioned.
Yes,
that's right.
Obviously.
Thank you, counsel. Justice Alito?
Well, I'm not sure I understood your most recent colloquy with Justice Sotomayor. You said that it would be that corruptly should or could reasonably be interpreted to mean unlawful under state law? Is that what you said?
I think she asked whether we could live with a definition, and I said that understanding that it was unlawful is a definition I think that certainly would be preferable to carving out gratuities from the statute altogether.
So if something is not unlawful under state law, then it cannot be prosecuted as a gratuity under 666?
If the person needs to understand that what they're doing is wrongful. I mean, this is why we do think
it's really a simple, counsel, really, it's a simple question.
Okay, let me just be clear.
It's a yes or no question.
I
just want to understand your position.
Yes, absolutely. I can live with, as I said to Justice Sotomayor, that narrow definition. I do not think it is correct. So that's the distinction that I am trying to draw. But if the court is intent on saying, we have this statute that Congress wrote that says you can't accept a payment intending to be rewarded, but it has to be corrupt. If the court thinks that what Congress wrote is not good enough, it's not protective enough of city officials, and we need to graft a limit on, I would certainly rather you graft on a limit that is still going to catch people who are, like petitioner, taking large sums of money after they awarded a contract with every intent to get that large sums of money. I would certainly rather you leave some room for that as opposed to carving it out entirely.
Okay, and just to summarize so I understand where you are, you think that corruptly means immoral or wrongful, and it requires knowing the person must know that what is being done is immoral or wrongful.
Know that it's forbidden. Again, to be honest, I'm quoting Arthur Anderson, so I think if you're looking for my definition of corruptly.
Just tell me
sure.
what the
So
definition.
what Arthur Anderson said is that corrupt needs to be wrongful, evil, immoral, and a consciousness of wrongdoing. So that's it. That's what we're looking at.
Okay, and where would one look to find the rules of wrongfulness and immorality that would be applied in that situation?
Well, again, I think that the criminal laws are a great place to look. So where the conduct is obviously unlawful, you can also look at ethical codes and regulations if you're not sure whether something is obviously wrongful. None of this was litigated in this case because, again, there was no dispute that accepting a $13,000 payment for having granted a contract was wrongful.
I think we understand that, but we didn't really take this case just to decide whether this particular case was correctly decided. We took it to explore the meaning of this provision. Was the jury instruction here on corruptly correct?
It was in the circumstances of this case because there was no dispute about whether accepting a reward was wrongful. But Justice Alito, Justice Alito, that is precisely what I'm trying to say. You do have to look at the circumstances because you have to isolate what was wrongful. And here there was no dispute that taking $13,000 as a payment for having granted a contract was wrongful. That's why petitioner didn't object to the jury instruction.
Is this the standard instruction that the government has requested in 666 gratuity cases?
In the Seventh Circuit, this comes from the model jury instructions. I would say that in the prosecutions that I have seen, there just hasn't really been room to argue that the acceptance of the payment wasn't wrongful because what the government has been prosecuting is taking money and then doing everything that you can to cover up the fact that you took the money as a reward. And there, it's pretty easy to show consciousness of wrongdoing, right? I think what you're all talking about is these fringe cases where, it's not really clear because the person actually took it openly and notoriously. That's going to make it really hard for the government to show consciousness of wrongdoing.
If we looked at the jury instructions in 666 gratuity cases, what would we find on the question of corruptly?
So
what would the jury be told? Here, what the jury was told is, am I right? Page 28 of the joint appendix, a person acts corruptly when he acts with the understanding that something of value is to be offered or given to reward or influence. So as to gratuity, to reward in connection with his official duties. I mean, all it has to be, the person has to know is that this is a reward. It doesn't have to be immoral, wrongful, or anything else.
Again, that's in the circumstances of this case, There was no dispute. So
I
take
understand that. I understand that. I don't want to talk about the circumstances of this case. I want to talk about what the law means and what the government's position has been on the issue of corruptly in other cases. Is this standard, or if we look at the others outside of the Seventh Circuit, the corruptly is defined as immoral or wrongful?
So the Second Circuit, I believe, has instructions that ask about a wrongful purpose. And of course, if the defendant thinks, look, I didn't know that taking this reward was wrong, then he can ask for an instruction saying, asking the jury to decide whether he understood that taking the reward was wrong. So there can be that express request. And this is just, I'm just sort of taking a page from Arthur Anderson on all of this. Corruptly is, I admit, a relatively unique mens rea, but it's one with a rich historical pedigree. So it's not that the government is making up some new limit. It's not that Congress in 1986, when it was trying to eliminate innocuous gratuities, was doing something wild and crazy by saying, we're going to use the corruptly mens rea because that is going to make sure that when people don't understand that what they're doing is wrongful, that when they're engaged in what everyone would reasonably think, or at least, that what somebody would reasonably think was just innocuous conduct, then they're not going to be prosecutable because the government just isn't going to be able to show that that was corruptly.
Counsel.
I'm sorry. It's done.
Well, I am concerned about the breadth of your interpretation, and it all seems to rest on the understanding of corruptly. The person who gives a reward simply because that person is grateful may not know what the ethics rules are with respect to the recipient of this reward. So is that a defense?
Certainly that person could ask for a jury instruction saying there needs to be consciousness of wrongdoing, so they need to have understood that what they were doing was wrongful. These are sort of obscure ethics rules. They didn't, the person could say, I didn't know about them. These are obscure ethics rules. How would anybody know, $25, $50? And yes, then they're entitled to a jury instruction saying, no, there had to be a consciousness of wrongdoing.
I mean, we could think of lots of different hypotheticals, and there are a lot in the briefs, and a lot have occurred. I'll just give you one more, and then I'll stop. So, the owner of a car dealership gets money as a result of COVID, enough money to qualify, and the owner is thankful to a firefighter for saving the life of his daughter, and so when that firefighter comes in his car breaks down and wants a new car. At that time, people are lined up. The cars are in short supply, and the dealer says, "Okay, well, you know what? For you, I'll put you at the top of the list." Is that a violation?
If he does not have a consciousness of wrongdoing, if he does not understand that what he is doing is wrong, I don't think the government. No, there's not going to be a conviction for that. Again, the corrupt...
There's not going to be a conviction because the jury is going to be sympathetic to this felon.
No, because it's not going to fulfill the corruptly mens rea. Again, I want to be clear because I think we keep losing sight of this. Section 201C bars for federal officials just accepting gratuities, and it has no corruptly mens rea. The corruptly mens rea is a break. It's a break that Congress put in as an extra help to make sure that people who are bound by Section 666 aren't going to be prosecuted for all of this innocuous conduct. So I think this idea that by putting in something to protect an extra protection for Section 666, people covered by Section 666, you could somehow render all the coverage of gratuities totally vague and unclear. I mean, that just can't be right.
Thank you, Counsel. Justice Sotomayor?
Counsel, you answered Justice Alito by saying the instruction here was correct. But I'm reading the Seventh Circuit opinion at page 580, and the court is talking about that it's recognizing the disparate penalties for gratuities between federal and state officers, and the difference is mitigated, this is the court's words, by the additional requirement in Section 666 that the reward be paid or received corruptly, and it defined corruptly, i.e. with the knowledge that giving or receiving the reward is forbidden.
That's right.
All right? But that wasn't part of the charge here.
At 41A, no, because again, the petitioner was not
So the charge wasn't correct. It just was not any error was not preserved.
I mean, that's an issue that could be dealt with on remand. But what I would
understand. Just answer my question.
Yes, I am.
All right, now stop. Okay. Assuming.
Okay.
Just answer my question.
Yeah. I mean, that's an issue that could be dealt with on remand. But what I would.
I understand. Just answer my question.
Yes, I am.
All right, now stop. Okay.
Okay.
Assume my question.
Yes, I am.
All right, now stop. Okay.
Okay.
Assuming. So the charge wasn't correct. It just was not. Any error was not preserved.
I mean, that's an issue that could be dealt with on remand. But what I would.
I understand. Just answer my question.
Yes, I am.
All right, now stop. Okay. I.e., with the knowledge that giving or receiving the reward is forbidden.
That's right.
All right, but that wasn't part of the charge here.
At 41A, no, because again, the petitioner was not.
So the charge wasn't correct. It just was not. Any error was not preserved.
I mean, that's an issue that could be dealt with on remand. But what I would.
I understand. Just answer my question.
Yes, I am.
All right, now stop. Okay. Assuming. If you go back below, if we say that, I'm not saying we're going to say it, that it doesn't cover, that 666 doesn't cover any kind of gratuity, what happens? Is this a reversal or a vacate and remand?
It's a vacate and remand because the government was pursuing a bribery theory.
As well. And so it was, we don't know what the acquittal went to, whether it went to the bribery or to the reward.
Pardon me, it's a single offense, the corrupt acceptance offense, that can be committed through intending to be influenced or rewarded. Now, the district court actually found that there was sufficient evidence to convict purely on the quid pro quo.
I remember that,
yeah.
yes. Okay. So, and if I don't disagree with that, then is there a retrial?
No, we think that there would be because the evidence was sufficient to convict on the bribery.
That was.
But again, that's
all right. Thank you, counsel.
Justice Kagan?
I think I've got your view of corruptly, but if you put that aside, are there any safe harbors in this statute? And just like if you would list for me the safe harbors that the government thinks exists either on the face of this statute or in the way you're prosecuting this statute, just give me a list.
Sure. So the safe harbors that come from the text. So this isn't a sort of trust us argument. It has to be in connection with business or transactions worth $5,000. Right. That's the sun diamond. There has to be the nexus. That's going to kick out a whole bunch of innocuous conduct, more even than
just list them.
Just list them. Okay. So the corruptly mens rea, the nexus requirement, the $5,000 floor, and the express exception for bona fide salary and compensation in the ordinary course of business.
Anything else?
That's all. Oh, well, and pardon me, and then the First Amendment protection that says that under McCormick, we understand that to mean that there really has to be an express quid pro quo when we're dealing with a bona fide campaign contribution.
Nothing else that the government can say. We realize that this doesn't appear on the text of in the text of the statute on, like you just read it, but we never prosecute X, Y, or Z.
I mean, you've told me to sort of set aside corruptly, and
yes,
I think that's where a lot of that comes in. But, for example, the government does not prosecute pure charitable contributions. Sometimes charitable contributions are used as a funnel, so it's just sort of like you pay into the charity and then that goes right into the person's pocket. But the government doesn't prosecute these just a pure charitable contribution. If you actually look at the facts of the cases that they're citing, I think one of them is from the local 150. That's the Doniger prosecution. There's actually thousands and thousands of dollars of payments of all different kinds. That's actually on Westlaw. You can look at the facts. They're quite dramatic. So that's not just pure charitable contributions. Similarly, I think they refer to a building inspector case. In that case, somebody was the building inspector was giving permits and then getting, again, large amounts of money from developers, having given them that permit. So I think we had $240,000 loan, $30,000 the person just got to keep scot-free. So I guess I'm kind of trying to give you a picture of the sort of prosecutions, which I guess I'm not kind of including in here the kind of apple for teacher and the the hypotheticals that you see in petitioner's brief. They're just not even on the radar of the government. So I think those are just what we're looking for is, again, corrupt acceptance of a payment with the intent to be rewarded in connection with business or transactions worth at least $5,000. And when we're talking about all these hypotheticals, they just, in the government's view, I think in any court's view, in any jury's view, they just don't fall into that.
Okay, thank you.
Justice Gorsuch.
Counsel, you, in your brief, make the point that we have to interpret rewarded your way rather than your friend's way because otherwise we're going to have a superfluity problem. In a case we're going to hear in a couple of days, the government makes the opposite argument. It says that, I think it says, overlap is not uncommon in criminal statutes. And therefore, superfluity doesn't come into play. Which is it?
So I think that certainly sometimes there is superfluity in a statute. There's belt and suspenders. The reason not here, Justice.
Why does it matter here, but it doesn't 2 days from now?
So the reason that it matters in this case, and I can't, of course, speak for other cases, but the reason it matters in this case is that, well, because I'm here about this case. So the reason is
you represent the government of the United States, which I would hope would take consistent positions across cases.
And we have,
so,
counsel, you why we are.
Thank you.
So Congress added the term intended to be influenced or rewarded in 1986. So they're adding the rewarded to what would otherwise have been language closely tracking Section 201B. They clearly were trying to add something to cover more, to cover additional material. So there, when we have Section 201B, which would be the example of what you would do if you wanted to cover only the type of quid pro quo bribery that petitioner is talking about, they had that, but they didn't just take 201B and plop it into Section 666.
I got it.
Instead, they
Counsel,
added
I got it. Okay. And earlier this term, the government argued that it would defy common sense for Congress not to have required more serious sentences for more serious crimes, Pulsifer. And that argument prevailed. Here, you're suggesting that it makes sense for the more serious offense of bribery and the lesser offense of receiving a gratuity to receive the same punishment. Can you reconcile that one for me?
Of course, the government looks first to the text, and we know that the text here says that the 10-year penalty. It did in 1984 when petitioner acknowledges that it undisputedly covered gratuities. But I can give you a historical reason why I think we have that. The 2 years under 1962 and the
that wasn't my question. Is why would both bribery and receipt of a gratuity have the same 10-year sentence here? And we should ignore that. But we were supposed to take cognizance of that kind of issue just last month.
Because Section 666 was enacted as part of the 1984 Crime Control Act, which also enacted the sentencing guidelines. And so Congress was moving from a situation where, as it had in 201, it was specifying specific sentences for specific for specific types of breaking of a law. So there's 201B, it had the 2-year maximum for that. In 1984, Congress is doing sentencing guidelines, so it's saying we're going to have a maximum, but we're not going to worry about that because we're going to have mandatory guidelines that are going to take care of this. And then, in fact, if you look, Section 666 is listed.
Well, the mandatory guidelines argument was the same point that was made in Pulsifer, and you said that wasn't enough there.
So just to finish my point, if you look at the guidelines, there is a gratuity guideline that applies to Section 666. There is a bribery guideline that applies to Section 666. Under the gratuity guidelines, people are not getting more than 2-year sentences, and petitioner hasn't appointed to any where that has happened.
Okay, last one, and this is circling back to Justice Kagan. Again, put aside the question about corruptly. It seems to me that the major safeguard that you pointed to in that discussion was the $5,000 threshold. Is that right? The $10,000 threshold and the $5,000 threshold.
I think the bona fide salary exception is pretty important.
Okay, got that. Okay. With respect to those thresholds, the government seems to have argued that they're satisfied pretty easily in connection with business of an organization. Governments argue that we can take account of the salary of police officers, which are obviously more than $5,000. So because the police department receives $10,000 and the police officer makes more than $5,000, any gift of any value would seem to qualify. What am I missing there?
No, that's not quite right. So I think you're talking about the case in which there was a drug dealer who was giving, I think,
No, I'm not talking.
I mean, that is the case.
That's the case where the Seventh Circuit said that $5,000 was satisfied by the police officer's salary. That's true.
And the reason was because they were counting up how many salary hours the police officers would have spent, and they were evaluating that. So it wasn't just kind of like a police officer makes more than $5,000.
So anytime an employee at a hospital does more than $5,000 worth of work on behalf of a patient, or a teacher spends more than $5,000 worth of time with a student, then that threshold would be satisfied in the government's view.
Where the specific transaction and business is worth more than $5,000, yes.
Okay, thank you.
Justice Kavanaugh?
You've said several times, I think, that some gratuities, some thank yous, should be prescribed, either because of the appearance problem they present, government officials getting payments like that, or because they're suggestive of something more nefarious that might also be going on with respect to the government official. And there's widespread agreement on that, I think, and I certainly do as well agree on that. I think there are two issues here you need to deal with, though, and I'm going to come back to them. One is we're talking about state and local officials who might have different state and local rules than what the federal government's going to come in and superimpose on them. The second issue is the word corruptly. And you said, I think, that the word corruptly was a break on an otherwise broad statute, and so it's a good thing here, right? And I accept that, but the problem is the word corruptly then creates enormous uncertainty and vagueness about where the line is drawn. And so when you have state and local officials who have one set of rules they think they're following, coupled with a vague federal line that they have no idea where that's drawn, and it's up to 10 years in prison, that's a problem.
So I think to alleviate that concern, it is consciousness of wrongdoing. So if there's uncertainty about whether accepting that reward is wrongful, the government isn't going to be able to prove that the person had this consciousness of wrongdoing.
Well, you nicely anticipated my next question, which is to drill down again, and you did with Justice Sotomayor, on wrongful, and Justice Gorsuch as well. I think it's your backup position. I think you said you could live with it, but I'm going to make sure I've got it. An instruction that says you're only guilty under this statute, paraphrasing, if the conduct was unlawful under state or local law.
Can I live with that? Oh, they're over cutting out gratuities entirely? I mean, yes, I'm going to take the narrower statutory surgery.
And knew that it was unlawful, because you've said consciousness of wrongdoing,
yes.
So consciousness of illegality. In other words, this statute would be narrowed to a situation where it was unlawful under state or local law, and you knew it was unlawful under state or local law to take that gratuity. That's
Yes. Yes.
That's better from your perspective then.
That's absolutely better. I think it might be worse for some defendants where the state or local law has some ticky-tacky requirement that they just couldn't possibly have known was really wrongful. So I think this is actually less protective in some ways. But I'm certainly willing to live with it.
Well, that may indicate that even the backup position's no good, but that's
No, I don't think so.
You're arguing against yourself there a little.
No, I don't think so. Again, the very worst is, I think what you could be saying is that, we know that gratuities are barred under Section 201C with no corruptly mens rea. I mean, if you think that corruptly can't be adding anything,
can I just stop
go
you
to
there?
Section 201C.
That lends to the clarity point. I mean, it's clear there. But here, when you put corruptly in, now you don't know where the line is. You don't know if the concert tickets, the game tickets, the gift card to Starbucks, whatever, where's the line? And so there's vagueness. That creates the problem that...
No, I disagree.
And you say, this is my last question, you said these fringe cases as compared to this case. I think the, quote, fringe cases are the everyday concern.
again, there's a requirement of consciousness of wrongdoing. So if the person couldn't know that this behavior was wrongful because it was unclear, because there are some line drawing difficulties, because some people think this is wrong and some people think it's right, then the government isn't going to be able to meet its burden of proof. So it's not introducing.
You're sitting in a criminal courtroom after you're a regular police officer or a local official. You've depleted your money. To defend yourself, you've lost your job because you're prosecuted. And it's like, oh, well, the good news is they won't be able to meet the burden of proof because some people thought it was okay to do this?
No, I mean, prosecutors have a responsibility not to bring prosecutions that don't meet the statute. And what I'm saying is that the statute prevents that kind of prosecution. So it's what Congress said. We don't want to reach innocuous conduct. We want to make sure we were going to put in a mens rea that makes sure that you understand that what you're doing is wrongful and you do it anyway. That's the nature of this mens rea. It's a break.
Yes.
Thank you.
Justice Barrett?
Okay, so I'm increasingly worried about the scope of the government's position. I'd like you to tell me how your backup position that you were just talking about with Justice Kavanaugh works for the private university or the private hospital employee that Justice Kagan was pointing out satisfies the grant amount. And I'll say, as Justice Gorsuch pointed out, I don't think that the nexus requirements or the $5,000 requirement does a whole lot of work. And, for the surgery, the employee's time, or the police officer's time working your case, or the professor's time spending, trust me, tutoring is expensive. I've paid a lot of tutoring bills. The professor spending all this extra time, outside of class. So if state and local laws, I assume you're encompassing ethics rules for state and local government employees in your answer to Justice Kavanaugh?
Yeah.
So how does that cash out for the private people?
So if it's acceptable under those rules, I think it's a safe harbor, is what we've been discussing.
Right, but I'm saying that these ethics rules aren't going to apply in the private context to the car dealer, the private university, the private hospital that's swept in because of the federal funds.
Oh, I don't think that's really necessarily true. I think many entities, like hospitals, research institutions, the entities that are actually being covered here, they do have ethics rules. So there is going to be something to look at, but also that they can certainly...
But not the state and... I guess, let me just pin you down. I'm not saying that they won't have ethics rules. Mm-hmm. The hospitals, the universities, et cetera, they're going to have ethics rules. I don't know about the car dealerships. But what I'm saying is if state and local government rules don't apply to them, where do you look for your backup position? Is it the university ethics rules, the hospital ethics rules?
I think that where I look is whether they had, I think the easiest thing is whether there would be concrete evidence that this was wrongful. So yes, if their entity's rules barred the thing, then I think that's going to be pretty good evidence. If it's unclear, though, Justice Barrett, I just want to again tell you that there has to be a consciousness of wrongdoing. So if there just was nowhere they could look and there was no way for them to know that taking the, cashmere blanket for the tutoring was wrongful, then the government can't show consciousness of wrongdoing and it can't prosecute in that case.
Can't show it? So, but you're kind of sliding, I guess, into the not backup position, but the immoral or this is unsavory or this is wrong?
No, they need to show that the person understood that what they were doing was wrongful. So if the government cannot show that the person understood what they were doing was wrongful, was against the law, is the easiest way to show that. But if they don't have any laws to point to, if they don't have anything that they can point to, then they're not going to be able to prove that the person would understand that what they're doing is wrongful.
But under your first order position, there wouldn't be anything to point to, right? Because I thought your first order position, your backup is if it's prescribed by law, but I thought your first order position was if it's wrong, if it's immoral, if people would know this is corrupt.
So our position is just let me be clear, it's that the act has to be wrongful and the person has to have consciousness of wrongdoing. That requirement of consciousness of wrongdoing, we recognize that. That's not a backup position. That's a first order.
No, I know, but I'm saying you said if the person doesn't have any place to look to know that it's wrongful, and I'm saying that I thought your first order position was that they don't have a specific place to look because you should know it's immoral, you should know it's wrong.
I think that the government can certainly, the government has to say this is something that is so obviously wrongful that everyone would know. And I would say that in the circumstances you're pointing to, the government isn't going to take that position. They're not going to be able to say that just because, that it has to be obviously wrongful. Because what they're saying is we don't have evidence to demonstrate that this specific person knew that what they were doing was wrongful, but this is something that is just so obviously inherently unlawful or not unlawful, I don't want to confuse things, inherently wrongful, that the person would be bound to know. And I agree with you that when it's something that is either permitted by ethics rules or it's just never governed by ethics rules, this isn't something that people even think about in the ethics world, maybe because cookies are just so, obvious, then there's just the government, there isn't going to be that consciousness of wrongdoing. The government isn't going to be able to show, and they're not, and therefore the statute does not cover that person because they do not understand that it is wrongful.
Justice Jackson?
I guess I'm just totally confused in a lot of ways because I had understood this case to be about a totally different part of the statute. And by what I mean is that suddenly it seems as though it's becoming a vehicle to investigate the corruptly solicits or demands element as opposed to the influenced or rewarded element. And I read the question presented to be about reward. Like, what does reward mean? The petitioner's statement of the question presented is whether 666 penalizes gratuities without any quid pro quo agreement to take those actions. So I thought we were looking at reward and determining whether or not you needed a quid pro quo. But it sounds like there's a lot of concern about the corruptly element. So can I ask you, do we need to take a position on corruptly here to rule in your favor on the question presented in this case?
No, to rule in our favor, you just have to look and say that rewarded obviously encompasses rewards that are accepted without a beforehand agreement.
All right, and if we were going to think about corruptly, I guess I'm trying to understand how this case on these facts even really presents that issue. I mean, I understand all of these hypotheticals about the blankets and the Starbucks and the gray areas around where people could say, is this person really acting corruptly? But was there a dispute in this case that it was corrupt for this official to, if he was taking a reward, to receive the $13,000 under these circumstances?
No, and that's generally the way these cases go. It's not someone saying, I took a reward, but I thought it wasn't wrongful. So it's not someone disputing the consciousness of wrongdoing point. It's someone saying, I wasn't taking a reward. I was taking something for being friends.
And that's how that came up here. So that's why, in response to Justice Sotomayor, this wasn't a question that was put to the jury about, this is why it's not in the jury instructions, this question of what is the definition of corruptly, because he essentially conceded that element for the purpose of this case.
Right. He did not challenge the jury instructions on corruptly, even though the district court had already rejected the request to narrow the statute to gratuities. So it's not true that he didn't protest the corruptly definition because he was trying to get at it in a different way, right? The district court had already said gratuities are going to come in. He doesn't contest the corruptly jury instruction here because he wasn't saying it's rightful.
Right. He wasn't in the gray area scenario where people could say, well, I thought this was right. He wasn't doing that. All right, so final question. With respect to the question I asked Ms. Black, if we hold constant the corruptly aspect of this, the demand aspect of this, we assume that's all met, and now we're really just focusing on reward, intended to be influenced or rewarded. Can you articulate why Congress would not have wanted rewarded to include these gratuities? In other words, it seems as though that element is equating bribes, quid pro quo bribes, with rewards. What I'm thinking of is gratuities in this context. If we agree with petitioner, it sounds as though Congress would have wanted to prohibit one and not the other, and I can't figure out why that would be.
I can't either because, again, gratuities have long been recognized to be as corrupt as rewards in many circumstances. We have the bar on gratuities in our Constitution itself. We have Blackstone saying that the acceptance of gratuities is corrupt and that, the Romans were wrong to permit it. We have Congress barring barring not just bribery, but also the acceptance of gratuities without the corruptly mens rea in Section 201. So there's just no reason, and that's not because Congress was like an overly moral being in this respect. It's because it's the same harm. If there's a beforehand agreement in this case, it doesn't change anything because it's crystal clear that what the petitioner was doing was taking a public act intending to get that reward. And whether there's a beforehand agreement or not, the harm is instead of doing the public act for the public good, he's doing the public act for his own, to line his own pocket.
Thank you.
Thank you, counsel. Rebuttal, Ms. Blatt?
Thank you, Mr. Chief Justice. I mean, at least we should get a 9-0 remand because everything that we heard today was not charged to the jury. It is truly, as a former government lawyer, baffling how someone could just say that it was not contested, that this was wrongful. No citation. Of course it was contested. The whole argument was this was a legitimate consulting agreement because local officials don't make any money. And just because the government says it at argument doesn't make it true, especially when they don't have a citation. There was no jury instruction. And then at times I feel like we're in a Senate room drafting language. She literally said, here's what the guidelines are going to look like going forward. What we're going to do is we're going to isolate wrongfulness. We're going to talk about if it appears for public sale and on and on and on. And then she said consciousness of wrongdoing 36 times. Consciousness of wrongdoing has never appeared. And here's where, if we're going to look at text, guess what? Corruptly applies to bribery. It has to mean the same thing. Corruptly, as in consciousness of wrongdoing, has never been the mens rea for bribery. And so now every single prosecution for bribery, I guess the defendant is entitled to an instruction. I didn't know what I was doing was wrongful. I didn't know it was unlawful. My hospital said I could do this. No, she wants a separate rule for corruptly. And to say that it's not part of the case is absurd. Corruptly means quid pro quo. Intending to be influenced and intending to be rewarded are parts of that quid pro quo. The other thing I just want to get to, and Justice Kavanaugh got on this, there is a statute that the statute applies to accepting. It also applies to anyone who gives. That's 666A2. So 300 million Americans are covered by this. Anyone who gives a gift commits a crime if it's corrupt. Now, that consciousness of wrongdoing has to apply to the person who goes to the car dealership or to the billionaire or the poor person who wants to give a toy truck. And then she said, well, I guess it's standard practice and you have to ask for it and be for sale. You see something, you say, I like your water bottle. It's got that, nice little Apple logo. Here, take it. Gratuity. You just give your job away for sale. You literally said, you want it, you can have it. Or they asked for it. I mean, this is preposterous that this would go into inherently wrongful. I still can't figure out, what about escort services? That seems not standard practice to give that to your university admissions. But maybe a plaque would be, or maybe a crystal would be. There's literally no guidance here. And the real irony is at least the banking officials would have more guidance. This is just kind of made up as like it sounds like at moot court they worked this out because it would sound good. The stuff on the lesser included and greater included was gibberish. It is recognized in government manuals that this is a greater included offense. And she said, well, it only applies to demand, but the statute says demand or agrees to accept. So if you agree to accept something, you don't have to demand. That's clearly a bribery. There is no set of circumstances where if you've proved a reward, you would ever need to prove a bribery. And that's why the government manual says go for broke, go for both. All you need to do is prove one, and you at least get, at least in the federal officials, a 2-year conviction. Here you get a 10-year conviction. The government sought 6 years here. We showed examples where they've prosecuted for 4 years. And the other thing in terms of the line drawing, I don't know why can I get a ride in the Uber would not count, because that's asking for, part of a value. And this definition of consciousness of wrongdoing, I don't think it gives anybody any guidance whatsoever about what happens day in and day out. So at least we get a remand. And Justice Sotomayor, on the harmless error under Nader, I'm not sure why she said evidence sufficiency. The standard is beyond a reasonable doubt. They'd have to show the jury instruction, and so there'd have to be overwhelming evidence of bribery, and so that would have to be worked on remand. But none of this was in the jury instruction. It was adequately yelling to the top of the roof that this could only apply to gratuity, i.e. gratuities were not wrongful. Thank you.
Thank you, counsel. The case is submitted. We will hear argument first this morning in case 23-10.
From me!
Progress, and who continue to focus. We have already served billions of queries with our generative AI features. It's enabling people to access new information, to ask questions in new ways, and to ask more complex questions. Most notably, based on our testing, we are encouraged that we are seeing an increase in search usage among people who use the new AI overviews, as well as increased user satisfaction with the results. And with Circle to Search, people can now circle what they see on their Android screens, ask a question about an image or object in a video, and get an AI overview with Lens. Fourth, our global product footprint beyond search. We have 6 products with more than 2 billion monthly users, including 3 billion Android devices. 15 products have 500 million users, and we operate across 100+ countries. This gives us a lot of opportunities to bring helpful Gen AI features and multimodal capabilities to people everywhere and improve their experiences. We have brought many new AI features to Pixel, Photos, Chrome, Messages, and more. We are also pleased with the progress we are seeing with Gemini and Gemini Advanced through the Gemini app on Android and the Google app on iOS. Fifth, improved velocity and execution. We've been really focused on simplifying our structures to help us move faster. In addition to bringing together our model building teams under Google DeepMind, we recently unified our ML infrastructure and ML developer teams to enable faster decisions, smarter compute allocation, and a better customer experience. Earlier this year, we brought our search teams together under one leader. And last week, we took another step, bringing together our platforms and devices teams. The new combined team will focus on delivering high-quality products and experiences, bolstering the Android and Chrome ecosystems, and bringing our best innovations to partners faster. We also remain focused on long-term efforts to durably re-engineer our cost base. You can see the impact of this work reflected in our operating margin improvement. We continue to manage our headcount growth and align teams with our highest priority areas. This speeds up decision-making, reduces layers, and enables us to invest in the right areas. Beyond our teams, we are very focused on our cost structures, procurement, and efficiency. And a number of technical breakthroughs are enhancing machine speed and efficiency, including the new family of Gemini models and a new generation of TPUs. For example, since introducing SGE about a year ago, machine costs associated with SGE responses have decreased 80% from when first introduced in labs, driven by hardware, engineering, and technical breakthroughs. We remain committed to all of this work. Finally, our monetization path. We have clear paths to AI monetization through ads and cloud, as well as subscriptions. Philip will talk more about new AI features that are helping advertisers, including bringing Gemini models into Performance Max. Our cloud business continues to grow as we bring the best of Google AI to enterprise customers and organizations around the world. And Google One now has crossed 100 million paid subscribers, and in Q1, we introduced a new AI premium plan with Gemini Advanced. Okay, those are the 6 points. So now let me turn to quarterly highlights from Cloud and YouTube in a bit more detail. They are increasingly
ads will play in delighting users and expanding opportunities to meet user needs. Which brings me to search and our strong performance in the first quarter. In Q1, retail was again a top contributor. Our focus remains on driving profitability and growth for retailers, helping them optimize digital performance for both online and offline, as well as innovate across our shopping and merchant experiences. Highlights include continued upsides for retailers, leading into agile budget and bidding strategies across search, PMax, or both. Take-home goods retailer IKEA, who leaned into Google's store sales measurement to understand its total omni-channel revenue opportunity across search. By measuring 2.3 times more revenue and using value-based bidding solutions to bid to its omni-channel customers, IKEA drove a significant increase in omni revenue in Q1 and is now scaling this strategy globally. We also expanded local inventory ads into 23 countries, helping drive shopper confidence and offline sales. Retailers can convert intent into action by showcasing in-store availability, pricing, pickup options, and more, all in one ad format. Moving to YouTube. Last quarter, I went deep into our strategy. It all starts with creation, which drives viewership, which leads to monetization. A few updates to build on Sundar's remarks. First, creation, which is all about giving creators the tools to create amazing content, grow their audiences, and build their businesses. In 2023, more people created content on YouTube than ever before, and the number of channels uploading shorts year-on-year grew 50%. We also hit a new milestone with 3 million plus channels in our YouTube Partner Program. We recently shared that YPP has paid out more than any other creator monetization platform, including over $70 billion to creators, artists, and media companies over the last 3 years. From a viewer's perspective, watch time across YouTube continues to grow, with strength in both Shorts and CTV. According to Nielsen, YouTube has been the leader in US streaming watch time for the last 12 plus months. In the first quarter, Living Room benefited from a combination of strong watch time growth, innovation in the user and advertiser experience, and a shift in brand advertising budgets from linear TV to YouTube. Viewers are watching YouTube because they expect to access everything in one place, across screens and formats, their favorite creators, live sports, breaking news, educational content, movies, music, and more. And advertisers continue to lean in to find audiences they can't find elsewhere. Which brings me to monetization. We're pleased with our Q1 performance across both our ad-supported and subscription offerings. Sundar covered subscription growth. On the ads front, direct and brand were both strong this quarter. Shorts monetization continued to improve. with Shorts ads now supported on mobile, tablet, living room, and desktop, and available to both performance and brand advertisers. In the US, the monetization rate of Shorts relative to in-stream viewing has more than doubled in the past 12 months, including a 10-point sequential improvement in the first quarter alone. Just last week, we introduced new ways for brands to get the most out of their Shorts ads with new lineups on YouTube Select, including sports, beauty, fashion and lifestyle, and entertainment. For YouTube advertisers, increasing brand lift is one of the core goals. In Q1, we saw strong traction from the introduction of a pause ads pilot on connected TVs, a new non-interruptive ad format that appears when users pause their organic content. Initial results show that pause ads are driving strong brand lift results and are commanding premium pricing from advertisers. Before I wrap, 2 quick highlights on how we're helping our partners transform and accelerate impact with the best across Google. Number 1, to help McDonald's build the restaurant of the future, we're deepening our partnership across cloud and ads. Part of this includes them connecting Google Cloud's latest hardware and data technologies across restaurants globally and starting to apply GenAI to enhance its customer and employee experiences. Number 2, WPP. At Google Cloud Next, we announced a new collaboration that will redefine marketing through the integration of our Gemini models with WPP Open. WPP's AI-powered marketing operating system already used by more than 35,000 of its people and adopted by key clients including the Coca-Cola Company, L'Oreal, and Nestle. We're just getting started here and excited about the innovation this partnership will unlock. With that, a huge thank you to our customers and partners, many of whom were excited to see at Google Marketing Live and Brandcast in just a few weeks. And a huge thank you, as always, to our incredible teams for their agility and hard work this quarter. Ruth, you're up.
Thank you, Philip. We are very pleased with our financial results for the first quarter, driven in particular by strength in search and cloud, as well as the ongoing efforts to durably re-engineer our cost base. My comments will be on year-over-year comparisons for the first quarter unless I state otherwise. I will start with results at the Alphabet level, followed by segment results, and conclude with our outlook. For the first quarter, our consolidated revenues were $80.5 billion, up 15% or up 16% in constant currency. Search remained the largest contributor to revenue growth. In terms of total expenses, the year-on-year comparisons reflect the impact of the restructuring charges we took in the first quarter of 2023 of $2.6 billion, as well as the $716 million in employee severance and related charges in the first quarter of 2024. As you can see in our earnings release, these charges were allocated across the expense lines in other cost of revenues and OPEX based on associated headcount. To help with year-on-year comparisons, we included a table in our earnings release to adjust other cost of revenues, operating expenses, operating income, and operating margin to exclude the impact of severance and related office space charges in the first quarter of 2023 versus 2024. In terms of expenses, total cost of revenues was $33.7 billion, up 10%. Other cost of revenues was $20.8 billion, up 10% on a reported basis, with the increase driven primarily by content acquisition costs associated with YouTube, given the very strong revenue growth in both subscription offerings and ad-supported content. On an adjusted basis, other cost of revenues were up 13% year-on-year. Operating expenses were $21.4 billion, down 2% on a reported basis, primarily reflecting expense decreases in sales and marketing and G&A, offset by an increase in R&D. The largest single factor in the year-on-year decline in G&A expenses was lower charges related to legal matters. On an adjusted basis, operating expenses were up 5%, reflecting first in R&D an increase in compensation expense, primarily for Google DeepMind and Cloud, and second, in sales and marketing, a slight increase year-on-year, reflecting increases in compensation expense, primarily for cloud sales. Operating income was $25.5 billion, up 46% on a reported basis, and our operating margin was 32%. On an adjusted basis, operating income was up 31%, and our operating margin was 33%. Net income was $23.7 billion, and EPS was $1.89. We delivered free cash flow of $16.8 billion in the first quarter and $69.1 billion for the trailing 12 months. We ended the quarter with $108 billion in cash and marketable securities. Turning to segment results. Within Google Services, revenues were $70.4 billion, up 14%. Google Search and other advertising revenues of $46.2 billion in the quarter were up 14%, led again by growth in retail. YouTube advertising revenues of $8.1 billion were up 21%, driven by both direct response and brand advertising. Network advertising revenues of $7.4 billion were down 1%. Subscriptions, platforms, and devices revenues were $8.7 billion, up 18%, primarily reflecting growth in YouTube subscription revenues. TAC was $12.9 billion, up 10%. Google Services operating income was $27.9 billion, up 28%, and the operating margin was 40%. Turning to the Google Cloud segment, revenues were $9.6 billion for the quarter, up 28%, reflecting significant growth in GCP with an increasing contribution from AI and strong Google Workspace growth, primarily driven by increases in average revenue per seat. Google Cloud delivered operating income of $900 million and an operating margin of 9%. As to our other bets for the first quarter, revenues were $495 million, benefiting from a milestone payment in one of the other bets. The operating loss was $1 billion. Turning to our outlook for the business, with respect to Google Services, first within advertising, we are very pleased with the momentum of our ads businesses. Search had broad-based strength across verticals. In YouTube, we had acceleration in revenue growth driven by brand and direct response. Looking ahead, 2 points to call out. First, results in our advertising business in Q1 continued to reflect strength in spend from APAC-based retailers, a trend that began in the second quarter of 2023 and continued through Q1, which means we will begin lapping that impact in the second quarter. Second, the YouTube acceleration in revenue growth in Q1 reflects, in part, lapping the negative year-on-year growth we experienced in the first quarter of 2023. Turning to subscriptions, platforms, and devices. We continue to deliver significant growth in our subscriptions business, which drives the majority of revenue growth in this line. The sequential quarterly decline in year-on-year revenue growth for the line in Q1 versus Q4 reflects in part the fact that we had only 1 week of Sunday Ticket subscription revenue in Q1 versus 14 weeks in Q4. Looking forward, we will anniversary last year's price increase in YouTube TV starting in May. With regard to platforms, we are pleased with the performance in Play, driven by an increase in buyers. With respect to Google Cloud, performance in Q1 reflects strong demand for our GCP infrastructure and solutions, as well as the contribution from our workspace productivity tools. The growth we are seeing across cloud is underpinned by the benefit AI provides for our customers. We continue to invest aggressively while remaining focused on profitable growth. As we look ahead, 2 points that will affect sequential year-on-year revenue growth comparisons across Alphabet. First, Q1 results reflect the benefit of leap year, which contributed slightly more than 1 point to our revenue growth rate at the consolidated level in the first quarter. Second, at current spot rates, we expect a larger headwind from foreign exchange in Q2 versus Q1. Turning to margins, our efforts to durably re-engineer our cost base are reflected in a 400 basis point expansion of our Alphabet operating margin year-on-year, excluding the impact of restructuring and severance charges in both periods. You can also see the impact in the quarter-on-quarter decline in headcount in Q1, which reflects both actions we have taken over the past few months and a much slower pace of hiring. As we have discussed previously, we are continuing to invest in top engineering and technical talent, particularly in cloud, Google DeepMind, and technical infrastructure. Looking ahead, we remain focused on our efforts to moderate the pace of expense growth in order to create capacity for the increases in depreciation and expenses associated with the higher levels of investment in our technical infrastructure. We believe these efforts will enable us to deliver full-year 2024 Alphabet operating margin expansion relative to 2023. With respect to CapEx, our reported CapEx in the first quarter was $12 billion, once again driven overwhelmingly by investment in our technical infrastructure, with the largest component for servers, followed by data centers. The significant year-on-year growth in CapEx in recent quarters reflects our confidence in the opportunities offered by AI across our business. Looking ahead, we expect quarterly CapEx throughout the year to be roughly at or above the Q1 level, keeping in mind that the timing of cash payments can cause variability in quarterly reported CapEx.
Yes.
With regard to other bets, we similarly have work streams underway to enhance overall returns. Finally, as I trust you saw in the press release, we are very pleased to be adding a quarterly dividend of 20 cents per share to our capital return program, as well as a new $70 billion authorization in share repurchases. The core of our capital allocation framework remains the same, beginning with investing aggressively in our business, as you have heard us talk about today, given the extraordinary opportunities ahead. We view the introduction of the dividend as further strengthening our overall capital return program. Thank you. Sundar, Philip, and I will now take your questions.
Thank you. As a reminder, to ask a question, you will need to press *1 on your telephone. To prevent any background noise, we ask that you please mute your line once your question has been stated. And our first question comes from Brian Nowak with Morgan Stanley. Please go ahead.
Great. Thanks for taking my question. I have two. The first one, I wanted to ask about overall search behavior. Philip, I know you talked in the past about how overall query trends continue to grow. Can I ask you to drill a little bit more into monetizable and commercial query trends? Have there been any changes in sort of your commercial query trends growth? There's been all these new entrants moving around in e-commerce, is my first one. And the second one for Ruth, when you talked about sort of more efforts to moderate expense growth from here, can you just sort of give us some examples of areas where you still see the potential for more optimization or work streams in place to continue to durably re-engineer the OpEx space as we go throughout 2024? Thanks.
Want to go again?
Thanks, Brian. To your first question,
this means you're due for a big one.
Look, I think broadly, we've always found that over many years when things work well on the organic side, monetization follows. So typically, the trends we see carry over well. Overall, I think with generative AI in search, with our AI overviews, we are definitely, I think we will expand the type of queries we can serve our users. We can answer more complex questions as well. And in general, that all seems to carry over across query categories. Obviously, still early, and we are going to be measured and put user experience at front, but we are positive about what this transition means.
And on the second question, in terms of the various work streams, as both Sundar and I said, we remain very focused on ongoing efforts to slow the pace of expense growth, what we've been calling durably re-engineering our cost base. And I made this point in opening comments, but we are very cognizant of the increasing headwind we have from higher depreciation and expenses associated with the higher CapEx. And so these efforts are ongoing. And they're very much the same that we've talked with you about previously. It starts with product and process prioritization, all of the work around organizational efficiency and structure. These are ongoing. And so as an example, the work that Sundar talked about, combining devices and services with our platforms and ecosystems, product area is a really good example, because unifying the teams not only helps us deliver higher quality products and experiences, but we think it enables us to move with greater velocity and efficiency. And then the other work streams we've talked to you about in the past, like all of the work around technical infrastructure, which Sundar alluded to, and with our suppliers and vendors, which he also referenced, the work you've seen on real estate optimization. These are all ongoing work streams, which is why we have them under the umbrella of durably re-engineering our cost base, and they are ongoing.
Our next question comes from Doug Amuth with J.P. Morgan. Your line is now open.
Thanks for taking the question. Sundar, you talked about bringing more generative AI features into the main search page. Can you just talk about what kind of queries or scenarios you think that's working best for so far, and just how we should think about the cadence of continuing to adopt more of those features within core search? And then, Ruth, on CapEx spending, the $12 billion in 1Q, can we assume that run rating that and above is reasonable for this year? And I know it's very early, but should we generally expect higher CapEx next year as well?
Thanks, Doug. On SGE in search, look, I think it tends to really, we're seeing early confirmation of our thesis that, this will expand the universe of queries where we are able to really provide people with a mix of factual answers, link to sources across the web, and bring a variety of perspectives, all in an innovative way. And we've been rolling out AI overviews in the US and UK, trying to mainly tackle queries which are more complex, where we think the SGE will clearly improve the experience. We've already served billions of queries, and it seems to cut across categories, but we are still continuing our testing, and we'll keep. We are metrics driven in these areas, and so but I am optimistic that it clearly improves the user experience. Users are telling us that, and we are seeing it in our metrics, and we'll continue evolving it through the course of this year.
And then in terms of CapEx, as I said in opening comments, we do expect the quarterly CapEx throughout the year to be roughly at or above the $12 billion cash CapEx we had here in Q1. As I said, you can always have variability in the reported quarterly CapEx just due to the timing of cash payments, but roughly at or above this level. And it really goes to Sundar's comment, opening comment, that we're very committed to making the investments required to keep us at the leading edge in technical infrastructure to support the growth in cloud, all the innovation in search that he and Philip have spoken about, and our lead with Gemini. I will note that most, nearly all, I should say, of the CapEx was in our technical infrastructure. We expect that our investment in office facilities will be about less than 10% of the total CapEx in 2024, roughly flat with our CapEx in 2023, but is still there. And then with respect to 2025, as you said, it's premature to comment, so nothing to add on that.
Great. Thank you.
Our next question comes from Eric Sheridan with Goldman Sachs. Please go ahead.
Thanks so much. Maybe just one question of the big picture in nature for Sundar. If we come back to your earlier comments at the beginning of the call and framing up longer-term initiatives and longer-term narratives, I wanted to know if you could talk a little bit about both the opportunities and the challenges of operating at scale in a time like this where there's a lot of technology innovation going on, and how you see the elements of trying to strike a balance towards moving the organization forward while still continuing to both invest for growth as well as balance margins. Thanks so much.
Thanks, Eric. Great question. Obviously, I think the AI transition, I think it's a once-in-a-generation kind of an opportunity. We've definitely, been gearing up for this for a long time. You can imagine we started building TPUs in 2016. So we've definitely been gearing up for a long time. The real opportunities we see is the scale of research and innovation which we've built up and are going to continue to deliver. I think for the first time we can work on AI in a horizontal way, and it impacts the entire breadth of the company, be it search, be it YouTube, be it cloud, be it Waymo, and so on. And we see rapid pace of innovation in that underlying. So it's a very leveraged way to do it, and I see that as a real opportunity ahead. In terms of the challenges, I think making sure. I think we are constantly. I think it's been a mindset shift which we've been driving across the company to make sure that we are embracing this opportunity, but being very efficient in how we are approaching it. making sure we are redirecting our people to the highest priorities across the company, building on our 20 years of experience in driving machine efficiencies year on year, so that we can put our dollars to work as efficiently as possible. So making sure balancing all of that, moving forward in a very bold and responsible way at the same time, those are very important things to get right from my perspective.
Our next question comes from Stephen Ju with UBS. Your line is now open.
Right, thank you so much. So, hi, Philip. I think it's approaching the 2-year anniversary for the launch of ads on YouTube Shorts, and I think you've given us an update on monetization pickup sequentially. But, with that in mind, I think, YouTube has launched an array of ad products and automation tools to help advertisers transfer what they're doing to the vertical screen. So, how is this translating into buy-in among your advertiser clients? And secondly, based on what you've seen over the last 2 years, are there any structural reasons that you can cite as to why the monetization cannot match what is already the case on the horizontal screen? Thanks.
Yeah, look, this is a great question. First of all, let's start with the fact that YouTube performance was very strong and this quarter. And on Shorts, specifically in the US, I mentioned how the monetization rate of Shorts relative to in-stream viewing has more than doubled in the last 12 months. I think that's what you were referring to. Yes, we're obviously very happy with this development. The way to think about it is advertisers really only spend with us when they see a positive ROI. So you can assume that this wouldn't be happening unless it were to work for advertisers in the short term and also in the long term. That's an important part, I think. Overall, Shorts is a long-term bet for the business. It has really helped us respond to both creator and viewer demand for short-form video. We talked about the strong growth, averaging 70 billion daily views. I mentioned the number of channels uploading has increased 50% year over year. Again, very happy with this development. And to your question, structural reasons, whether we can't get to a match here, I have a hard time seeing those at the moment over time.
Okay, thank you.
Our next question comes from Justin Post with Bank of America. Your line is now open.
Great, thank you. I'm going to ask another one about CapEx. It seems to be your biggest investment area. Just first, you saw the big uptick the last 2 quarters, but you've been investing in AI for years. Is the uptick because supply is getting easier to get, or do you see more opportunities with the available supply to really fuel AI? So it has the GPUs and everything gotten better that you feel more investing more? And then thinking about the returns both for advertising and cloud on the CapEx, do you feel like this is a higher cost of doing business, or do you think this is an opportunity to even get better returns on your capital spend than you've had in the past? Thank you.
So the increase in CapEx, as Sundar said and I said, really reflects the opportunity we continue to see across the company. It starts with all that we're doing in support of the foundation model, of the Gemini foundational model, but then also clearly the work across cloud on behalf of cloud customers and the growth that we're seeing with GCP and the infrastructure work there. And then, of course, as both Sundar and Philip talked about, the application across search, YouTube, and more broadly, the services that we're able to offer. So it's the growing application and our focus on ensuring that we have the compute capacity to deliver in support of the services and opportunities we see across Alphabet. And it really goes to the second part of your question, which is that as we're investing in CapEx and applying it across new opportunities, and we're very focused on the monetization opportunity, it does underlie everything that we're doing in Google Services and Google Cloud. And as Sundar noted, we're at the same time very focused on the efficiency of all elements of delivering that compute capacity from hardware, software, and beyond.
Our next question comes from Mark Mahaney with Evercore. Your line is now open.
Great, thank you. This is Jan Lee for Mark Mahaney. A couple questions. One, just maybe an expansion on the search query question from before. More like search volume, and maybe in the context of the off-Google environment, like AI chatbot, for example, we've seen kind of Meta AI directing to Google search results. Do you think there's actually a scenario where like AI system can create a step function change in search volume or use cases off Google? You can give us more color on what are you seeing right now or what are you expecting to see in that area? And then the second question on just the comment of YouTube and cloud exiting at 100 billion run rate. What is informing this outlook of visibility for you? If you can talk about, is it driven by any sort of cloud demand inflection or step change in the GenAI workload demand? If you can flesh it out a little bit. Thanks a lot.
On your first question, look, I said this before, but to be clear, we view this moment as a positive moment for search. And I think it allows us to evolve our product in a profound way. And search is a unique experience. People come and they get to, be it if you want answers, if you want to explore more, if you want to get perspectives from across the web, and to be able to do it across the breadth and depth of everything they are looking for, and the innovation you would need to keep that up. I think it's what we've been building on for a long time, and so I feel we are extraordinarily well set up, particularly given the innovation path we are on. And overall, I view this moment as a positive moment. So that's how I would say it. On the second part, Ruth?
I'm sorry, what was the
YouTube and cloud.
Yeah, like in terms of your comment about 100 billion exit rate for YouTube and cloud, what's driving this visibility for you, and any kind of inflection you're seeing in the cloud demand?
Oh, I would just say from Sundar's opening comments, it's just the ongoing momentum that we've seen in the business that we've been talking about, the ongoing growth, the strong performance. And so what we were really getting at in that comment, what Sundar was getting at, is that we've continued to build strong businesses over time, and that just helps dimension it. We had similar comments last quarter when you talk about our subscription business. We're really proud of all the work that teams are doing across the company, building new, strong opportunities, delivering for our users, for customers, for advertisers in profound ways. And so it was just helping to dimension what we have built over the years.
Our next question comes from Ken Gorelski with Wells Fargo. Your line is now open.
Thank you very much. Two, if I may. First, on GCP, you had nice acceleration in the quarter. Could you talk a little bit about the opportunities and constraints upon GCP's ability to continue to address that large addressable market and accelerate growth? Is it more sales-oriented? Is it more product sales solutions, or both? And do you plan to address most of these organically, or could a partner approach work for you? And then the second one, just more detailed on YouTube and sports rights. Could you reiterate your view on further live sports rights? There's some larger, mostly in the U.S. league rights coming up soon, and will be more over the next several years. Could you just talk about your philosophy there beyond NFL Sunday Ticket? Thank you.
Thanks. Look, on the cloud side, obviously, it's definitely a point of inflection overall. I think the AI transformation is making everyone think about, their whole stack, and we are engaged in a number of conversations. I think, be it AI infrastructure, people really looking to Vertex AI, given our depth and breadth of model choice, or using Workspace to transform productivity in your workplace, etc. So I think the opportunities there are all related to that, both all the work we've built up and AI being a point of inflection in terms of driving conversations. I think you will see us do it both organically and with a strong partner program as well. So we'll do it with a combination. And the challenges here are always, and in there are switching costs to cloud, and the challenges we see is how do we make it easier for people. There's a lot of interest, but there's definitely barriers in terms of people switching, and so that's an area where we are constantly investing to make it easier for our customers.
And with regard to your sports rights question, look, I mean, we've had long-standing and significant partnerships with the most popular sports league here in the U.S., around the globe, federations, teams, athletes, broadcasters. And obviously these partnerships in combination with our very vast audience of sports fans drives investment in subscription experiences across many offerings, NFL Sunday Ticket, YouTube TV, YouTube primetime channels, and so on. But there's nothing that we have to announce at the moment. We're obviously always looking at where we can create more value for our users, for our advertisers, for creators, but nothing specific to talk about at this moment.
Thank you.
Our next question comes from Ross Sandler with Barclays. Your line is now open.
Great. Sundar, I had a question about smartphone-based AI searches. So you guys are powering all these new AI interactions and searches on Pixel and on Samsung devices, and I think there's speculation that Gemini might be used on iOS in the future state. So the question is if users start searching on smartphones and those searches are basically rendered on the model on the phone without accessing the web, how do you guys anticipate monetizing some of these smartphone-based behaviors that are kind of run on the edge? Any thoughts on that?
Look, I think if you look at what users are looking for, people are looking for information and an ability to connect with things outside. So I think there'll be a set of use cases which you'll be able to do on device. But for a lot of what people are looking to do, I think you will need the richness of the cloud, the web, and you have to deliver it to users. So I think again, to my earlier comments, I think through all these moments, you saw what we have done with Samsung, with Circle to Search. I think it gives a new way for people to access search conveniently wherever they are. And so I view this as a positive way to bring our services to users in a more seamless manner. So I think it's positive from that perspective. In terms of on-device versus cloud, there will be needs which can be done on device, and we should to help it from a privacy standpoint. But there are many, many things for which people will need to reach out to the cloud. And so I don't see that as being a big driver in the on-cloud versus off-cloud in any way.
And our last question comes from Colin Sebastian with Baird. Your line is now open.
Thanks, and good afternoon. I guess first, follow up on some of the questions on SGE and the core search. I guess I'm wondering, along with some of those changes in behavior, is there a way to quantify that overall engagement shift, whether that's an increase in time spent or increase in or the level of increase in queries for both sort of traditional search as well as more generative answers? And then secondly, on the hardware roadmap, I assume later this year we'll hear more about some of the products. But any areas of particular focus or that you would point out that we should keep in mind in terms of hardware launches in the back half? Thank you.
Look, on the first question on search, not much more to add to what I said, but what we have seen, and remember we've been in live experiments just for a few weeks and in US and UK and on a slice of our queries where and all indications are positive that it improves user satisfaction. We see an increase in engagement, but I see this as something which will play out over time. But if you were to step back, this moment, there were a lot of questions last year, and we always felt confident and comfortable that we would be able to improve the user experience. People question whether these things would be costly to serve, and we are very, very confident we can manage the cost of how to serve these queries. People worried about latency. I think we are, when I look at the progress we've made in latency and efficiency. We feel comfortable. There are questions about monetization, and based on our testing so far, I'm comfortable and confident that we'll be able to manage the monetization transition here well as well. It'll play out over time, but I feel we are well positioned. And more importantly, when I look at the innovation that's ahead and the way the teams are working hard on it, I am very excited about the future ahead.
Thank you, and that concludes our question and answer session for today. I'd like to turn the conference back over to Jim Friedland for any further remarks.
Thanks everyone for joining us today. We look forward to speaking with you again on our second quarter 2024 call. Thank you and have a good evening.
Thank you, everyone. This concludes today's conference call. Thank you for participating. You may now disconnect.
Greetings and welcome to the Microsoft Fiscal Year 2024 Third Quarter Earnings Conference Call. At this time, all participants are in a listen-only mode. A question and answer session will follow the formal presentation. If anyone should require operator assistance during the conference, please press star 0 on your telephone keypad. As a reminder, this conference is being recorded. I would now like to turn the conference over to your host, Brett Iverson, Vice President of Investor Relations.
Good afternoon, and thank you for joining us today. On the call with me are Satya Nadella, Chairman and Chief Executive Officer, Amy Hood, Chief Financial Officer, Alice Jalla, Chief Accounting Officer, and Keith Dolliver, Corporate Secretary and Deputy General Counsel. On the Microsoft Investor Relations website, you can find our earnings press release and financial summary slide deck, which is intended to supplement our prepared remarks during today's call and provides the reconciliation of differences between GAAP and non-GAAP financial measures. More detailed Outlook slides will be available on the Microsoft Investor Relations website when we provide Outlook commentary on today's call. On this call, we will discuss certain non-GAAP items. The non-GAAP financial measures provided should not be considered as a substitute for or superior to the measures of financial performance prepared in accordance with GAAP. They are included as additional clarifying items to aid investors in further understanding the company's third quarter performance, in addition to the impact these items and events have on the financial results. All growth comparisons we make on the call today relate to the corresponding period of last year unless otherwise noted. We will also provide growth rates in constant currency when available as a framework for assessing how our underlying businesses performed, excluding the effect of foreign currency rate fluctuations. Where growth rates are the same in constant currency, we'll refer to the growth rate only. We will post our prepared remarks to our website immediately following the call until the complete transcript is available. Today's call is being webcast live and recorded. If you ask a question, it will be included in our live transmission, in the transcript, and in any future use of the recording. You can replay the call and view the transcript on the Microsoft Investor Relations website. During this call, we'll be making forward-looking statements, which are predictions, projections, or other statements about future events. These statements are based on current expectations and assumptions that are subject to risks and uncertainties. Actual results could materially differ because of factors discussed in today's earnings press release, in the comments made during this conference call, and in the risk factors section of our Form 10-K, Forms 10-Q, and other reports and filings with the Securities and Exchange Commission. We do not undertake any duty to update any forward-looking statement. And with that, I'll turn the call over to Satya.
Thank you, Brett. It was a record third quarter powered by the continued strength of Microsoft Cloud, which surpassed $35 billion in revenue, up 23%. Microsoft Copilot and Copilot Stack, spanning everyday productivity, business process, and developer services to models, data, and infrastructure, are orchestrating a new era of AI transformation, driving better business outcomes across every role and industry. Now I'll highlight examples walking up the stack, starting with AI infrastructure. Yes. Azure again took share as customers use our platforms and tools to build their own AI solutions. We offer the most diverse selection of AI accelerators, including the latest from NVIDIA, AMD, as well as our own first-party silicon. Our AI innovation continues to build on our strategic partnership with OpenAI. More than 65% of the Fortune 500 now use Azure OpenAI service. We also continue to innovate and partner broadly to bring customers the best selection of frontier models and open source models, LLMs and SLMs. With 5.3, which we announced earlier this week, we offer the most capable and cost-effective SLM available. It's already being trialed by companies like CallMiner, LTI, Mindtree, PwC, and TCS. Our Models as a Service offering makes it easy for developers to use LLMs and SLMs without having to manage any underlying infrastructure. Hundreds of paid customers from Accenture and EY to Schneider Electric are using it to take advantage of API access to third-party models, including, as of this quarter, the latest from Cohere, Meta, and Mistral. And as part of a partnership announced last week, G42 will run its AI applications and services on our cloud. All up, the number of Azure AI customers continues to grow and average spend continues to increase. We also saw an acceleration of revenue from migrations to Azure. Azure Arc continues to help customers like Dick's Sporting Goods and World Bank streamline their cloud migrations. Arc now has 33,000 customers, up over 2x year over year. And we are the hyperscale platform of choice for SAP and Oracle workloads, with Conduent and Medline moving their on-premise Oracle estates to Azure, and Kyndryl and L'Oreal migrating their SAP workloads to Azure. Overall, we are seeing an acceleration in the number of large Azure deals from leaders across industries, including billion-dollar-plus multi-year commitments announced this month from Cloud Software Group and the Coca-Cola Company. The number of $100 million plus Azure deals increased over 80% year over year, while the number of $10 million plus deals more than doubled. Now on to data and analytics. Our Microsoft Intelligent Data Platform provides customers with the broadest capabilities spanning databases, analytics, business intelligence, governance, and AI. Over half of our Azure AI customers also use our data and analytics tools. Customers are building intelligent applications running on Azure, PostgreSQL, and Cosmos DB with deep integrations with Azure AI. TomTom is a great example. They've used Cosmos DB along with Azure OpenAI Service to build their own immersive in-car infotainment system. We are also encouraged by our momentum with our next-generation analytics platform, Microsoft Fabric. Fabric now has over 11,000 paid customers, including leaders in every industry, from ABB, EDP, Energy Transfer to Equinor, Foot Locker, Itochu, and Lumen, and we are seeing increased usage intensity. Fabric is seamlessly integrated with Azure AI Studio, meaning customers can run models against enterprise data that's consolidated in Fabric's multi-cloud data lake, OneLake. And Power BI, which is also natively integrated with Fabric, provides business users with AI-powered insights. We now have over 350,000 paid customers. Now on to developers. GitHub Copilot is bending the productivity curve for developers. We now have 1.8 million paid subscribers, with growth accelerating to over 35% quarter over quarter, and continues to see increased adoption from businesses in every industry, including Itaú, Lufthansa Systems, Nokia, Pinterest, and Volvo Cars. Copilot is driving growth across the broader GitHub platform too. AT&T, Citigroup, and Honeywell all increased their overall GitHub usage after seeing productivity and code quality increases with Copilot. All up, more than 90% of the Fortune 100 are now GitHub customers, and revenue accelerated over 45% year over year. Anyone can be a developer with new AI-powered features across our low-code, no-code tools, which makes it easier to build an app, automate workflow, or create a Copilot using natural language. 30,000 organizations across every industry have used Copilot Studio to customize Copilot for Microsoft 365 or build their own, up 175% quarter over quarter. Cineplex, for example, built a Copilot for customer service agents, reducing query handling time from as much as 15 minutes to 30 seconds. All up, over 330,000 organizations, including over half of Fortune 100, have used AI-powered capabilities in Power Platform, and Power Apps now has over 25 million monthly active users, up over 40% year over year. Now on to future of work. We are seeing AI democratize expertise across the workforce. What inventory turns are to efficiency of supply chains, knowledge turns, the creation and diffusion of knowledge are to productivity of an organization. And Copilot for Microsoft 365 is helping increase knowledge turns. That's having a cascading effect, changing work artifacts and workflows, and driving better decision-making, collaboration, and efficiency. This quarter, we made Copilot available to organizations of all types and sizes, from enterprises to small businesses. Nearly 60% of the Fortune 500 now use Copilot, and we have seen accelerated adoption across industries and geographies, with companies like Amgen, BP, Cognizant, Koch Industries, Moody's, Novo Nordisk, NVIDIA, and Tech Mahindra purchasing over 10,000 seats. We're also seeing increased usage intensity from early adopters, including a nearly 50% increase in the number of Copilot-assisted interactions per user in Teams, bridging group activity with business process workflows and enterprise knowledge. And we're not stopping there. We're accelerating our innovation, adding over 150 Copilot capabilities since the start of the year. With Copilot in Dynamics 365, we're helping businesses transform every role and business function as we take share with our AI-powered apps across all categories. This quarter, we made our Copilot for Service and Copilot for Sales broadly available, helping customer service agents and sellers at companies like Land O'Lakes, Northern Trust, Rockwell Automation, and Toyota Group generate role-specific insights and recommendations from across Dynamics 365 and Microsoft 365, as well as third-party platforms like Salesforce, ServiceNow, and Zendesk. And with our Copilot for Finance, we are drawing context from Dynamics as well as ERP systems like SAP to reduce labor-intensive processes like collections and contracts and invoice capture for companies like Dentsu and IDC. ISVs are also building their own Copilot integrations. For example, new integrations between Adobe Experience Cloud and Copilot will help marketeers access campaign insights in the flow of their work. When it comes to devices, Copilot in Windows is now available on nearly 225 million Windows 10 and Windows 11 PCs, up 2x quarter over quarter. With Copilot, we have an opportunity to create an entirely new category of devices purpose-built for this new generation of AI. All of our largest OEM partners have announced AI PCs in recent months, and this quarter we introduced new Surface devices, which includes integrated NPUs to power on-device AI experiences like auto-framing and live captions. And there's much more to come. In just a few weeks, we'll hold a special event to talk about our AI vision across Windows and devices. When it comes to Teams, we once again saw year-over-year usage growth. We're rolling out a new version which is up to 2 times faster while using 50% less memory to all customers. We surpassed 1 million Teams rooms for the first time as we continue to make hybrid meetings better with new AI-powered features like automatic camera switching and speaker recognition. And Teams Phone continues to be the market leader in cloud calling, now with over 20 million PSTN users, up nearly 30% year over year. All of this innovation is driving growth across Microsoft 365. Companies across the private and public sector, including Amadeus, BlackRock, Chevron, Ecolab, Kimberly-Clark, all chose our premium E5 offerings this quarter for advanced security, compliance, voice, and analytics. Now on to industry and cross-industry clouds. We're also bringing AI-powered transformation to every industry. In healthcare, DAX Copilot is being used by more than 200 healthcare organizations, including Providence, Stanford Healthcare, and WellSpan Health. And in manufacturing this week at Hanover Massey, customers like BMW, Siemens, and Volvo Penta shared how they're using our cloud and AI solutions to transform factory operations. Now on to security. Security underpins every layer of the tech stack, and it's our number one priority. We launched our Secure Future initiative last fall for this reason, bringing together every part of the company to advance cybersecurity protection, and we are doubling down on this very important work, putting security above all else, before all other features and investments. We are focused on making continuous progress across the 6 pillars of this initiative as we protect tenants and isolate production systems, protect identities and secrets, protect networks, protect engineering systems, monitor and detect threats, and accelerate responses and remediation. We remain committed to sharing our learnings, tools, and innovation with customers. A great example is Copilot for Security, which we made generally available earlier this month, bringing together LLMs with domain-specific skills informed by our threat intelligence and 78 trillion daily security signals to provide security teams with actionable insights. Now let me talk about our consumer businesses, starting with LinkedIn. We continue to combine our unique data with this new generation of AI to transform the way members learn, sell, and get hired. Features like LinkedIn AI-assisted messages are seeing a 40% higher acceptance rate and accepted over 10% faster by job seekers, saving hirers time and making it easier to connect them to candidates. Our AI-powered collaborative articles, which have reached over 12 million contributions, are helping increase engagement on the platform, which reached a new record this quarter. New AI features are also helping accelerate LinkedIn Premium growth, with revenue up 29% year over year. And we're also seeing strength across our other businesses, with hiring taking share for the 7th consecutive quarter. Now on to search advertising and news. We once again took share across Bing and Edge as we continue to apply this new generation of AI to transform how people search and browse. Bing reached over 140 million daily active users, and we are particularly encouraged by our momentum in mobile. Our free Copilot apps on iOS and Android saw a surge in downloads after our Super Bowl ad and are among the highest rated in this category. We also rolled out Copilot to our ad platform this quarter, helping marketeers use AI to generate recommendations for product images, headlines, and descriptions. Now on to gaming. We are committed to meeting players where they are by bringing great games to more people on more devices. We set third quarter records for game streaming hours, console usage, and monthly active devices. And last month, we added our first Activision Blizzard title, Diablo 4, to our Game Pass service. Subscribers played over 10 million hours within the first 10 days, making it one of our biggest first-party Game Pass launches ever. We were also encouraged by ongoing success of Call of Duty's Modern Warfare 3, which is attracting new gamers and retaining franchise loyalists. Finally, we are expanding our games to new platforms, bringing 4 of our fan-favorite titles to Nintendo Switch and Sony PlayStation for the first time. In fact, earlier this month, we had 7 games among the top 25 on the PlayStation Store, more than any other publisher. In closing, I'm energized about our opportunity ahead as we innovate to help people and businesses thrive in this new era. With that, let me turn it over to Amy.
Thank you, Satya, and good afternoon, everyone. Our third quarter revenue was $61.9 billion, up 17%, and earnings per share was $2.94, up 20%. Results exceeded expectations, and we delivered another quarter of double-digit top and bottom line growth, with continued share gains across many of our businesses. In our commercial business, bookings increased 29% and 31% in constant currency, significantly ahead of expectations, driven by Azure commitments with an increase in average deal size and deal length, as well as strong execution across our core annuity sales motions. In Microsoft 365, suite strength contributed to ARPU expansion for our Office commercial business, although new business growth continued to moderate for standalone products sold outside the Microsoft 365 suite. Commercial remaining performance obligation increased 20% and 21% in constant currency to $235 billion. Roughly 45% will be recognized in revenue in the next 12 months, up 20% year over year. The remaining portion, recognized beyond the next 12 months, increased 21%. And this quarter, our annuity mix increased to 97%. In our consumer business, PC market demand was slightly better than we expected, benefiting Windows OEM, while advertising spend landed relatively in line with our expectations. In gaming, we also saw better than expected performance of Activision titles, benefiting Xbox content and services. At a company level, Activision contributed a net impact of approximately 4 points to revenue growth, was a 2-point drag on operating income growth, and had a negative 4-cent impact to earnings per share. A reminder that this net impact includes adjusting for the movement of Activision content from our prior relationship as a third-party partner to first-party, and also includes $935 million from purchase accounting adjustments, integration, and transaction-related costs. FX did not have a significant impact on our results and was roughly in line with our expectations on total company revenue, segment-level revenue, COGS, and operating expense growth. Microsoft Cloud revenue was $35.1 billion and grew 23%, ahead of expectations. Microsoft Cloud gross margin percentage decreased slightly year over year to 72%, a bit better than expected. Excluding the impact of the change in accounting estimate for useful lives, gross margin percentage increased slightly, driven by improvement in Azure and Office 365, even with the impact of scaling our AI infrastructure, partially offset by sales mix shift to Azure. Company gross margin dollars increased 18% and gross margin percentage increased slightly year over year to 70%. Excluding the impact of the change in accounting estimate, gross margin percentage increased roughly 1 point, even with the impact from the purchase accounting adjustments, integration, and transaction-related costs from the Activision acquisition. Growth was driven by the improvement in Azure and Office 365 just mentioned, as well as sales mix shift to higher margin businesses. Operating expenses increased 10% with 9 points from the Activision acquisition. At a total company level, headcount at the end of March was 1% lower than a year ago. Operating income increased 23% and operating margins increased roughly 2 points year over year to 45%. Excluding the impact of the change in accounting estimate, operating margins increased roughly 3 points, driven by the higher gross margin noted earlier and improved operating leverage through continued cost discipline. Now to our segment results. Revenue from productivity and business processes was $19.6 billion and grew 12% and 11% in constant currency, in line with expectations. Office commercial revenue grew 13% and 12% in constant currency. Office 365 commercial revenue increased 15%, in line with expectations, driven by healthy renewal execution, ARPU growth from continued E5 momentum, and early Copilot for Microsoft 365 progress. Paid Office 365 commercial seats grew 8% year over year, with installed base expansion across all customer segments. Seat growth was again driven by our small and medium business and frontline worker offerings, although growth continued to moderate in SMB. Office commercial licensing declined 20% and 18% in constant currency, with continued customer shift to cloud offerings. Office consumer revenue increased 4%, slightly below expectations. Microsoft 365 subscriptions grew 14% to 80.8 million. LinkedIn revenue increased 10% and 9% in constant currency, ahead of expectations, driven by slightly better than expected performance in our premium subscriptions and Talent Solutions businesses. However, in Talent Solutions, bookings growth continues to be impacted by the weaker hiring environment in key verticals. Dynamics revenue grew 19% and 17% in constant currency, ahead of expectations. Growth was driven by Dynamics 365, which grew 23% and 22% in constant currency, with continued growth across all workloads, and better than expected new business, although bookings growth remains moderated. Segment gross margin dollars increased 11%, and gross margin percentage decreased slightly year over year. Excluding the impact of the change in accounting estimate, gross margin percentage increased slightly, driven by improvement in Office 365. Operating expenses increased 1%, and operating income increased 17% and 16% in constant currency. Next, the Intelligent Cloud segment. Revenue was $26.7 billion, increasing 21%, ahead of expectations with better than expected results across all businesses. Overall, server products and cloud services revenue grew 24%. Azure and other cloud services revenue grew 31%, ahead of expectations, while our AI services contributed 7 points of growth, as expected. In the non-AI portion of our consumption business, we saw greater than expected demand broadly across industries and customer segments, as well as some benefit from a greater than expected mix of contracts with higher in-period recognition. In our per-user business, the enterprise mobility and security install base grew 10% to over 274 million seats, with continued impact from the growth trends in new standalone business noted earlier. In our on-premises server business, revenue increased 6%, ahead of expectations, driven by better than expected renewal strength, particularly for contracts with higher in-period revenue recognition. Enterprise and partner services revenue decreased 9% on a strong prior year comparable for enterprise support services. Segment gross margin dollars increased 20%, and gross margin percentage decreased slightly year over year. Excluding the impact of the change in accounting estimate, percentage increased slightly, primarily driven by the improvement in Azure noted earlier, even with the impact of scaling our AI infrastructure, partially offset by sales mix shift to Azure. Operating expenses increased 1%, and operating income grew 32%. Now to more personal computing. Revenue was $15.6 billion, increasing 17%, with 15 points of net impact from the Activision acquisition. Results were above expectations, driven by better than expected performance in gaming and Windows OEM. Windows OEM revenue increased 11% year over year, ahead of expectations, primarily driven by the slightly better PC market noted earlier, as well as mix shift to higher monetizing markets. Windows commercial products and cloud services revenue increased 13% and 12% in constant currency, below expectations, with impact from the growth trends in new standalone business noted earlier, as well as lower in-period revenue recognition from the mix of contracts. Devices revenue decreased 17% and 16% in constant currency as we remained focused on our higher margin premium products. Overall, Surface demand was slightly lower than expected. Search and news advertising revenue ex-TAC increased 12%, ahead of expectations, with continued volume growth and increased engagement on Bing and Edge. And in gaming, Revenue increased 51% and 50% in constant currency, with 55 points of net impact from the Activision acquisition. Results were ahead of expectations, primarily driven by Call of Duty. Xbox content and services revenue increased 62% and 61% in constant currency, with 61 points of net impact from the Activision acquisition. Xbox hardware revenue decreased 31% and 30% in constant currency. Segment gross margin dollars increased 27% and 26% in constant currency, with 13 points of net impact from the Activision acquisition. Gross margin percentage increased roughly 4 points year over year, primarily driven by sales mix shift to higher margin businesses. Operating expenses increased 41%, with 43 points from the Activision acquisition. Operating income increased 16% and 15% in constant currency. Now, back to total company results. Capital expenditures, including finance leases, were $14 billion to support our cloud demand, inclusive of the need to scale our AI infrastructure. Cash paid for PP&E was $11 billion. Cash flow from operations was $31.9 billion, up 31%, driven by strong cloud billings and collections. Free cash flow was $21 billion, up 18% year over year, reflecting higher capital expenditures to support our cloud and AI offerings. This quarter, other income and expense was negative $854 million, lower than anticipated, driven by losses on investments accounted for under the equity method. Our effective tax rate was approximately 18%. And finally, we returned $8.4 billion to shareholders through dividends and share repurchases. Now, moving to our Q4 outlook, which, unless specifically noted otherwise, is on a U.S. dollar basis. First, FX. Based on current rates, which reflect the recent strengthening of the U.S. dollar, we now expect FX to decrease total revenue and segment-level revenue growth by less than 1 point. When compared to our January guide for Q4 FX, this is a decrease to total revenue of roughly $700 million. We expect FX to decrease COGS growth by approximately 1 point and operating expense growth by less than 1 point. In commercial bookings, we expect solid growth on a relatively flat expiry base, driven by continued strong commercial sales execution. As a reminder, larger long-term Azure contracts, which are more unpredictable in their timing, can drive increased quarterly volatility in our bookings growth rate. Microsoft Cloud gross margin percentage should decrease roughly 2 points year over year. Excluding the impact from the change in accounting estimate, Q4 cloud gross margin percentage will be down slightly, as improvement in Azure, inclusive of scaling our AI infrastructure, will be offset by sales mix shift to Azure. We expect capital expenditures to increase materially on a sequential basis, driven by cloud and AI infrastructure investments. As a reminder, there can be normal quarterly spend variability in the timing of our cloud infrastructure buildouts and the timing of finance leases. We continue to bring capacity online as we scale our AI investments with growing demand. Currently, near-term AI demand is a bit higher than our available capacity. Next, to segment guidance. In productivity and business processes, we expect revenue to grow between 9 and 11% in constant currency, or $19.9 to $20.2 billion US dollars. In Office Commercial, revenue growth will again be driven by Office 365, with seat growth across customer segments and ARPU growth primarily through E5. We expect Office 365 revenue growth to be approximately 14% in constant currency. We continue to progress with adoption of Copilot for Microsoft 365 and remain excited for the long-term growth opportunity. In our on-premises business, we expect revenue to decline in the mid to high teens. In Office Consumer, we expect revenue growth in the low to mid-single digits, driven by Microsoft 365 subscriptions. For LinkedIn, we expect revenue growth in the mid to high single digits, driven by continued growth across all businesses. And in Dynamics, we expect revenue growth in the low to mid-teens, driven by Dynamics 365. For both LinkedIn and Dynamics, the continued bookings growth moderation noted earlier is a headwind to Q4 revenue growth. For Intelligent Cloud, we expect revenue to grow between 19 and 20% in constant currency, or $28.4 to $28.7 billion US dollars. Revenue will continue to be driven by Azure, which, as a reminder, can have quarterly variability primarily from our per-user business and in-period revenue recognition, depending on the mix of contracts. In Azure, we expect Q4 revenue growth to be 30 to 31% in constant currency, or similar to our stronger-than-expected Q3 result. Growth will be driven by our Azure consumption business and continued contribution from AI, with some impact from the AI capacity availability noted earlier. Our per-user business should see benefit from Microsoft 365 suite momentum, though we expect continued moderation in seat growth rates given the size of the installed base. In our on-premises server business, we expect revenue growth in the low to mid-single digits with continued hybrid demand, including licenses running in multi-cloud environments. And in enterprise and partner services, revenue should decline in the mid to high single digits on a high prior year comparable for enterprise support services. In more personal computing, we expect revenue to grow between 10 and 13% in constant currency, or 15.2 to 15.6 billion US dollars. Windows OEM revenue growth should be in the low to mid-single digits as PC market unit volumes continue at pre-pandemic levels. In Windows commercial products and cloud services, customer demand for Microsoft 365 and our advanced security solutions should drive revenue growth in the mid-single digits. As a reminder, our quarterly revenue growth can have variability, primarily from in-period revenue recognition, depending on the mix of contracts. In devices, revenue should decline in the mid-teens as we continue to focus on our higher-margin premium products. Search and news advertising ex-TAC revenue growth should be in the low to mid-teens, driven by continued volume strength. This will be higher than overall search and news advertising revenue growth, which we expect to be relatively flat. And in gaming, we expect revenue growth in the low to mid-40s, including approximately 50 points of net impact from the Activision acquisition. We expect Xbox content and services revenue growth in the high 50s, driven by approximately 60 points of net impact from the Activision acquisition. Hardware revenue will decline again year over year. Now, back to company guidance. We expect COGS between 19.6 to 19.8 billion US dollars, including approximately $700 million from purchase accounting, integration, and transaction-related costs from the Activision acquisition. We expect operating expense of 17.15 to 17.25 billion US dollars, including approximately $300 million from purchase accounting, integration, and transaction-related costs from the Activision acquisition. Therefore, we now expect full-year FY24 operating margins to be up over 2 points year over year, even with our cloud and AI investments, the impact from the Activision acquisition, and the headwind from the change in useful lives last year. This operating margin expansion reflects the hard work across every team to drive efficiencies and maintain disciplined cost management, knowing we will continue to grow our cloud and AI investments next year. Other income and expense should be roughly negative $850 million, as interest income will be more than offset by interest expense and losses on investments accounted for under the equity method. As a reminder, we are required to recognize gains or losses on our equity investments, which can increase quarterly volatility. We expect our Q4 effective tax rate to be approximately 18%. Now, I'd like to share some closing thoughts as we look to the next fiscal year. We continue to focus on building businesses that create meaningful value for our customers, and therefore significant growth opportunities for years to come. In FY25, that focus and execution should again lead to double-digit revenue and operating income growth. To scale to meet the growing demand signal for our cloud and AI products, we expect FY25 capital expenditures to be higher than FY24. These expenditures over the course of the next year are dependent on demand signals and adoption of our services, so we will manage that signal through the year. We will also continue to prioritize operating leverage, and therefore, we expect FY25 operating margins to be down only about 1 point year over year, even with our significant cloud and AI investments, as well as a full year of impact from the Activision acquisition. We are leading the AI platform wave and are committed to bringing that value to our global customers as we enter the final quarter of our fiscal year. With that, let's go to Q&A, Brett.
Thanks, Amy. We'll now move over to Q&A. Out of respect for others on the call, we request that participants please only ask one question. Operator, can you please repeat your instructions?
Thank you. Ladies and gentlemen, if you would like to ask a question, please press star 1 on your telephone keypad, and the confirmation tone will indicate your line is in the question queue. You may press star 2 if you would like to remove your question from the queue. For participants using speaker equipment, it may be necessary to pick up your handset before pressing the start keys. And our first question comes from the line of Keith Weiss with Morgan Stanley. Please proceed.
Excellent. Thank you guys for taking the question, and congratulations on a fantastic quarter. A lot of excitement in the marketplace around generative AI and the potential of these technologies, but there's also a lot of investment going on behind them. It looks like Microsoft's on track to ramp CapEx over 50% year on year this year to over $50 billion. And there's media speculation of more spending ahead, with some reports talking about like a $100 billion data center. So obviously investments are coming well ahead of the revenue contribution, but what I was hoping for is that you could give us some color on how you as the management team try to quantify the potential opportunities that underlie these investments, because they are getting very big. And maybe if you give us some hints on whether there's any truth to the potential of like a $100 billion data center out there. Thank you so much.
Thank you, Keith, for the question. Let me start, and then Amy, you can add. At a high level, the way we, as a management team, talk about it is there are two sides. There is training and there's given that we want to be a leader in this big generational shift and paradigm shift in technology, that's on the training side. We want to be able to allocate the capital required to essentially be training these large foundation models and stay on the leadership position there. And we've done that successfully all the way today, and you've seen it flow through our P&L, and you can continue to see that going forward. Then Amy referenced what we also do on the inference side, which is one, we first innovate and build products. And of course, we have an infrastructure business that's also dependent on a lot of ISVs building products that run on our infrastructure. And it's all going to be demand-driven. In other words, we track very closely what's happening with inference demand. And that's something that we'll manage, as Amy said in her remarks, very, very closely. So we feel, and obviously we've been doing this, quite frankly, Keith, for now multiple years. So this is not the quarter. I realize in the news it's a lot more in the quarter nowadays, but if you look at it, we've been doing what is essentially capital allocation to be a leader in AI for multiple years now. And we plan to sort of essentially keep taking that forward.
And Keith, I do think it's important to really think about our planning cycles, and we do talk about spending sequentially higher, and we look forward to being able to continue to build out the infrastructure needed to meet the demand. Another thing that you really asked in the beginning was the opportunity and the size of that. And I think in some ways, it's important to think about every business process that can be impacted and the opportunity that's represented by every business process. And so when you think of it that way, I think the opportunity is significant. The opportunity to power that next wave of quote-unquote cloud infrastructure is important. It's important because we've been the leader through this decade of the cloud transition, and it's important for us to confidently invest to do that in the second wave, building on our success in the first. And I think that's really the best way to think about how we'll spend, is the same way we approached it for a decade. Watch the signal, invest to be a leader in the technical foundation, and then execute consistently to add value to customers. The opportunity is represented by the amount of value we add. And I look forward to being able to continue to deliver that.
Excellent. Thank you so much.
Thanks, Keith. Operator, next question, please.
The next question comes from the line of Brent Thill with Jefferies. Please proceed.
Satya, how would you characterize the demand environment? On one hand, you have bookings and Azure both accelerating year over year in the quarter, but we're seeing a lot of future concern and hesitation from other vendors we all cover. So I think everyone loves to get your sense of budget health for customers this year.
A great question, Brent. There are a couple of things that I would say. On the Azure side, which I think is what you specifically asked, we feel very, very good about we're fundamentally a share taker there, because if you look at it from our perspective at this point,
Azure has become a port of call for pretty much anybody who is doing any AI project. So that's sort of been a significant help for us in terms of acquiring even new customers. Some of the logos I even referenced in my remarks are new Azure customers. So that's one. The second thing that we're also seeing is AI just doesn't sit on its own. So AI projects obviously start with calls to AI models, but they also use a vector database. In fact, Azure Search, which is really used by even ChatGPT, is one of the fastest growing services for us. We have Fabric integration to Azure AI, and so Cosmos DB integration. So the data tier, the dev tools is another place where we are seeing great traction. So we are seeing adjacent services in Azure that get attached to AI. And lastly, I would say migrations to Azure as well. So this is not just all an AI story. We are also looking at customers. I mean, this is something that we have talked about in the past, right? Which is, there's always an optimization cycle, but there's also, as people optimize, they spend money on new project starts, which will grow, and then they'll optimize. So it's a continuous side of it. So these are the three trends that are playing out on Azure in terms of what at least we see on demand side.
Thank you. Thanks, Brent. Operator, next question, please.
And the next question comes from the line of Mark Mordler with Bernstein Research. Please proceed.
Thank you very much for taking my question, and congratulations on the quarter and the guidance. I want to follow up on the AI, obviously. We're seeing companies shifting their IT spending to invest in and learn about AI rather than receiving additional budgets for AI. At some point, for AI to be transformative, as everyone expects, it needs to be accretive to spending. Satya, when do you believe AI will hit a maturity level where it will be net increase to IT or outside of IT spending? And what would be the leading indicators of that maturation? And Amy, am I characterizing this correctly as it relates to Azure? Some projects are being delayed so that their spending could be shifted from core Azure toward Azure AI. Thank you.
Yeah, great set of questions, Mark. Let me just start by saying, a good place to start is to watch what's happening in terms of standard issues for software teams, right? I mean, if you think about it, they bought tools in the past. Now you basically buy tools plus Copilot, right? So you could even say that this is characterized as perhaps shift of what is OpEx dollars into effectively tools spent. Because it gives operating leverage to all of the OpEx dollars you're spending today, right? That's really a good example of, I think, what's going to happen across the board. We see that in customer service, we see that in sales, we see that in marketing, anywhere there's operations. That's why I described it as, knowledge turns. You can even think of it as lean for knowledge work, right? So because it just reduces waste, increases speed, and customer value. And so one of the interesting rate limiters here is culture change inside of organizations. When I say culture change, that means process change. And Amy referenced this even in her answer to the first question, because at the end of the day, companies will have to take a process, simplify the process, automate the process, and apply these solutions. And so that requires not just technology, but in fact companies to go do the hard work of culturally changing how they adopt technology to drive that operating leverage. And this is where you're going to see firm-level performance differences. So one of the things we see is any customer who is working closely with us, deploying it internally at Microsoft, we see it, right? We're also taking our own medicine to apply this across every process. And we know that this is not just about technology, it's about being able to have the methodology that goes with it. And so we see it in software development, we see it in customer service, we're seeing it even in the horizontal use of Copilot today, where every day people are discovering new workflows that they can optimize. And so that's like the PC when it became standard issue in the early 90s. That's the closest analogy I can come up with. And so yes, it'll take time. for it to percolate through the economy. But this is faster diffusion, faster rate of adoption than anything we have seen in the past, as evidenced even by Copilot, right? It's faster than any suite we have sold in the past. But it is going to require workflow and process change.
And Mark, maybe to answer your question on, are we seeing project start transition from maybe something that was core consumption to an AI project? In our results, that's not what we saw. We saw more what Satya was speaking to earlier, which is you see maybe growth in migrations again. You're seeing work in the data space again, and you're seeing AI project starts. And I think that's why maybe you see our growth be different, of course, than you see IT budget spend. It's because it's a share, I think, improvement, plus also really focusing on what Satya said. It's about spending maybe in other areas that we don't traditionally think of as being in the IT budget spend under a CIO. It's spend being done by the head of customer service. It's spend being done by the head of marketing. And I do think that will be important as we think about the opportunity ahead.
Incredibly helpful. Thank you both.
Thanks, Mark. Operator, next question, please.
The next question comes from the line of Karl Kierstead with UBS. Please proceed.
Thank you, and Satya and Amy, congrats on these outstanding Azure results. I'd love to hone in a little bit on the 7-point lift to Azure growth from AI. Outstanding number, but it's leveling off a little bit from 6 points in December. I'm wondering if you could unpack that a little bit. To what extent did the capacity issues that you, Amy, highlighted on the call impact that number? Is there any seasonality? I wouldn't think so. Or any other factor that can swing around that number that you'd advise us to keep in mind? Thanks so much.
Thanks, Carl. There's not a seasonality to the number, so you're absolutely right to start there, and it's a good question. The way to think about it is a bit more how much capacity we have in play and how much capacity that we have to sell on the inferencing side in particular. And so that is partially why you see the capital investment in the shape that it is because right this minute we do have demand that exceeds our supply by a bit. So it is fair to say that could have been an impact on the number for the quarter and does impact a little bit the number in Q4.
Okay, helpful. Thank you.
Thanks, Carl. Operator, next question, please.
And the next question comes from the line of Raimo Lenschow with Barclays. Please proceed.
Thank you. I have more conceptual question for Satya. If you think about Copilot and what you're doing there, you're kind of impacting a lot of different businesses and the opportunities seem very broad-based. How do you think this will play out in the industry between you guys offering certain Copilots versus like the rest of the industry following, and everyone seems to have a Copilot now and seems to be talking about that? How does that impact what you want to do, your partner strategy going forward? Thank you.
Yeah, it's a great question. So the way we see it play out is, if you think about it, the way Office was used broadly for knowledge work was in the context of business process, right? So it's not like when people do knowledge work, they're not doing knowledge work. They're doing knowledge work in support of making progress in the context of sales enablement, customer service, revenue ops, supply chain, or what have you, right? So that's the first thing to know. And they do it inside of email, they do it inside of Teams, they do it inside of Excel, PowerPoint, Word, and what have you. Now we have the ability to essentially bridge the work and the work artifacts inside of these knowledge worker tools with the workflow and the business process and the business process data. So when we think about our Copilot has that ability to integrate, whether it's with ServiceNow, where it has the ability to integrate with SAP, with Salesforce, with obviously Dynamics. That's what we are seeing. In fact, you'll hear us talk a lot about it at our developer conference, which is the extensibility. And Copilot Studio is really off to the races in terms of the product, and most people are excited because one of the things in the enterprise is you want to ground your Copilot with enterprise data, which is in all of these SaaS applications, and Copilot Studio is the tool to use it. To make that happen. And so that's what we're seeing, which is we are building a Copilot, which also happens to be an orchestrator of all these other Copilots, which to us appear as extensions. And net, what happens is some of these knowledge worker tools that people have used all the time, right? Because when you think about teams, when you're having a meeting, you're not doing a random meeting. The meeting is in the context of some business process. It could be a supply chain, meeting where you're trying to understand which suppliers to bet on or what terms to do. And so now you can access all of that data right in the team's context. So that's, I think, what's exciting for us, having built all these horizontal tools, which I would say were underappreciated for the amount of work. How people use those tools to make progress on business process, but we now get to bridge that between the business applications and knowledge worker tools more horizontally.
Okay, perfect. Thank you. Congrats from me as well.
Thanks, Raimo. Operator, next question, please.
And the next question comes from the line of Michael Turin with Wells Fargo. Please proceed.
Hey, great. Appreciate you taking the question. I wanted to go back to Azure. You've been hinting at stabilization there for the past couple of quarters. Still, very good to see the bounce. Maybe you can expand on just what the commercial bookings number, appreciating the variability there, does in terms of visibility, and any characterization you can give us around what you're seeing in areas like cost optimization and core workload growth coming back is just helpful context for us in unpacking the numbers. Thank you.
Thanks, Michael. I may take those a bit in reverse. It's a little easier to address them. When you think about, we've been talking about sort of stabilization, and what you saw this quarter, if you break down the Azure number, is you saw, which I think I talked a little bit about with Carl, was 7 points of contribution from AI, and you could call then the difference 24 from our core, really Azure business. And within that, the activity we saw on the consumption side was really this balance that we were quite used to and have seen throughout the cloud transition. We saw new workload starts, and we saw optimizations. And then those optimizations create new budget, and you apply it. And that cycle, which is actually quite normal, we saw it again this quarter in a balanced way. And I think so when we talk about stabilization, or even what we saw between Q2 and Q3, which is a bit of acceleration in that core, was a lot of the newer project starts relating back to not just AI starts, but lots of other workflows that companies are still going from on-prem to cloud. That's why Satya mentioned migrations. And some of that, which I know isn't as exciting as talking about all the AI projects, this is still really foundational work to allow companies to take advantage of the cost savings. And the total TCO is still really good. And so I think that balance is really what you saw this quarter. And I feel like there wasn't really a big difference, Michael, across industries or across geos. So I would say it was actually pretty consistent, is the other maybe texture that I could give you to that question. And so then when you're saying, do we keep sort of pointing to stabilization, I really do look sort of workload to workload. What are we seeing? Where are starts? And this one actually felt quite balanced, and optimizations looked like they normally would, which, by the way, is super important. It's something we encourage customers to do. You want to run your workloads as efficiently as you possibly can. It's critical to customers being able to grow and get value out of that. So I sometimes think you all may ask the question more as a negative, and for us, it's just about a healthy cycle at the customer account level.
Now, consistent core cloud growth is still pretty exciting to us as well. Thank you.
Thank you.
Thanks, Michael. Operator, next question, please.
The next question comes from the line of Kirk Materne with Evercore ISI. Please proceed.
Yes, thanks for taking the question. I'll add my congrats on the quarter. Satya, I was wondering if you could chime in on a discussion that comes up a lot with investors, which is, is there a sort of data quality problem in the market in terms of being able to take advantage of all these new Gen AI capabilities? And I was just curious if you could comment on, do you see companies making inroads on sort of addressing that? And do you see that as sort of an inhibitor to AI growth at all at this point? Thanks.
Yeah, it's a great question, because there are two sets of things in order to make sense of or successful deployment of these new AI capabilities. I mean, if you sort of say this, what is this AI? It does two things, right? There's a new user experience, there's a natural language interface, and second thing is it's a reasoning engine. And the reasoning engine requires good data, and it requires good data for grounding, right? People talk about something called retrieval augmented generation, and in that context, having good grounding data that then helps with the reasoning, I think, is helpful. And then, of course, people are also looking to sort of fine-tune or RLHF or essentially take the large model and ground it further. So all of these tools are now available. The sophistication of how people can deploy these models across various business processes where there is data and where there is tuning of these models is also getting more widespread. Even as system integrators and other developers are there to help enterprises. So all that's mature. So we feel good. And this is where I think on the commercial side, these are some of the harder problems to solve, broad consumer, right? I mean, I think there's a couple of orders of magnitude of improvements in, I'll call it, our models before we can sort of have more sophisticated, open-ended consumer scenarios. Whereas in the enterprise, these are all things we can go tackle. Again, I point to GitHub. If you think about how it's not an entire system, right? It's just not an AI model. It's the AI, or the user experience scaffolding, the editor, the chat, the interpreter, and the debugger work along with the continuations of the model to help essentially create these reasoning traces which help the entire thing work. And effectively what we're doing with Copilot, Copilot Studio, and connectors to all these business systems, think of it as we're creating GitHub Copilot-like scenarios for every business system. That's what I think is going to have both what Amy references, business value and better grounding. But you're absolutely right in saying a lot of work we're doing with Fabric or Cosmos or Postgres or SQL is about preparing that data so that it can be integrated with these AI projects.
Thank you.
Thanks, Kurt. Operator, we have time for one last question.
And our last question will come from the line of Alex Zukin with Wolfe Research. Please proceed.
Hey, guys. Thanks for taking the question. I wanted to ask the AI question, but from a Microsoft 365 Copilot perspective. I think you talked a little bit about starting to see some of those impacts positively in the quarter on the Office business. I wanted to ask more broadly around that capacity constraint that you alluded to in your prepared remarks, Amy, and kind of how does the easing, how tight are we, like, as you invest for that CapEx and bring more of the capacity online, how much does that unblock or unlock the ability to deliver both a higher Azure AI number as well as a higher Microsoft 365 Copilot number?
Thanks for the question. It's a good opportunity to clarify. And I would not say that there is a capacity constraint on the Copilot. It's a real priority for us to make sure we optimize the allocation of our capacity to make sure that those per user businesses are able to continue to grow. And so think about that as our priority one. And so then what that does mean is capacity constraints, when we have them, you'll tend to see them on the Azure infrastructure side, the consumption side of the business is a better way of thinking about it.
Perfect. Thank you.
Thanks, Alex. That wraps up the Q&A portion of today's earnings call. Thank you for joining us today, and we look forward to speaking with all of you soon.
Thank you all.
Thank you.
This concludes today's conference. You may now disconnect your lines at this
Welcome, traveler. May Itera smile on you. Welcome, traveler. May Terra smile upon you.
has come. Death will not take me! Death will not take me!
We'll hear argument next in case 2350, Cheverini versus the City of Napoleon. Ms. Anand?
Mr. Chief Justice, and may it please the Court. Everyone in this case now agrees that as the lack of probable cause element of a malicious prosecution claim under the Fourth Amendment, the charge-specific rule governs. That is, the plaintiff may make out a malicious prosecution claim by proving that one charge is not supported by probable cause, even if other charges are, provided, of course, that the plaintiff also makes out the other elements of the claim. As no one appears to dispute, that charge-specific rule is supported, as Chief Judge Pryor put the point, by both centuries of common law and by bedrock Fourth Amendment principles. That's all this Court needs to address to resolve this case. Respondents urge this Court to go beyond that ruling to weigh in on a series of open questions about a different element of the Fourth Amendment malicious prosecution claim that resulted in a seizure element. No one disputes Mr. Cheverini is going to have to prove that on remand. But weighing in on the kind of precise contours of that question would require this Court to go beyond the question presented to address issues not aired at all below, that haven't percolated in the courts of appeal, and to do so on the sort of briefing that doesn't have the kinds of text, history, common law arguments that you'd expect before weighing in on an element of a constitutional tort. As in Thompson, this case involves a narrow dispute over one element of a Fourth Amendment malicious prosecution claim. This Court should simply hold that a plaintiff can make out a claim by showing that at least one charge lacks probable cause, again assuming they can make out the other elements of the claim, and remand for consideration of everything else. I welcome this Court's questions.
Well, what do you have to show, if anything, about causation? If you have a situation where you've got three allegations and two are concededly valid and they justify the seizure, you still get relief? Don't you have to show some kind of causation?
Yes, Your Honor. So we agree there has to be some kind of causation, and we think the formulation in Thompson is correct. You have to show that the malicious prosecution resulted in a seizure. Our position is that if you want to weigh in on precisely what the counterfactual is, the 11th Circuit's position is correct, that the correct counterfactual is, could this have been done as a warrantless arrest? So the 11th Circuit
What's it?
Could the plaintiff have been seized for this length of time or seized for this length of time based on a warrantless arrest? And so the way the 11th Circuit articulates it is, look, this legal process was corrupted. We know this legal process was necessary if the detention is longer than 48 hours, right? That's a Fourth Amendment requirement. You've got to have legal process for a detention that's longer than 48 hours. And so because this legal process was necessary, what you have to show is you prevail unless this could have been done as a warrantless arrest.
Well, I thought the evidence was that the first two of the crimes would certainly support what was done in this case without regard to the third.
So that's correct, Your Honor. Would support in the sense that a magistrate could constitutionally have signed this arrest warrant. But in fact, no magistrate did sign this arrest warrant based on just those two charges. So based on this kind of court's case law, so for instance, we cite the Eastern District of Michigan case in our opening brief, where the court says, that's the case, remember, where the Attorney General says, I can sign warrants to authorize wiretaps. This court says, surely a magistrate would have signed off on these warrants, right? Surely a magistrate would have caved to the national security concerns and signed these things. Still a Fourth Amendment violation because the magistrate didn't do so. Again, I think this is all beyond the scope of the question presented, and frankly, because there are indications from precedent and common law to support the 11th Circuit's rule, at the very least, this court shouldn't go any further than it did in Thompson in defining kind of precise contours of the resulted in the seizure element.
Are you giving up on the SG's position that, as an alternative to the 11th Circuit's view, that if you can show that you were retained for longer, or that, as you argued below, I understand, at least in one of your arguments, that you would have never been arrested, you would have been given a summons to appear as the person who sold you the jewelry was, so you would have never been in jail, that would be enough. Are you giving up on that as well?
No, Your Honor. So we think we don't have much of a dog in this fight. We think that we win under the 11th Circuit's rule. We win under the SG's rule. As between the two, we think the 11th Circuit's rule is more consistent with this court's precedent and with the common law. But again, we think that you should make that decision on the basis of some briefing about the text of the Fourth Amendment, founding era practice, common law, none of which you have before.
We shouldn't reach it, is what you're saying.
Yeah, that's right.
Well, what if I think it is subsumed within the question presented? What is wrong with the logic of the Solicitor General's position? Under Thompson, an element of the claim at issue is a seizure, and that's necessary to bring this within the Fourth Amendment. So your client was seized when he was arrested, and under Thompson, he experienced a continuing seizure during the period when he was in jail. And so the question is whether either his arrest or the length of his detention was the result of the so-called money laundering charge. I don't know why this statute is called money laundering, because it doesn't seem to have anything to do with money laundering. But what's wrong with that logic? It seems to follow step by step.
So again, Your Honor, I think we win under that test, right? So the police officer's affidavit in this case says we are seeking a warrant because there is a felony of the third degree. So I don't want to push too hard on this. I think that's a totally acceptable result from our point of view. The reason that we think that it's not the best way to interpret that resulted in a seizure language is twofold. The first is what Williams explains is that the entire point of requiring a neutral and detached magistrate to weigh in is to give that neutral party the opportunity to weigh the law enforcement interest against the privacy interest. And so doing this sort of counterfactual, predicting what the magistrate would have done, kind of undermines that goal. And so I think the Williams rule, which basically says, look, if you could have done this as a warrantless arrest, right? If you didn't need the warrant, you didn't need to have a Gerstein hearing, you only detained him for a few hours, then it's fine if the warrant process was totally corrupt. That was just something bonus you were doing. But where the warrant was necessary to the detention, you could not have detained him for 4 days without a warrant, then we're not going to kind of peer in and try to figure out, would the magistrate have reached this exact same result if it knew the actual charges against?
What if the other charges on which there was probable cause were also felonies, maybe even more serious felonies than the so-called money laundering charge? Would you make the same argument?
So I don't think we'd be able to make the same argument about why we win under the United States' rule. But I think that the 11th Circuit.
But you think you should win anyway?
I think under the 11th Circuit's rule, that's the defensible. And you can imagine, right? I mean,
Why?
some of them are.
I mean, why? What if one of the charges is murder, and there's probable cause to support the murder charge, and then they throw in this money laundering charge? Or let's say it's an assault, and let's say there's a video when the legitimate owners of the ring came to the store and they were causing a fuss, and the client pulled out a gun, and he said, "Get out of my store! I'm going to blow your head off." So he's charged with an assault as well as money laundering. Same result?
So, just as a preface, I think that this is the reason you should let these rules percolate, right? We should figure out how these rules actually play out in practice. The reason I think it's the same result, what the Williams court would say is, there's a reason police officers lied about this charge, right? And so we're going to assume that they lied about it in part because they needed it to be able to detain the person.
Well, you may be. This is the facts of this case are disturbing, and you may well win, but we're talking about what the general rule should be. So your rule would apply in a case where the police officers act in good faith, but they just don't have probable cause. And it's not limited to a case in which there was perjury or the manufacture of false evidence, right? Your rule is not limited in that way.
So that's correct, but we think that another element, right, the mens rea element, which this court hasn't weighed in on yet and on which there's a circuit split, is the proper element to do the filtering that Your Honor is talking about. And the reason why I think the more serious, less serious charge rule, so to be clear, I think that's a rule we could certainly live with. We win under that rule. There's some evidence in the common law. The Newell Treatise, for instance, seems to suggest that the charge lacking probable cause should be the more serious charge. So we think there's some warrant for it. But the reason we don't think it's the best option is because you can imagine a situation, for instance, where the felony charge is a white-collar offense on which, no one's ever going to be detained. The misdemeanor's a resisting arrest charge, and and the magistrate says, that indicates some kind of dangerousness, that's the reason I'm going to detain him. And so I don't think you can have a kind of categorical, more serious, less serious charge rule. And again, I think what the 11th Circuit's rule does is it says, look, at the point where this legal process has been tainted, remember, this court's cases like Gerstein and County of Riverside say if there was no legal process, right, if there's no arrest or Gerstein hearing, we actually don't care if there's all the probable cause in the world.
Well, you're talking about being tainted. Now then you're back to the idea that Officer Everhoff lied, right? But what if he hadn't? I mean, what if there's just there's no indication that there's a lie, there just wasn't probable cause?
Sure, Your Honor. So I think in that circumstance, first, probable cause, remember, is a low bar, right? It's just a reasonable belief. And second, qualified immunity will almost certainly protect the officer in a situation where there's no probable cause, but even the judge is confused and thinks there's probable cause.
Yeah, well, it'll protect the officer, but it won't protect the municipality.
That's true, Your Honor. But I'm having trouble thinking of a situation where a judge signs this thing, right? Signs the arrest warrant, signs off on the Gerstein hearing, knowing all the facts the police officer accurately reported, and yet there's not even probable cause.
Can I ask you a question about the 11th Circuit rule? I just want to make sure I'm understanding it. I had thought that one distinction, and maybe it doesn't matter until you can tell me if it does, is that in Williams, it was actually the crime for which he was being detained and for which probable cause had been manufactured was the tainted crime, and the other crime for which there would have been probable cause if a warrant had been pursued was the one that had not had the adequate process. And that's a different situation than we have here, right? Because here, there was a valid warrant for the misdemeanors, right? It was just the money laundering. And so you actually had that process observed for the two misdemeanors in a way that Williams, it was kind of like, it was blank, right, on the other side. And so there was no valid process holding him. Why does that not matter? I gather you think it doesn't.
So I don't think it does, because Williams is very clear, this is at 1165, that Williams will prevail if he establishes a genuine dispute about whether at least one of the two charges against him for attempted murder, right? So remember, there's attempted murder as to two different officers. Mm-hmm. The holding is he only has to prove that one of those lacked probable cause. This is at 1165. So it's true that in Williams, there was also this uncharged offense, but Williams just says you have to prove one of the two charges in the actual arrest warrant was bogus.
Okay, and then I want to understand a distinction, or that I think is a distinction between your position and, say, the SG's. Do you agree that that you have to show a seizure for purposes of making out your claim?
So we agree that you could just continue to reiterate the Thompson language, which has resulted in a seizure. We don't think this court should use this case to go further and say that there cannot be a malicious prosecution claim predicated on, for instance, the unreasonable search clause or the warrant clause. We don't think that this is the case that tees that up.
Well, the search clause, sure, but I mean, is it going farther? We've said that before. I mean, you have to make out a Fourth Amendment claim, and here your claim is for seizure of the person, and you didn't make, I don't think, a separate claim about the seizure of his effects being unreasonable.
So below, we did argue about the seizure of his effects as well as about the unreasonable search. What's come before this court is
this one.
Yeah, and so all we're saying is that you shouldn't, and I think we agree with the SG on this. Okay. You shouldn't reach out and affirmatively say there can be no other Fourth Amendment malicious prosecution claim.
I'm sorry. Is one of your elements that you have to prove is lack of probable cause with respect to the one crime, and that caused an unreasonable seizure?
The language in Thompson is, and the malicious prosecution resulted in a seizure, which we think is consistent with any of the rules.
So you're fighting with saying that it caused an unreasonable seizure?
Yes, the malicious prosecution caused an unreasonable seizure.
Are you accepting that language, or are you fighting that language?
So I don't mean to quibble. Thompson has resulted. It is important. So I think the Thompson formulation is correct. Resulted in a seizure. The other elements get you to the unreasonable part.
What are the other elements? If it doesn't cause an unreasonable seizure,
so it must cause
why don't you just list what you think the elements are?
Right. So the appropriate mens rea, which this court hasn't resolved, favorable termination, initiation of legal process, lacking probable cause, so that's where the unreasonable part comes in, resulted in a seizure. All we're saying is don't double count the unreasonable. You don't have to prove something separate from the mens rea plus lack of probable cause.
So, Ms. Anand, I have a question about the element that brings us here today, which is the initiation of legal process lacking probable cause, right? Am I?
That's correct.
Okay, and that's separate from the causation
exactly
that we've been discussing. I guess you're now saying that everybody's on the same page that the Sixth Circuit was wrong about that. Is that
correct.
Okay. And I'm trying to understand why the Sixth Circuit was wrong, and I think I have a theory, and I'm hoping you can help me to determine whether or not I'm right about this.
Sure.
I'm wondering whether the Sixth Circuit, whether they were just taking what is a basic principle related to probable cause in another context. The other kind of Fourth Amendment claim that one might bring is the unlawful seizure, false arrest, etc. There you have no probable cause, and we would say that if there are 3 or 4 different charges being brought and your claim was unlawful arrest, when you proved lack of probable cause with respect to only one of those 3 or 4 charges, we would say, too bad, you still lose. Right? So it's sort of like the same idea that the Sixth Circuit was latching onto, because there are cases that say that, but it seems like they're in a different context. They're not malicious prosecution theory. It's the unlawful arrest theory. So it's like probable cause is doing different work depending upon the theory. Does that make any sense?
That's exactly right. So that's exactly how the Sixth Circuit justified this rule.
Yes.
It said the same rules apply to false arrest and malicious prosecution, but both at common law and in this court's Fourth Amendment cases, there has always been a distinction between the warrantless arrest context, where, as your Honor notes, doesn't matter if the officer had 1 charge or 10 charges or 0 charges in mind. What matters is if there's probable cause out there somewhere. And the legal process cases like Gerstein and Franks and County of Riverside, where you're required to specify the charges. And that's for a couple of good reasons that I'm happy to explain.
And, I mean, is one of them because the malicious prosecution context is really about the culpability of the process server. It's about the person who is initiating process maliciously. It's not really about whether you were committing bad behavior, whether you were... So in other words, you could have a person who actually is a criminal, right? He's committing crimes, but here for charges 2, 3, and 4. But if charge 1, there was no basis for it, baseless, and maliciously added on to the thing, that person would added on to the indictment, that person would still have, at least theoretically, a claim for malicious prosecution with respect to that charge.
That's exactly right, and that's reflected again in this court's Fourth Amendment cases. So to take an extreme example, Gerstein says that if you don't have process, right, no warrant, no hearing, doesn't matter if you're actually guilty of absolutely everything. It's still a Fourth Amendment violation because we care about the process. The Fourth Amendment says what makes a seizure of any duration reasonable is that someone neutral and detached weighed in and signed off on this. It's not just the police officer's discretion. And what the any crime rule would do would basically move this back into police officers' discretion if they could just lie to the magistrate about the set of charges they have on them.
So what are we disputing here? Both sides agree that the Sixth Circuit got it wrong. I guess I'm trying to understand why we're continuing on.
I don't
what is left of this case if the fundamental issue has been essentially resolved? There's no one. Should we have appointed someone on the other side of the question that was presented here?
So I don't think so because, you know, I do think respondents are arguing for an affirmance on a sort of waiver plus this other element theory. I think that this just means it's an easy opinion to write. So just last week in Sheets, this court said when there's radical agreement that the court below erred in applying a categorical premise, we leave all the kind of additional nuanced arguments for remand. I think this court should follow the same course here.
Well, radical agreement is a good thing if it exists. But I'm not quite sure there is radical agreement here. I thought the argument on the other side, which is presented in respondent's brief and also in one of the amicus briefs, which I don't have with me, is that the Sixth Circuit had a prior decision in which they essentially adopted the Solicitor General's position. And what they did here should be understood in light of that. Isn't that the argument on the other side?
So I think the other side is making two arguments. One is the one that Your Honor articulated, which is that somehow the lower court secretly was applying a different rule, but as the United States says at page 23, that description conflicts with the language of the decision below.
Yeah, okay, so there's a dispute about what they did here, whether they were following, I've forgotten the name of the earlier Sixth Circuit decision.
Hausa, yeah.
Okay, whether they were following that or not. So there's not really radical agreement, as much as one might like to have it.
So I think that there is disagreement about how the caused a seizure resulted in a seizure element works in the nuances, right? What counterfactual you run, how exactly, whether it's the legal process could or the bogus charge would have or the bogus charge could have. But that's a separate element from lack of probable cause. And I think everyone agrees that the decision below, which said because probable cause existed on at least one charge, his malicious prosecution claim fail, full stop, right? That's the holding of the decision below. Everyone agrees that's not correct. That's not the rule.
Just to clarify on the caused the seizure point, your position, say we don't reach it on remand, would be doesn't matter if it actually caused the seizure, doesn't matter if these misdemeanor offenses would have led to the same amount of the 3 days in detention. That would be your position, right?
So I'd articulate it slightly differently. Okay. I would say that the tainted legal process surely caused this seizure. So in other words, he could not have been held for 4 days, but for this arrest warrant or some other form of process.
And why? Would 3 days or 4 days?
4 days.
4 days. Okay, so would 4 days be an unreasonable length of time for a detention for the two misdemeanors?
It's not that it would be an unreasonable length of time. It's that Gerstein and County of Riverside say that length of detention must be authorized by a neutral and detached magistrate. And here, a neutral and detached magistrate didn't say you can detain him or even arrest him for this length of time, except for, without knowing that the felony charge was bogus.
So you mean, just to make sure that I understand, it's possible that he could have been held for the 4 days if the magistrate had only had in front of him the two misdemeanors. But you're saying that the presence of the third necessarily corrupts everything else, and so the causation element doesn't run there.
That's exactly right. And again, the only published circuit court case analyzing this question came to that result. So, I think, again, this court should weigh in on that question with the benefit of kind of full briefing, argument, some sort of historical analysis, and we just don't think that's presented here.
Thank you, counsel. Justice Alito?
Well, just out of curiosity, the 4 days are Friday to Monday, right? It's over the weekend?
That's correct.
What happens in the city of Napoleon? I looked up how many people there are. It's not a big city, right? What happens with people who are arrested on Friday?
So remember, County of Riverside says that a Florida statute that says you can exclude weekends from the 2-day calculation.
I mean, what happens in that town?
So,
all right, that's irrelevant. I am somewhat curious about the facts of this case. This is a crazy little incident. Why didn't your client just give the police officers the ring?
Well, Your Honor, he asked for the opportunity to consult with counsel because the hold letter was ambiguous, right? It said both hold this as evidence and return it.
I know. I mean, there's crazy behavior on both sides. But look, when the police officers are there saying, give the ring to the people who... Why doesn't he just give it to them? He paid $45 for this. What did he think was going to happen? Something bad is going to happen to me because I've got this ambiguous letter that says hold the ring or give the ring to I forget their names. Give the ring to them. Something terrible is going to happen to me if I give them this ring when the police are telling me to give them the ring?
So, Your Honor, maybe that goes to the reason why the Sixth Circuit found probable cause for the retaining stolen property charge, but it is nothing about felony money laundering.
No, I understand. I understand. And this is not really a money laundering statute, right?
That's correct, Your Honor. It's about purchasing with knowledge. And again, even if Your Honor is correct, and I just want to say that the facts aren't quite as Your Honor is suggesting they are, it certainly doesn't justify the police officers going out, doctoring a report, securing an arrest warrant, finding a way to detain him for 4 days, seizing his property.
I'm not getting it. I'm just wondering about the facts of this. What you said it wasn't as I suggested. What did I suggest that wasn't a fact?
So it wasn't that he refused to give back the jewelry. It's that he asked for time to consult with counsel before he did so.
Okay.
Justice Sotomayor?
Having worked many a Saturday night to arraign people before judges, that's what some jurisdictions do.
Justice Gorsuch?
Maybe an idiosyncratic question, but on this causation element, one way I think of it is this, that malicious prosecution in common law was all about protecting the judicial process. And so the 11th Circuit, or your view of the 11th Circuit's causation holding, makes a great deal of sense in light of that common law background. That it doesn't matter what actually happened. What mattered was the process was tainted. The problem I have is that we've thrown malicious prosecution into the Fourth Amendment context. And the seizure's got to come around someplace in the Fourth Amendment, because that's what it says, right? And that's where I struggle on how to put those two things together, because to me, a malicious prosecution claim naturally flows from the Due Process Clause. And it wouldn't require you to show anything other than the process was tainted. So help me out with that. But that's not what we've done. Okay,
So
that battle's been lost. I understand that.
Setting aside this court's cases, I do think that Gerstein and County Riverside say as a matter of the Fourth Amendment process matters, right? So Gerstein says, yes, you can make a warrantless arrest, but you've got to bring the person in front of a magistrate as soon as possible, certainly no longer than 48 hours. And Gerstein doesn't say, and it's okay if you actually did the crime, no need to bring them before the magistrate. It wants the process, even if the...
I'm wholly with you on due process,
But
right? As a matter
Gerstein's-
of process.
So, but I'll just say Gerstein situates that right in the Fourth Amendment.
Okay, all right. Let me ask you another idiosyncratic question. So you brought a straight-up malicious prosecution claim under the common law in count one, your client did. Also brought this Fourth Amendment hybrid thing in count three, I think it was, and got removed to federal court. I don't understand why. Malicious prosecution in state law is a pretty easy tort to prove. Not always, but you might have had a really good shot and got punitive damages and your attorney's fees and everything. Why are we making a federal case out of this?
Well, Your Honor, again, setting aside this court's recent cases saying we're entitled to do that.
I'm not questioning them. I'm not questioning
Sure.
them. I'm just asking purely strategically. I've struggled to understand why some of these cases wind up in federal court when, as an old plaintiff's lawyer, I might have wanted to bring them in front of a
keep them in
state.
state court. So there's a couple of reasons, just speaking at a high level of generality. So many states don't allow malicious prosecution against law enforcement. So like California doesn't allow that. In many states, there's a heightened mens rea. So in the Sixth Circuit, the mens rea for the federal malicious prosecution tort is lower than for the state malicious prosecution tort.
Can you tell me a little bit about that? What is that split?
I can't tell you the precise split, which is that the Fourth, Sixth, and D.C. circuits say that the mens rea element is purely objective. Other circuits have imposed some sort of malice or heightened requirement.
An objective mens rea. Okay, got it. All right. And did you have anything else you wanted to add? I'm sorry, I interrupted you.
All I wanted to say on that front is just that it was all right to bring the Fourth Amendment malicious prosecution case, and that's not just from Thompson and Manuel, where I understand that Your Honor disagrees, but dating back to Gerstein and County of Riverside from the 80s and 90s, saying, and Justice Scalia explains it, that the idea of a reasonable seizure at the time of the founding, what the framers anticipated was you arrest someone, you bring them before the magistrate right away. That's what constitutes a reasonable seizure. So this is a matter of what is a reasonable seizure, not just as a function of the Due Process Clause.
Thank you.
Justice Kavanaugh? Justice Barrett? Justice Jackson? Thank you, counsel. Mr. Suri?
Mr. Chief Justice, and may it please the Court, I'd like to address Justice Alito's and Justice Jackson's questions about what exactly everyone is fighting about here today. I think the main disagreement is about how far the Court ought to go in its opinion and what issues it should decide. I understood Petitioner to be saying that the Court should say simply that it is possible to bring a Fourth Amendment malicious prosecution claim even when a valid charge is accompanied by a baseless charge, and to stop there. We think it's important for the court to take one step further and to say that the plaintiff bears the burden of proving that the baseless charge caused an unreasonable seizure. That's an important step to take because if there's no unreasonable seizure, there's no violation of the Fourth Amendment. But it's also not a significant step to take because you'd just be reaffirming what you've already said in Thompson. Now, I understand respondents to ask the court to take one step further still and to determine that the seizure in this particular case was reasonable. But we don't think the court should reach that question because it hasn't been the focus of the briefing and wasn't passed on below. I welcome the court's questions.
Would your formulation leave open the 11th Circuit rationale?
Yes, it would leave open the 11th Circuit rationale. We do think that, as Justice Barrett was...
But she fought on that, and she may, in reply, explain, but yes. Why do you think she fought it?
We think that the 11th Circuit...
It's an unfair question, but...
We think the 11th Circuit rationale makes sense in the context where there is an uncharged crime for which there was probable cause, and the police officer wants to defend manufacturing the crime that was charged on the ground that there was also this uncharged crime. We don't think the 11th Circuit rationale makes sense in the context where there are multiple charges on which the magistrate did pass, and it turns out there was no probable cause for one of them. We don't think the court needs to get into that issue in order to resolve this case.
In this case, there is evidence from which one could infer that the magistrate would not have issued an arrest warrant were it not for a felony charge as to which there was not probable cause. But it does strike me that in many other cases, it would be very difficult, and I don't know how a plaintiff would prove that the charge that for which there was no probable cause was the one that resulted in the decision to arrest as opposed to just issue a summons.
Justice Alito, I appreciate that it may be difficult for the plaintiff to make that showing, and since it's an element of the claim, the failure to make the showing would mean that the plaintiff would lose. But I could point out a few ways in which a plaintiff might be able to make that showing. First, if there's a bail determination and the judge sets higher bail because of a felony charge that was added to a misdemeanor charge, but it turns out that the felony charge was fabricated, that might be a circumstance where it's possible to show that the felony charge was the cause of the detention. In addition, state law might provide that certain minor offenses result only in a citation or a summons, but more serious offenses can result in pretrial detention. That's another way in which the plaintiff could make that showing. Ultimately, however, it would depend on the facts and circumstances of the case.
Presumably, the plaintiff would not be able to depose the magistrate and ask the magistrate, what would you have done?
That's right, Justice Alito. We see this kind of inquiry in other areas of criminal procedure. For example, in an ineffective assistance of counsel claim, you ask, what would the court have done but for counsel's error? Or in a Brady claim, what would the jury have done but for the suppression of particular evidence? And you don't have people deposing the judge or the jury. You just ask objectively what would have happened in those circumstances. We envision a similar inquiry here.
So would it be, to make sure that I understand your response to Justice Alito, because I was trying to figure out from your brief exactly what your position was and if it was distinct from respondents. You see it as kind of a but-for inquiry. Like you don't see it as asking, would it have been reasonable to detain him, say, for 4 days based on these two misdemeanors? You think the right inquiry is to say, would he in fact have said 4 days is sufficient?
Would the magistrate, in fact, have authorized the additional detention? And the bail example might make that particularly clear, what the distinction between us and respondents would be. We would say, if the magistrate says, I'm issuing this higher bail, which it turns out the defendant can't pay because of the felony charge, that should be enough to show that that's an unreasonable seizure if the felony was a fabricated charge. But I take respondents to be saying that if the magistrate could have simply denied bail outright as a matter of federal constitutional law, then there's no Fourth Amendment violation.
But just to make sure I have this right, you do not think that we should engage on that issue?
Correct.
And why not?
It's not been the focus of the briefing, and it's not what the court below decided. In addition, the unreasonable seizure question raises a variety of nuanced issues. For example, distinguishing between a fabricated charge that was presented to the magistrate and a fabricated charge for which there was probable cause that wasn't presented to the magistrate, distinguishing between the first 48 hours after the arrest and the pretrial detention that happens after, between bail and other procedures that might happen during the pretrial procedure. It's just too complicated to get into without briefing.
And as to the two questions that you think we should address, the one that Ms. Anand agrees with, and then you added that, of course, this would have to cause a seizure. But there's no disagreement on that one either, is there?
I take petitioner to be suggesting that it's also possible to bring a Fourth Amendment malicious prosecution claim under the warrant clause based on the issuance of a warrant that's never executed and when no seizure results.
I see. I took her to say something like, we should just leave that to the side. And you think we shouldn't leave that to the side?
I think that the court should say that to bring this particular type of claim, the Manuel Thompson Fourth Amendment malicious prosecution claim, an unreasonable seizure is required. That's in Thompson itself. Of course, there may be a separate claim under the warrant clause that's cognizable under 1983, but that may have a different common law analog. It may be that the common law analog for that isn't malicious prosecution. There's a separate tort that I found preparing for this case called malicious procurement of a warrant. Maybe that's the appropriate analog. That's why we suggest that you limit your focus to the seizure provision.
But you're saying that we should not, just to piggyback on Justice Kagan's last point, that you would have us stop at just saying that for this kind of claim, you have to have caused, the baseless charge has to have caused an unreasonable seizure, but not get into how one would go about proving that.
That's correct. That would be enough to resolve the circuit split.
I took Ms. Anand to be agreeing with all of that, so maybe I'll just put in a request with Ms. Anand to say on rebuttal whether you agree with all of that.
Thank you, Justice Alito. Any further? Okay. Thank you, counsel. Ms. Wold?
Mr. Chief Justice, and may it please the court. When a plaintiff brings a Section 1983 malicious prosecution claim under the Fourth Amendment, the plaintiff must show that the alleged malicious prosecution resulted in the plaintiff's seizure, as this court held in Thompson. The Sixth Circuit correctly concluded that petitioner cannot make that showing because probable cause supported his detention. Petitioner was arrested and detained for 3 days pursuant to a warrant supported by probable cause for 2 first-degree misdemeanor crimes, each carrying a sentence up to 6 months imprisonment. In light of that, the presence of a third charge, allegedly lacking probable cause, could not have resulted in petitioner's detention. This result flows directly from existing Fourth Amendment precedents, including Devenpeck versus Alford and Wren versus United States, which make clear that a seizure does not violate the Fourth Amendment, quote, as long as the circumstances viewed objectively justify that action. Or, as those precedents also state, Fourth Amendment reasonableness allows certain actions to be taken in certain circumstances, whatever the subjective intent an arresting officer is alleged to have had. Moreover, in Baker versus McCollin, the court concluded that a 3-day seizure like petitioner's did not violate the Fourth Amendment because the arrest and detention was pursuant to a warrant supported by probable cause, even though police in that case had actually detained an innocent individual based on a mistaken identification. Applying the correct Fourth Amendment rule here means setting aside the charge that petitioner alleges to have lacked probable cause and assessing whether the remaining charges objectively justify his detention. They clearly do, and so I urge the court to affirm the decision below, and I welcome your questions.
What happened to this radical agreement we heard of?
It was news to me that there was radical agreement. I think what has happened is that petitioner has created this any crime rule that was in fact a rule that the Sixth Circuit had not adopted under this any crime straw man rule, it would mean that the presence of one charge supported by probable cause automatically justifies any detention. I don't think that's what the Sixth Circuit thought. That's not what the relevant Sixth Circuit precedent had held that the panel below was applying. And I would point the court to the decision below at Cert Appendix pages 9A and 10A, where the court articulates in a paragraph the standard that it's applying for malicious prosecution. And it says that the success of the malicious prosecution claim depends on whether probable cause supported his detention. And so we need to know what the petitioner's detention was, and here it was this few days detention pursuant to a warrant supported by probable cause on 2 charges, and that satisfies Fourth Amendment reasonableness, so there can be no Fourth Amendment malicious prosecution.
What do I do with the language of the court that says, moreover, we can affirm the district court's decision if probable cause supports one or more of the 3 charges? That's an every crime exception.
I realize that. I would again point the court to the paragraph that I referenced because that's where they articulate the standard. And if there's anything that might be somewhat unsatisfactory about the lower court opinion, it's that they are joining together the false arrest, false imprisonment, and malicious prosecution analyses. And I think that may cause some shorthand to appear later in the opinion that gives that impression. But I think it's important to note what...
So do you disagree with the Solicitor General that if... I don't know how we get to this proof, but assuming it could be made, that absent the felony charge, no arrest warrant would have issued?
No, I absolutely...
That a summons would have issued. Do you think then that it's an unreasonable seizure to have gotten the warrant?
No, I disagree, and that's not the way Fourth Amendment precedents operate in this area. We look at the detention and we ask whether it is objectively justified. I would point out as well that even on the face of the warrant...
A seizure can be permitted, but the detention unreasonable.
Absolutely, and I think that might arise in circumstances where a particular offense is maybe a fine-only offense, for example, and that's the only charge that can provide probable cause. A more serious charge that accompanied it lacks probable cause. Well, certainly at some point that detention, and certainly beyond 48 hours for an uncharged crime, is always going to be unreasonable under the Fourth Amendment.
Just to get back to the question that Justice Sotomayor asked about that language, I understand that you're saying we shouldn't take that language at face value, but if that language were taken at face value to mean what Justice Sotomayor suggested it meant, which is that any crime gets you out of... you do disagree with that?
You're talking about the language in the Sixth Circuit opinion. If it meant an any crime rule, the way petitioner defines it, that any probable cause automatically insulates any detention, yes, we agree that would be incorrect. We don't think that's what the Sixth Circuit applied. If, however, you look at the Sixth Circuit opinion and you disagree, and you think that is the standard that the Sixth Circuit applied, then we think you should announce the right rule, and we, I think, largely agree with the United States about what that rule is. But we also think you should apply it in this case. There's ample precedent for doing that in Crawford and Employment Division versus Smith, Terry versus United States, Katz versus United States. We think that'd be appropriate to do.
So you would say first we knock off the any crime, then we say that there has to be a showing of causation as to the detention or the seizure. But then you want us to go further than the Solicitor General by saying what the right way to show causation is. Is that right?
Well, certainly not the right way in every case, but I think the way we ask you to then apply the rule you would set out is according to existing Fourth Amendment precedents. And even if you weren't willing to go ahead and apply the rule in this case, we do think the court should make clear that when Manuel and then Thompson in particular recognized a Fourth Amendment malicious prosecution claim, they weren't recognizing a brand new body of Fourth Amendment law that was going to create standards that are different than in other areas. We think the applicability of reasonability should continue to be as it already is in the Fourth Amendment. And to the extent that's dissatisfactory, it would be, as Justice Gorsuch suggests, potentially possible to locate the claim in the 14th Amendment, and there may be efforts to do so. The court has explicitly reserved that possibility.
So how is it that it applies here? So what is your standard for causation?
So we just think it's the application of ordinary Fourth Amendment principles. So you would look at the warrant just as you do under Franks and exclude the information that is alleged to be false. It's alleged to be the malicious prosecution evidence, if you will. And you would look at what remains, and you would ask whether there's probable cause and whether that supports the detention.
But I guess to look at ordinary principles, a lot of those ordinary principles come up in a different context. So it's hard to really say that they should translate and drive the analysis here. I mean, I had a whole colloquy with Ms. Anand about false arrest, probable cause, and what we look at and what we care about being different than the probable cause element, and I understand we're talking about the causation element, but the gravamen of a malicious prosecution claim is not the same as the gravamen of an unlawful arrest claim. And so when you're thinking about unreasonableness from the standpoint of causation, I guess I'm a little worried about treating them the same.
So the Fourth Amendment, as we know, prohibits unreasonable seizures, but not unreasonable charges. And we think that's the difference. And if there's any kind of misfit between these things, I think the court was well aware of that in Thompson, understanding that the common law malicious prosecution.
No, but isn't it in the malicious prosecution context, the malicious and unreasonable charge has caused, as you say, the unlawful seizure. And so when we're looking at causation, it's very hard for me to understand how you can take out of the picture, as you did with your definition, the malicious prosecution. What Ms. Anand is saying is that when you have a malicious initiation of charges, that sort of taints the process, and it's it's almost like you have to presume that almost everything that happened afterwards was tainted by that, unless we have clear evidence that you could have proceeded without the malicious prosecution. And you seem to be saying the opposite in a way.
I think that those same kinds of arguments could have been put forward, I think were put forward in Devenpeck versus Alford about the way we handle this in the context of a false arrest. And the answer was a Fourth Amendment answer about reasonableness, and that Fourth Amendment reasonableness does not depend on the subjective intent of a particular officer. We know that from Wren, from Devenpeck, from numerous other cases. It also doesn't.
That's because that's not a malicious prosecution scenario. I mean, this is the precise point, right? When you take the jurisprudence that relates to the reasonableness of just an unlawful arrest, I totally buy what you're saying. We're not really focusing on the intent of the officer. We're looking at the circumstances and whether or not an objective officer with those circumstances would have arrested you and behaved in that way. But when you're beginning in the world of malicious prosecution, the thing that we care about is the intent and the maliciousness and what the process is doing to you for baseless reasons. And so once we're starting there, it seems to me you can't really judge the causation by those other standards, by standards that say, well, we don't really care what the officer was thinking. We've already crossed that bridge because we're in the world of malicious prosecution.
I think that Thompson answers this question by requiring that there be an unreasonable seizure, because Thompson was locating the claim in the Fourth Amendment, or at least acknowledging it as a type of Fourth Amendment claim that could be brought. And I think the kinds of things you're discussing might be more at home in the 14th Amendment, but it's not been a part of our Fourth Amendment analysis. And I don't think that Thompson was creating a rule by which there'd be a new type of claim and it would have brand new elements and change the meaning of probable cause. I think Thompson was acknowledging that this claim could be brought under the Fourth Amendment, but I don't think there's any reason to deviate from Fourth Amendment principles beyond that.
Ms. Wold, if we do what the SG proposes that we do and say, the any-crime rule is not good, but you do have to show causation and that this caused a seizure in order to make out the Fourth Amendment claim, what happens on remand? What arguments then do you make?
Well, I think on remand we would continue to argue, as I would ask the court to also state, that existing Fourth Amendment principles apply. And so the question is whether his detention is justified by probable cause.
And so this would be the colloquy that you're having with Justice Jackson right now, saying that we look at it objectively and we say, was this 4 days? If you cross out, put your hand over the money laundering charge, would it have been reasonable to hold him for 4 days for these two misdemeanors?
Yes, that's exactly right. So you would ask, based on the probable cause that we know was determined by a neutral and detached magistrate at the issuance of the warrant, the probable cause on those 2 charges clearly justifies the entirety of his detention, and that would resolve the issue.
Does it get tricky? I mean, I'm not sure any of our precedent squarely addresses this point. When do we stop thinking about the Fourth Amendment and start thinking about, say, speedy trial, or is he being held so long that we're violating the Sixth Amendment, or was this fine so high it's actually, an excessive fine problem? Is all this really, is that maybe another reason for caution here? Is all this really a Fourth Amendment issue?
So I think the recognition that pretrial detention could be a Fourth Amendment claim arises in 2017 with Manuel, so some of these questions may be a bit new. I do think in the past the court has resolved some questions about length of detention by asking at some point did that detention become punishment, and then it's punishment without a conviction, and that can fall under other provisions of the Constitution. Maybe it's an unsatisfactory answer. I think there are complicating factors here. I think this case and these facts are not difficult because the detention is so limited and it clearly corresponds to the length of detention the court has found to be reasonable under the Fourth Amendment in other cases, like Baker versus McCollin, where there you had the wrong person. That person was completely innocent and saying so from the moment of arrest onward. But the warrant was valid, the warrant was supported by probable cause, and that justified the detention for a matter of days.
Thank you.
I'd just like to understand better if we were to remand for some sort of causation showing here exactly what your argument would be. Would it be that probable cause existed sufficient on the 2 charges that remained, and that would be enough to justify 4 days? Or would it be that there's probable cause under any laws that we can point to that would suffice to support 4 days?
It would be, first, I obviously don't want to exclude on remand that we might make lots of arguments, but I think the argument I'm positing today is that the 2 charges that were the subject of the warrant, those supply probable cause, not some kind of uncharged conduct, not under any law.
I guess I'm wondering why that would be the case under your logic. If we're going to take try to import Fourth Amendment principles further into this malicious prosecution claim, false arrest, this seems to be where you're kind of driving the train, or wanting to. I may be mistaken there. And there, I'm not sure we would always be limited to the indictment or charge. We would look and see if there's probable cause to support the detention vel non.
Right. I think in this case, it wouldn't be enough to look at uncharged conduct because the seizure lasted more than 48 hours. So there wouldn't be a probable cause determination by a neutral and detached magistrate as to uncharged conduct, and that's why you couldn't do what you could otherwise do in the false arrest context.
We're not looking necessarily at uncharged conduct, but I understand that limitation, but the claims that the government might bring, why would you be limited on that?
Maybe I'm failing to understand the question, but I think when the government is holding someone beyond 48 hours...
No, you've got to come up with a crime. But there's a lot of crimes out there these days, not just those you happen to charge.
That's correct, but this is all after the fact, and so here we know the detention went beyond 48 hours. We are limited to claims that were charged.
Okay. All right, thank you.
So it seems to me that your causation rule eviscerates the kind of plaintiff dynamic that I explored with Ms. Anand, and maybe you can help me understand why that's the case, why that's not the case. So I said, we have a person who is a criminal, and he's committing crimes, and he's got 3 or 4 of them absolutely dead to rights. But one of them, no. One of them, he says, this additional thing, whatever it is, I didn't do it, and because I'm, a career criminal, the police officer knows me from way back when, and he actually tacked that on after he made stuff up, and this charge is a malicious prosecution. It seems to me that if we buy your rule of causation, so first of all, we don't say, any charge, he still gets to go forward just because there are these other charges. He still gets to go forward on that basis. But you're knocking him out basically for the same reason on the causation prong. You're saying because you have these other charges for which you could have been arrested, and perhaps he even agrees to that,
you're not allowed because you can't say that the baseless charge caused. And I guess I don't understand why that's the case. Why shouldn't he still be able to make his claim on the civil docket with respect to the malicious prosecution of that one charge?
I think you've absolutely highlighted a distinction between our positions. I think Williams versus Aguirre, which petitioner embraces, would hold that you could make out a per se constitutional violation for that alleged malicious prosecution. And we think that's incorrect. And we think that's because of the operation of the Fourth Amendment. The correct rule is a Fourth Amendment rule. How could you have a per se constitutional violation for an unreasonable charge, which the Fourth Amendment does not forbid, without an unreasonable seizure? And we think it's the Fourth Amendment that does the work there.
So what if the other crimes are all misdemeanors and he can show, we have this coming up in other cases, that no one would ever have been prosecuted or held or detained for the three other things? Yes, he says, I did those things, but those are not things for which people get detained. It's the one they made up. And that's, in fact, why they made it up, because they wanted me to go to jail. Does he go forward or no under your causation?
We still think it is the overlay of existing Fourth Amendment precedent that asks about that objectively. And that means that if those misdemeanor charges, regardless of local practice, even if it hadn't been local practice to arrest for those, the Fourth Amendment says you can arrest for even a fine-only offense. That's Atwater versus City of Lago Vista. And the Fourth Amendment also allows an arrest even if it would be unlawful under state law. That's Virginia versus Moore. Those don't violate the Fourth Amendment, so you can hold that individual. Now, it would be a different case if the detention is for 18 months, for example, and the only probable cause that supports it are for these very minor misdemeanor offenses.
But it doesn't matter to you at all if there's evidence that he puts forward that no one would ever, that this magistrate, in fact, wouldn't have or didn't, go forward with respect to this authorizing this detention, but for the baseless charge that was put there in order to get him to go to jail.
That's right. We think that is exactly the kind of analysis that the Fourth Amendment forecloses. And I can point to Wren, Virginia versus Moore, that all say the Fourth Amendment reasonableness does not depend on local practice. It doesn't depend on state law. It doesn't vary from place to place and from time to time. And that's just settled Fourth Amendment law.
Counsel, let's say I understand all that, and maybe even I'm slightly sympathetic to it, but what about the 14th Amendment, and what about the common law malicious prosecution claims, which didn't depend upon showing that all of the charges against me were false?
I think the standard could definitely be different under those. I think under state law there is no requirement that you show a seizure, so the analysis would be different. That claim has been abandoned by this stage in the litigation. And yes, under the 14th Amendment, you wouldn't have this requirement to show a seizure. I think the analysis would be different if the court were to recognize it in the future.
Thank you, Counsel. Justice Alito? Justice Sotomayor? Okay. Scores. Thank you, Counsel. Rebuttal?
Thank you, Your Honor. So to answer Justice Kagan's question first, we are totally fine with the United States' position. Answer the question presented. Reiterate what you said in Thompson, that the malicious prosecution must have resulted in a seizure, which, as the United States points out, is perfectly consistent with our preferred 11th Circuit formulation. And don't touch the question of the warrant clause. We read the warrant clause to talk about the values and purposes of the Fourth Amendment only, not to suggest there is necessarily a 1983 claim predicated on it or what constitutional tort applies. As for respondents' position, I'll just note that what they're now describing as a straw man is precisely what they argued for below. Here's a quote from oral argument. So long as probable cause exists to one of multiple criminal charges, that is enough to negate the entire malicious prosecution claim. This court can do a lot of good by just resolving the question presented and saying that the any crime rule, as Justice Gorsuch said, you can always come up with some crime for which there's probable cause. And so the any crime rule allows police officers to entirely insulate their misconduct by just tacking on a charge for which there's probably probable cause for just about anyone. This court can do a lot of good by just saying that that rule is incorrect, that a plaintiff can make out a malicious prosecution claim even if some charges are supported by probable cause, and we'll fight about all the complexities that Your Honors heard about on remand. Thank you.
Thank you, Counsel. The case is submitted. We will hear argument this morning in Case 23-5572, Fisher versus United States. Mr. Green?
Mr. Chief Justice, and and may it please the Court. Congress enacted 1512C in 2002 in the wake of the large-scale destruction of Enron's financial documents. The statute therefore prohibits the impairment of the integrity or availability of information and evidence to be used in a proceeding. In 2002, Congress hedged a little bit and added Section C2 to cover other forms of impairment, the known unknowns, so to speak. It was, after all, the dawn of the information age. Until the January 6th prosecutions, Section 1512C2, the otherwise provision, had never been used to prosecute anything other than evidence tampering. And that was for good reason. This court has said that otherwise, when used in a criminal statute, means to do similar conduct in a different way. The government would have you ignore all that or disregard all that and instead convert C2 from a catch-all provision into a dragnet. One of the things that dragnet would cover is Section C1. Our construction of the statute at least leaves C1 and C2 to do some independent work. The January 6th prosecutions demonstrate that there are a host of felony and misdemeanor crimes that cover the alleged conduct. A Sarbanes-Oxley-based, Enron-driven evidence tampering statute is not one of them. I welcome the court's questions.
Mr. Green, how do we determine what these two provisions have in common? Do we look after the otherwise or before, and why?
You look at before, Justice Thomas, and you look at the kinds of manner in which documents and records are to be impaired, and then you look after to see what the effect is. But I would submit that the effect is the same, right, in order to cause the impairment of the integrity of the evidence that's to be used in a proceeding or to prevent its availability. So we look back and we look forward.
Wouldn't it be just as easy to look at the C2 and then ask what it has in common with C1 and use C2's provisions as the basis for that similarity?
No, because in C2 speaks to the effect of the actions that the otherwise clause covers. So, in other words, we look at C1 and we see that Congress is concerned about documents and records and other objects and things that are done to those to impair the integrity of those. And the effect of that is to obstruct. And so C2 omits that object and verb section.
But you could just as easily say that Congress is really concerned about things that obstruct, influence, or impede official proceedings. And that's C2. So why isn't that the basis for the similarity?
Well, because of the presence of the otherwise provision. So otherwise, as I mentioned, and otherwise this court has said, means to do similar conduct in a different way. So what we've got here is the impairment of evidence being done in a different way.
I'm sorry. I thought was, yes, doing it in a different way. So let me give you an example. There is a sign on the theater. You will be kicked out of the theater if you photograph or record the actors or otherwise disrupt the performance. If you start yelling, I think no one would question that you can be expected to be kicked out under this policy, even though yelling has nothing to do with photograph or recording. The object that the verb is looking at, the verbs are looking at, is the obstruction. It's not the manner in which you obstruct, it's the fact that you've obstructed. Isn't that the structure of this provision?
It is, Your Honor. It's in part the structure of the provision. But what your hypothetical omits is that there is a specific retriculation, I guess it's called, of all of the different sorts of things that might be done to evidence to begin with.
Except that what's fascinating about one, which is not about two, is that one doesn't require you to have actually impeded the proceeding. One requires you to have that intent, but you don't actually have to accomplish the intent. Two requires you to accomplish the intent. And so that's a very different articulation of what the object of 2 is. The object of 2 is the actual disruption of the proceeding.
Well, I would respectfully disagree because...
Well, why? Look at the language. Yeah. Alters, destroys, mutilates, or conceals a record. I do that in my home, and I do it anticipating that it might be needed. All I have to do is have the intent to impair. By that very language, I don't have to have an actual proceeding that I've impaired. On 2, you need an actual proceeding to impair.
Yes, I guess I'm a little confused, Justice Sotomayor, because as I read this, I would think that the government would say that any attempt at 1 is also covered by the statute, and I'm not sure that I would disagree. So I don't think that there has to be an actual impairment.
No, I do think under 1 you don't need an actual impairment. Under 2 you do.
Well,
if you read it, the verb
says
requires you to actually obstruct the proceeding in 2. Nowhere in 1 do you actually have to obstruct.
Well, in 2, you only have to attempt to do the things that are in 2.
No, otherwise obstructs or impedes, or attempts to, yes.
Yes.
Counsel, can I ask you whether, let's imagine that we agree with you. On remand, do you agree that the government could take a shot at proving that your client actually did try to interfere with, or under C1, under C2, obstruct evidence because he was trying to obstruct the arrival of the certificates arriving to the Vice President's desk for counting? So there would be an evidence impairment theory?
I'm quite sure that my friend would take a shot, Your Honor, but I would say no. And the reason why is that this statute prohibits operation on specific evidence in some way, shape, or form. Attempting to stop a vote count or something like that is a very different act than actually changing a document or altering a document or creating a fake new document.
He's obstructing evidence in my hypothetical. I mean, he's not actually altering the vote certificates, which is why I corrected myself and said under C2. I mean, would that be different than someone, say, in a trial or criminal proceeding trying to prevent evidence that was going to be introduced in the proceeding from making it there? So I'm imagining him acting on the certificates, not the act of counting them.
Well, again, I think they could try it, but I don't think that we're talking about trying to impair just anything other than the evidence itself. We're trying to obstruct a proceeding. And there's questions about what proceeding means here, as Your Honor doubtless knows. But what the government would essentially be doing, as you noted, is converting what they've charged in C2 to a C1 type of crime.
No. C2, I mean, maybe I'm misunderstanding your argument, but I thought your argument was that C2 picks up other things, but they just have to be evidence-related. So in the hypothetical I'm giving you, it's evidence-related because it's focused on the certificates, but it's obstruct or impede, say, the certificates arriving to the Vice President's desk insofar as the goal was to shut down the proceeding and therefore interfere with the evidence reaching the Vice President.
That's closer. It's definitely closer. But if you zoom out and look at all of 1512 in order to understand what kinds of impairment we're talking about, we are talking about, or Congress is prohibiting, the kinds of impairments that actually change documents that actually affect their integrity. If it's just impeding or delaying, we'd submit actually that is not part of 1512C. Delays are mentioned in 5 other parts of 1512, but not in C.
Mr. Green, if Justice Barrett is wrong, then what work is C2 doing? I mean, it seems like you've just now re-articulated only the theory of C1. and you're saying that you have to make it into C1 in order to be, to have this statute apply. So can you help me at least understand, under your theory, what additional thing does C2 offer?
Let's look at the verbs of C1, which are alter, destroy, mutilate, and conceal, and let's think about their antonyms. So one, instead of destroy, would be actually to create. So one could use some sophisticated computer program. We've heard an awful lot about AI, and we've heard about the possibility of deep fake photographs. So I think you would violate C2 if you created a photograph that established your alibi in some extremely sophisticated way that would get it admitted into evidence, or make it, or you submit it for evidence would probably be where the crime occurred.
So you're saying there are other things other than particularly altering, destroying, mutilating, or concealing, but it has to be limited to a record?
Not necessarily, because, one other example, if I might, Your Honor, would be not to conceal, but to disclose. So if I disclosed a witness list in a large multi-defendant drug trial, my purpose in doing that, though I haven't altered the document, would be to intimidate the witnesses or prevent their attendance. That, on our submission, would also violate C2.
All right, can I just ask you one other question, just so that I can fully understand your theory? You keep using the term evidence, and that does not appear in the statute. The statute C1 says record, document, or other object. Now, I appreciate that evidence can be such a thing, but you can imagine a world in which those two are different. So where does evidence come in your theory, and why is it there?
Well, the title of the statute refers to tampering with witnesses, victims, and informants. But along with witnesses, victims, and informants comes evidence that they provide, whether in the form of testimony or whether in the form of documents.
No, I understand, but the statute, the provision we're talking about here, does not use the term evidence. And so, and instead, or in addition, it uses the term official proceeding, which is elsewhere defined, not in terms of, court proceedings or investigations. It's just a proceeding, before Congress. So is it your argument that the only thing that this provision covers is something that is tantamount to evidence in an investigation or trial?
It is, Your Honor, and we're not limiting it. Our position does not limit it to documents or records. I would submit C1, which we say carries into C2 through the otherwise clause, when it says other object, is pretty broad. And it need not be as 1512F provides. It need not be admissible. F. It need not be admissible. So it could cover things like electronic records. It could cover communications. It could cover emails. It could cover all kinds of things that we think get used by fact finders in a formally convened hearing.
Just to take you back to...
Just a quick question. What about the Second Circuit's decision in U.S. versus Reich, where what was involved was not evidence, it was a forged court order? Would that fall within C2?
Yes, we think that does fall within C2. And I think anything that is falsified in this operative way that is used to obstruct a proceeding would be covered by C2. Yes.
And just to take you back to the question that Justice Thomas started you with, it seems to me there are two choices here, and you could read this as otherwise obstructs a proceeding or otherwise spoils evidence. And you're using it to say otherwise spoils evidence with, spoils being all those verbs. But it doesn't say that. It says otherwise obstructs a proceeding. There are plenty of ways to write the statute that you want to write. You could just say otherwise affects the integrity or availability of evidence in an official proceeding. You could combine official proceeding with evidence in other ways. One with, you could replicate the mens rea that C1 has. There are ways in which C2, multiple ways in which the drafters of C2 could have made it clear that they intended C2 to also operate only in the sphere of evidence spoliation. But it doesn't do that. All it says is otherwise obstructs, influences, or impedes.
Certainly the statute could be written more precisely. Any statute could be written more precisely.
Well, it's not a question of precisely. The question is, what is this otherwise? This is what Justice Thomas said at the beginning. What is this otherwise taken from C1? Of course there's commonality that's involved in an otherwise. There's both commonality and difference. But what is the commonality that C2 is drawing from C1? It tells you what the commonality is. The commonality is that the things that fall into C2 also have to obstruct, influence, or impede. But what C2 does not say, really does not say, is everything in C2 also has to spoil evidence.
But this court has said that otherwise in a criminal statute means similar conduct.
Similar conduct, obstruction of a proceeding, different ways of carrying out that similar conduct, which is obstruction of a proceeding. The statute tells you what the similar conduct is right on its face.
Respectfully, Justice Kagan, the statute tells you what the effect is. The conduct that's specified in C1 is altering, destroying, mutilating, or concealing a document, a record, or other object. And so a drafter of the statute could easily omit something like that and would omit something like that for the sake of economy and also to hedge, because we know that what comes before might not be exactly the same as after. So we're not going to repeat what we said there, but we're going to use a connector like otherwise to demonstrate that we're talking about similar conduct. And I would submit, Your Honor, that if you look at C2 alone, that is, please.
What's your best case for this, like, going backward and trying to find language that does not appear in the otherwise provision and trying to incorporate it into the otherwise provision?
Well, I think Begay is our best case for sure.
And that's not a very good advertisement, I would think. I mean, what Begay does is exactly that. So you have a very good case there. And it was a complete failure. Begay said, we look back at this thing that Congress did not use in the otherwise provision, and we derive various things from it, and we put it in. It was purposeful, violent, and aggressive. And then a few years later, we said, where did that come from? We made it up, and we get rid of the whole thing. So that's not a great advertisement for rewriting a statute to take an otherwise provision that says what it says and turn it into an otherwise provision that says something else.
We would submit that Begay was abrogated on other grounds, Your Honor. And the other grounds are the members of the court could not decide between an assessment of the types of things that came before otherwise versus the level of risk. And when that began to play out in complicated cases like Chambers and many others involving escape from a halfway house, it became and the court said, an untenable proposition to figure out what a potential harm to another person might be looking at what came before.
Well,
that doesn't.
And I'm sorry, Mr. Green. Go ahead. Finish your sentence.
Yeah, but that doesn't mean that the court's holding about how to construe a statute and its significant holding about otherwise was abrogated in and of itself as a result of the cases that came after Begay.
Well, I'm not a fan of Begay. Some of us perceived at that time that there were different problems with what the court did there. But I think there's a point in the colloquy that you've been having. The specific types of conduct that are enumerated in 1, alter, destroy, mutilate, conceal a record, document, etc., have two things in common. 1, they all involve documents or objects, and they also all involve the impairment of the object's integrity or availability for use in an official proceeding. So the similarity could be either of those things. And so I think that you may be biting off more than you can chew by suggesting, if you are indeed suggesting, that the otherwise clause can only be read the way you read it. one might say it can certainly be read the way the government reads it, and that might even be the more straightforward reading. But it is also possible to read a clause like this more narrowly, and Judge Katz has provided an example of that in his opinion. If you have a statute that says anyone who kills or injures or assaults someone or otherwise causes serious injury, commits a crime, you wouldn't think that that applies to defamation. So it could be read your way. So then I think you have to go on to some other arguments and explain why your reading is better than the government's reading.
Certainly, and I would submit, Your Honor, that there are plenty of other reasons why our reading is the better reason. And I'm not going to contest or bite off more than I can chew and say that the government's reading of C2 is implausible. We think it's unsound, but it's unsound for the additional reasons that if one zooms out and looks at what the prohibited conduct is in 1512 generally, we are talking about interference or operation on forms of evidence and testimony that obstruct a proceeding. That's what 12 is all about generally. And I would submit, Your Honor, too, that as the briefing indicates, Jus Gem Generis and Nocitero Socius, those two venerated Latin canons, also operate in our favor here, as well as the broader context of Chapter 73 and Section 15. All of these things are about doing things that obstruct a proceeding. In 1512 and 1512C zero in on witnesses and evidence.
Well, you have other arguments. You have surplusage arguments. You have arguments about the breadth of the government's reading of the provision. Do you want to say anything about those?
Right. So with respect to surplusage, Your Honor, I would refer to Judge Katz's opinion, as you did, in particular in the Joint Appendix at page 88, which lists out all of the different provisions in Section 1512. 15 of the 21 would be subsumed by the government's reading of C2. The government's reading of C2, I remind the Court, is so broad that it would cover anyone who does something understanding that what they're doing is wrong in some way, that in any way influences, impedes, or obstructs an official proceeding of any type.
Well, Mr. Green, I think that
limited by federal.
There's a good case that this provision, everybody knew it was going to be superfluous because it was a provision that was meant to function as a backstop. It was a later enacted provision. Congress had all these statutes all over the place. It had just gone through Enron. What Enron convinced them of was that there were gaps in these statutes, and they tried to fill the gaps. They tried to fill the particular gap that they found out about in Enron,